Senate will come to order. Mr. Carpenter, please call the roll.
Senators Bridges,
Excused.
Cook, Corum, Court, Crowder, Danielson, Donovan, Finberg, Fields, Foote, Gardner, Janal, Gonzalez, Hill, Heisey, Holbert, Lee, Lundeen,
Absent.
Marble, Moreno, Pedersen, Priola, Rankin, Rodriguez, Scott, Smallwood, Sonnenberg, Story, Tate, Todd, Williams, Winter, Woodward, Zenzinger, Lundeen, Mr. President.
Here. With 34 present, 0 absent, and 1 excused, we have a quorum. Senator Lee, will you please lead us in the Pledge of Allegiance?
Thank you, Mr. President. It's my honor to do so. Please follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Members, please help me welcome President Kevin Grantham to the chambers. Approval of the journal. Senator Heisey. Senator Heisey.
Thank you, Mr. President. I move that the reading of the Journal of Thursday, March 21st, 2019 be dispensed with and that the journal be approved as corrected by the Secretary.
You have heard the motion. Is there any discussion? Senator Hill.
Thank you, Mr. President. I request a moment of personal privilege to explain my upcoming motion.
Granted.
Thank you, Mr. President. Colleagues, very briefly, I think it's important that we continue to have more deliberation about the policies that we push for. I'm asking very specifically for a sit-down with my leadership to discuss oil and gas, to discuss the red flag bill up today, and to discuss the budget upcoming next week. With that, Mr. President, I ask that the Journal of Thursday, March 21st, 2019 be read at length and approved as corrected by the Secretary.
You have heard the request. Mr. Carpenter, please read the journal at length.
Senate Journal, 77th day, March 21st, 2019, page 509. Senate Journal, 72nd General Assembly, State of Colorado, first regular session, 77th Legislative Day, Thursday, March 21st, 2019. Prayer by the chaplain, Dr. Gene Sealander. Crystal Clear Ministries, Denver. Call to order by the President at 9 a.m. Roll call. President 34, excused 1, Scott. Present later 1, Scott. Quorum. The President announced the quorum present. Pledged by Senator Lee. Reading of the journal. Senator Heisey moved the reading of the journal of Wednesday, March 20, 2019 be dispensed with, and that the journal be approved as corrected by the Secretary. On a substitute motion pursuant to Senate Rule 14B and at the request of Senator Hill, the journal of Wednesday, March 20, 2019 was read at length and approved as corrected by the Secretary. Committee of Reference Reports, Education, after consideration of the merits. The committee recommends that Senate Bill 189 be referred to Committee of the Whole with a favorable recommendation, and with the recommendation placed on the consent calendar. Education, after consideration of the merits. The committee recommends that House Bill 1186 be referred to Committee of the Whole with a favorable recommendation, with the recommendation be placed on the consent calendar. Judiciary, after consideration of the merits, the committee recommends that House Bill 1197 be referred to Committee of the Whole with a favorable recommendation. Recommendation be placed on the consent calendar. Judiciary, after consideration of the merits, the committee recommends that Senate Bill 180 be amended as follows. As so amended, be referred to the Committee on Appropriations with favorable recommendation. Judiciary, after consideration of the merits, committee recommends that House Bill 1119 be referred to Committee of the Whole with favorable recommendation. Judiciary, after consideration of the merits, committee recommends that Senate Bill 143 be amended as follows. As so amended, be referred to Committee on Appropriations with favorable recommendation. Amend printed bill, page 2, strike lines 2 through 13, strike pages 3 through 5. Page 510, Senate Journal, 77th day, March 21st, 2019, page 6, strike lines 1 through 3, renumber succeeding sections accordingly. Page 6, line 4, after amend, insert 1, page 6, strike lines 7, and substitute 17, 119.7, prison population management measures. 1, the department shall track the prison bed vacancy rate in both correctional facilities and state-funded private contract prison beds on a monthly basis. If the vacancy rate falls below strike 2, unstrike 3%, for 30 consecutive days, the department shall notify the governor, the Joint Budget Committee, the parole board, each elected district attorney, the chief judge of each judicial district, the state public defender, and the Office of the Community Corrections, the Department of Public Safety. The department shall notify the governor, the Joint Budget Committee, the parole board, each elected district attorney, the chief judge of each judicial district, the state public defender, and the Office of Community Corrections. Once the vacancy rate exceeds strike 3, unstrike 4% for 30 consecutive days. Page 6, line 10, strike may, and substitute strike may, unstrike shall. Page 6, line 21, strike and approved, and substitute a favorable. Page 7, line 4, after inmate insert and a date of release. Page 7, strike line 5. Page 7, line 6, strike release. Page 7, line 8, after review, insert or hearing. Page 8, line 3, after 1622-1029, insert or any other offense, the underlying factual basis of which involves unlawful sexual behavior. Page 8, line 6, after amend, insert 1.5D, 1.5G1. Page 8, strike line 9, and substitute 17-103. Arrest of parolee, revocation proceedings. 1.5D, if a parolee has a technical violation, the parolee's community parole officer, with the approval of the director of the division of adult parole, the director's designee, may impose a brief term of confinement in the county jail not to exceed strike 5, unstrike 14 consecutive days as an intermediate sanction. G, notwithstanding any other provision of this section, a community parole officer may bypass the use of intermediate sanctions or any additional intermediate sanctions in response to a technical violation of parole and file a complaint seeking revocation of parole If one, the parolee has received up to 4 intermediate sanctions committing the parolee to a brief term incarceration in jail, except for a parolee for whom subsection 11B3 of this section applies, or page 9, line 11, after 1622-1029, insert, or any other offense, the underlying factual basis of which involves unlawful sexual behavior, page 9, strike lines 12 through 19, and substitute Article 6.5 of Title 18 or Section 18.6.801. The board may revoke parole and request the sheriff of the county in which the hearing is held to transport the parolee to a place of confinement for a period not to exceed 30 days and order the parolee confined to a facility designated by the executive director, page 10, line 6, strike add 19, and substitute amend 3H1 4F 1C 4F 1D and 5C2 and add 4F 1E and 19. Senate Journal, 77th day, March 21st, 2019, page 511, page 10, strike line 8, and substitute 17.2.201, State Board of Parole Duties definitions 3. The chairperson, in addition to other provisions of law, has the following powers and duties. H.1, to contract with qualified individuals to serve as release hearing officers. 1, to conduct parole applications, hearings for inmates convicted of Class 4, Class 5, or Class 6 felonies, or Level 3 or Level 4 drug felonies, who have been assessed to be less than high risk by the Colorado Risk Assessment Scale developed pursuant to Section 1722.54042A, or hearings pursuant to subsection 19 of this section, pursuant to rules adopted by the Parole Board. And 4, the Board has the following powers and duties. F1, to conduct an initial or subsequent parole release review in lieu of a hearing without the presence of the inmate. If C, the inmate has a statutory discharge date or mandatory release date within 6 months after his or her next ordinarily scheduled parole hearing, and victim notification is not required pursuant to Section 24.4.1302.5, strike or unstrike D, the inmate is assessed to be a low or very low risk on the validated risk assessment instrument developed pursuant to Section 1722.54042. The inmate meets readiness criteria established by the board. And victim notification is not required pursuant to Section 24.4.1302.5, or E, the inmate is subject to subsection 19 of this Section 5C2, except if the offender is subject to subsection 19 of this section. If the offender fails to pay the restitution, he or she may be returned to the board, and upon proof of failure to pay, the board shall, page 10, line 18, after parole, insert board, page 10, line 25, after days, insert is required to be considered by the full board for release, page 11, after line 11, insert Section 5 of Colorado Revised Statute 1722.5402, add 4 as follows. 1722.5402, discharge from custody for a person discharged from correctional facility without supervision is eligible to receive reentry support services from the department or community-based organizations to receive funding from the department to provide reentry services for up to 1 year after the person's date of discharge. Renumber succeeding sections accordingly. State Veterans and Military Affairs, after consideration of the Marriage Committee, recommends that Senate Bill 149 be amended as follows. As amended, be referred to Committee on Appropriations with favorable recommendation. Amend printed bill, page 2, line 1, strike 6, and substitute 1B21, B22, 4F and 6, repeal 4A1, and add 1B24 and 1B25. Page 2, after line 3, insert 1B. The membership of the council must reflect, to the extent possible, representation of urban and rural areas of the state and a balance of expertise, both governmental and non-governmental, in issues relating to human trafficking. The council must include members with expertise in child welfare and human services to address the unique needs of child victims, including those child victims who are involved in the child welfare system. The membership of the council consists of the following persons appointed as follows: 20, strike 2, unstrike 4 persons who are former victims of human. Page 512, Senate Journal, 77th day, March 21st, 2019. Trafficking, strike 1, unstrike 2. Who, strike is a, unstrike are former, strike victim, unstrike victims of human trafficking for involuntary servitude, and strike 1, unstrike 2. Who, strike is a, unstrike are former, strike victim, unstrike victims of human trafficking for sexual servitude, each to be appointed by the governor or his or her designee. 22, one person to be appointed by the Commissioner of Agriculture, strike and unstrike. 24, a representative of a statewide coalition for victims of domestic violence to be appointed by the governor for his or her designee. And 25, one person who is a specialist in issues or research regarding involuntary servitude trafficking to be appointed by the governor or his or her designee for the council shall hold its first meeting on before November 1st, 2014 at a time and place to be designated by the executive director of the Department of Public Safety or by his or her designee. The council shall meet at least 4 times each year and shall carry out the following duties. A, on or before January 1st, 2016, make recommendations to the judiciary committees of the House of Representatives and Senate or any successors committees concerning: 1, strike whether the General Assembly should establish standards and a process for certification of organizations that provide services to victims of human trafficking. Unstrike F, identity best practices for the prevention of all forms of human trafficking. Strike particularly for the prevention of, unstrike including but not limited to child sex trafficking and involuntary servitude trafficking. State Veterans and Military Affairs, after consideration of the Marriage Committee, recommends that House Bill 1185 be postponed indefinitely. State Veterans and Military Affairs, after consideration of the Marriage Committee, recommends that Senate Bill 104 be amended as follows. As so amended, be referred to Committee on Appropriations with favorable recommendation. Amend printed bill, strike everything below the enacting clause and substitute Section 1 in Colorado Revised Statutes, add Article 99 to Title 22 as follows. Article 99 eliminates duplicate regulations. 2299-101, elimination of duplicate regulations, commission creation, definition 1. There is created in the Department of Education in the elimination of duplicate regulations commission referred to in this Article 99 as the commission. 2, the commission consists of A, the Commissioner of Education or his or her designee, B, the Executive Director of the Department of Human Services or his or her designee, C, the Executive Director of the Department of Public Health and Environment or his or her designee, and D, at least 3 practitioners appointed by the Commissioner of Education whose programs are in good licensing standing with the Department of Human Services and are operated by or on behalf of a school district, district charter school, or institute charter school. 3, for purposes of this Article 99, unless the context otherwise requires, program means a school-age child care program that holds a license pursuant to Part 1 of Article 6 of Title 26, including a before and after school program, day camp, summer camp, extended day program, or playground program, and operates on the property of a school district. Senate Journal 77th day, March 21st, 2019, page 513, Charter School or Institute Charter School 2299-102, Duties 1. The Commission shall A, analyze and identify duplicate regulations promulgated by the Department of Education, the Department of Human Services, and the Department of Public Health and Environment relating to health and safety requirements for programs, including without limitation the active oversight and monitoring of such programs, and B, identify with regulations described in subsection 1A of this section may be eliminated, revised, or delegated to the Department of Education, the Department of Human Services, or the Department of Public Health and Environment to eliminate duplicate regulations and ensure the efficient regulation of health and safety requirements for programs. 2, in performing the duties in subsection 1 of this section, the Commission shall consider and prioritize oral and written public testimony. B, consider and prioritize updating regulations consistent with evidence-based research regarding the health and safety of children. C, consider and prioritize updating regulations to align with requirements of federal funding eligibility. 2, on or before June 30th, 2020, the Department of Education, the Department of Human Services, and the Department of Public Health and Environment shall commence respective rulemaking proceedings consistent with the outcomes of the Commission 2299-103 repeal of this article. This Article 99 is repealed effective July 1st, 2021, Section 2. Act subject to petition. Effective date. This act takes effect at 12:01 a.m. on the day following the expiration of a 9-day period after final adjournment of the General Assembly, August 2nd, 2019. If adjournment seen AD is on May 3rd, 2019, except that if a referendum petition is filed pursuant to Section 1.3 of Article 5 of the State Constitution against this act or an item, section, or part of this act within such period, the act, item, section, or part will not take effect unless approved by the people. The general election will be held in November 2020, and in such case will take effect on the date of the official declaration of the vote thereon by the governor. State Veterans and Military Affairs Office Service and Mayor's Committee recommends that Senate Bill 174 be referred to committee to hold the favorable recommendation placed on the consent calendar. State Veterans and Military Affairs Office Service and Mayor's Committee recommends that Senate Bill 194 be referred to committee to hold the favorable recommendation placed on the consent calendar. Health and Human Services. After consideration, the Mayor's Committee recommends that House Bill 1131 be amended as follows. As so amended, be referred to committee to hold the favorable recommendation. Amend re-engross bill, page 2, strike lines 16, 17, substitute. Also provide notice of the existence of any generic prescription drugs or biosimilars from the same, page 3, line 1, after activity insert undertaken with the intent to sell a prescription drug, page 3, strike lines 24 and 25, and substitute. Also provide notice of. Page 514, Senate Journal 77th day, March 21st, 2019, the existence of any generic prescription drugs or biosimilars from the same, page 4, line 5, after activity insert undertaken with the intent to sell a prescription drug. Health and Human Services Office and Mayor's Committee recommends Senate Bill 153 amendment as follows. As submitted before the Committee on Finance with favorable recommendation. Amend printable bill, page 6, strike line 20, and substitute Section 7 of Colorado Revised Statutes, add 1232-120 as follows. 1232-120, bone marrow aspirations from the tibia. 1, the board may permit a podiatrist to perform bone marrow aspirations from the tibia distal to the tibia turbosal if the podiatrist A has successfully completed a podiatric surgery residency with a reconstruction rear foot ankle surgery certification, and B is in good standing with the board. Section 8 in Colorado Revised Statutes, add to Article 290 as relocated by House Bill 191172, 12290-123 as follows. 12290-123, bone marrow aspirations from the tibia. The board may permit a podiatrist to perform bone marrow aspirations from the tibia distal to the tibia turbosal if the podiatrist has successfully completed a podiatric surgery residency with a reconstruction rear foot ankle surgery certification, and B is in good standing with the board. Section 9 in Colorado Revised Statutes 123108, repeal is relocated by the House Bill 191172-4A1F as follows. 123108, confidential agreement to limit practice violation grounds for discipline. 4A, this section does not apply to 1, the following healthcare professionals. F, strike podiatrists regulated pursuant to Article 290 of this Article 12, unstrike. Section 10 in Colorado Revised Statutes 12290-105, amendment is relocated by House Bill 191172-4 as follows. 12290-105, appointment of members of podiatry board, terms repeal of Article 4. This Article 290 is repealed effective strike July 1st, 2019, on strike September 1st, 2026. Before the repeal, the functions of the board are scheduled for review in accordance with Section 2434-104, Section 11 of Colorado Revised Statutes 12-290-107 amendments relocated by House Bill 19-1172-1C and add 1C.5 as follows. 12-290-107 examinations as to qualifications rules. 1. Every person desiring to practice podiatry in the state shall be examined as to the person's qualifications except as otherwise provided in this Article 290. Each applicant shall submit in a manner approved by the board an application containing satisfactory proof that the applicant C has completed 1 year of residency program approved by the board as established by rules promulgated by the board. Strike and unstrike C.5 has passed an examination approved by the board as established by the rules promulgated by the board, and Section 12 in Colorado Revised Statutes 12-290-108 amended is relocated by House Bill 19-1172-3J as follows. 12-290-108 issuance, revocation, or suspension of license, probation, unprofessional conduct definitions, immunity, and professional review. 3. Unprofessional conduct as used in this Article 290 means J. Strike the physical or mental disability as surrender the license and able to perform podiatry with reasonable skill and with safety to the patient. Unstrike failing. 2. 1. Notify the board of physical illness. Physical Senate Journal, 77th day, March 21st, 2019, page 515. Condition or behavioral or mental health disorder that affects the podiatrist's ability to practice podiatric medicine with reasonable skill and safety to patients to act within limitations created by a physical illness, physical condition, or behavioral or mental health disorder that renders the podiatrist unable to practice podiatric medicine with reasonable skill and safety to patients. Or 3. Comply with the limitations agreed to under a confidential agreement entered pursuant to Section 12-290-123, Section 13 of Colorado Revised Statutes 12-290-113, amended as relocated by House Bill 19-1172-2C3 as follows. 12-290-113, disciplinary action by the board. 2C, on completion of an investigation, the board shall make a finding that 3, the complaint or investigation discloses an instance of misconduct that, in the opinion of the board, does not warrant formal action by the board, but that should not be dismissed as being without merit, in which case the board may strike, send, unstrike, issue a letter of admonition, strike by certified mail, unstrike to the licensee in accordance with Section 12-2404-4, Section 14 of Colorado Revised Statutes, add to Article 290 as relocated by House Bill 19-1172, 12-290-123 as follows. 12-290-123, confidential agreements to limit practice violation grounds for discipline. 1, except as specified in subsection 2 of this section, Section 12-3108, concerning confidential agreements. To limit practice applies to this Article 292. This section and Section 12-3108 do not apply to a licensee subject to discipline under Section 12-290-1083C, Section 15, effective date. This act takes effect July 1st, 2019, except that Sections 8 through 14 of this act take effect only if House Bill 19-1172 becomes law, in which case Sections 8 through 14 take effect October 1st, 2019, renumber succeeding sections accordingly. After consideration, the Mayor's Committee recommends that House Bill 1086 be referred to Committee of the Whole with favorable recommendation. Business, Labor, and Technology. Business, Labor, and Technology. The Committee on Business, Labor, and Technology has had on consideration having on the following appointments or government appointments in place in the consent calendar firm. Members of the board, mortgage loan originators for terms expiring August 10, 2022. Charles Patterson Buzz Moore of Grand Junction, Colorado, licensed mortgage loan originator, reappointed. Fred Joseph of Denver, Colorado, member of the public at large, reappointed. Business, Labor, Technology. After consideration, Mayor's Committee recommends that Senate Bill 156 be amended as follows. As submitted, be referred to Committee on Finance with favorable recommendation. Amend printed bill, page 3, line 16, strike portion and 1.2, and substitute portion 1.2 and 1.3, page 3, after line 25, insert 1.3, electric, light, heat, and power means the standard types of electricity that are supplied by an electric utility, regardless of weather. Page 516, Senate Journal, 77th day, March 21st, 2019. The source is an electric utility or the inverter output circuit of a photovoltaic system or a similar circuit from another type of renewable energy system or electric vehicle charging infrastructure and used and consumed in real estate improvement or real estate fixture. Page 10, line 1. After 12-115-103, insert amend as relocated by House Bill 19-1172-3, and page 10, after line 8, insert 3. Electric, light, heat, and power means the standard types of electricity that are supplied by an electric utility, regardless of whether the source is an electric utility or the inverter output circuit of a photovoltaic system or similar circuit from another type of renewable energy system or electric vehicle charging infrastructure and used and consumed in real estate improvement or real estate fixture. Senate Services Report correctly printed. Senate Bill 203 and 204, Senate Resolution 5 and 6 correctly re-engrossed. Senate Bill 178 and 183 correctly revised. House Bill 1028, 1035, 1052, 1078, 1153, 1191, 1200, and 1201 correctly enrolled. Senate Bill 79 and 100. On motion of Majority Leader Fenberg, and with the majority of those elected to the Senate having voted in the affirmative, the Senate proceeded out of order for moments of personal privilege. Senate in recess. Senate reconvened. Upon request of Senator Hill, House Bill 1173, 1209, and 1166 were removed from the general order. Second reading of bills, consent calendar of Thursday, March 21st, 2019, and replaced at the end of the general order. Second reading of bills calendar of Thursday, March 21st, 2019. On motion of Senator Danielson, the Senate resolved itself in the Committee of the Whole For consideration of general orders, second reading of bills, and Senator Danielson was called to act as chair committee of the whole. General orders, second reading of bills. The committee of the whole, having risen, the chair reported that the following bills had been considered and action taken thereon as follows. House Bill 1106 by Representatives Titone, Gonzalez, Gutierrez, Benavides, Buckner, Coleman, Duran, Galindo, Harrod, Jackson, Jaquez, Lewis, Kennedy, Lontine, McLaughlin, Singer, Sirota, Valdez, A. Weissman, also Senators Pedersen, concerning the rental application process for prospective tenants. Amendment number 1, Local Government Committee Amendment, printed in Senate Journal March 15, page 477, and placed in members' bill files. Amendment number 2, L034 by Senator Pedersen. Amend the Local Government Committee report dated March 14th, 2019, page 1, strike line 11, and substitute page 6, line 17, strike make a good faith effort to. Senate Journal, 77th day, March 21st, 2019, page 517, amendment number 3, L035 by Senator Pedersen, amend Rand Gross Bill, page 6, line 11, strike penalties and substitute liability, page 6, after line 22, insert 4. A person who purposefully and in bad faith brings a meritless claim against the landlord under this Part 9 is liable for the landlord's court costs and reasonable attorney fees in defending the claim. At the request of Senator Hill, the bill was read at length. As amended, ordered, revised, and placed on the calendar for their reading and final passage. House Bill 1170 by Representatives Jackson and Weissman, also Senators Williams, A. and Bridges, concerning increasing tenant protections relating to the residential warranty of habitability. Laid over until Friday, March 22nd, retaining its place on calendars. Senate Bill 2 by Senators Winter and Fenberg, also Representatives Jackson, concerning the regulation of student education loan services. Amendment number 1, Education Committee Amendment, printed in Senate Journal February 8th, pages 191 through 203, and placed in members' bill files. Amendment number 2, Finance Committee Amendment, printed in Senate Journal February 27th, page 338, and placed in members' bill files. Amendment number 3, Appropriations Committee Amendment, printed in Senate Journal March 19, page 487, and placed in members' bill files. Amendment number 4, L004 by Senator Winter. Amend the Education Committee report dated February 7, 2019, page 13, line 38. After the period, add if a student loan servicer is not also the loan holder or is not acting on behalf of the loan holder, the student loan servicer satisfies the requirement established by this subsection 5A by providing the new student loan servicer with information necessary for the new student loan servicer to honor all benefits originally represented as available to student loan borrower during the repayment of the student education loan and preserve the availability of the benefits, including any benefits for which the student loan borrower has not yet qualified. Page 14, line 10, strike complete and substitute notify affected student loan borrowers of page 14, line 12. After the period, add the notice must include 1, the identity of the new student loan servicer, 2, the effective date of the transfer of the student loan borrower's student education loan to the new student loan servicer, 3, the date on which the existing student loan servicer will no longer accept payments, and 4, the contact information for the new student loan servicer. At the request of Senator Hill, the bill was read at length. As amended, ordered, engrossed, and placed on the calendar for their reading and final passage. For further action, see amendments to the report of the Committee of the Whole. Page 518, Senate Journal 77th day, March 21st, 2019, House Bill 1007 by Representative Sirota, also Senator Zenzinger, concerning the establishment of contribution limits under the Fair Campaign Practices Act for candidates for county offices in connection with making an appropriation at the request of Senator Hill. The bill was read at length. Order revised and placed on calendar for their reading and final passage. Majority Leader Fenberg moved the Committee of the Whole rise, report progress, and beg leave to sit again. A majority of those elected in the Senate having voted in the affirmative, the motion was adopted. Committee of the Whole in recess. Senate in recess. Senate reconvened. Call of the Senate. Call raised. Committee of Reference reports continued. Agriculture and Natural Resources. The Committee on Agriculture and Natural Resources had in consideration had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar. Confirmed members of the Water Quality Control Commission for terms expiring February 15, 2021. Troy Glenn Waters of Fruita, Colorado, appointed. Joan Card of Boulder, Colorado, appointed. Richard Clark Hum of Nathrop, Colorado, reappointed. Agriculture and Natural Resources. The Committee on Agriculture and Natural Resources had in consideration having the following appointments recommends the appointments be placed on the consent calendar. Confirmed members of the Solid and Hazardous Waste Commission for term expiring August 1st, 2020. Charles R. Adams of Lakewood, Colorado, to serve as a representative from the regulated community as an unaffiliated, reappointed for terms expiring August 1st, 2021. Christopher Stephen Gilbreth of Westminster, Colorado, to serve as a representative from the regulated community as a Republican, appointed. Laura Jean Davis of Westminster, Colorado, to serve as a representative of the Government of Academic Community and as a Republican, appointed. Catherine Stewart of Denver, Colorado, to serve as a member of the public and as Democrat, appointed. Senate Journal, 77th day, March 21st, 2019, page 519. The Committee on Agriculture and Natural Resources has had on consideration and had a hearing on the following appointments and recommends appointments placed on the consent calendar. Confirmed. Members of the Groundwater Commission for term expiring May 1st, 2019. Glenn S. Freehoff of Williams, Colorado, to serve as a resident of agriculture from North Kiowa Bijou Basin, and occasioned by the removal of Daniel L. Farmer of Colorado Springs, Colorado, appointed. For a term expiring May 1st, 2022, Miguel Angel Diaz of Monte Vista, Colorado, to serve as representative from Water Division 3 as an agriculturist appointed. Agriculture and Natural Resources. The Committee on Agriculture and Natural Resources had in consideration had a hearing on the following appointments and recommends the appointment be placed on the consent calendar of confirmed members of the State Board of Stock Inspection Commissioners. For a term expiring May 1st, 2022, Eric Morlang, Fort Morgan, Colorado, is representing the confinement cattle industry appointed. Agriculture and Natural Resources. The Committee on Agriculture and Natural Resources has had in consideration and had a hearing on the following appointment and recommends the appointment be placed on the consent calendar of confirmed member of the Colorado Agriculture Development Authority Board of Directors for term expiring June 30th, 2021, Hannah Donnell Wilkes of Arvada, Colorado, Democrat, serve as a member of the knowledge of agriculture activity in the state and who shall represent the various agriculture operations in geographical regions of the state. Reappointed. Agriculture and Natural Resources after consideration of merits. Committee recommends that Senate Bill 150 be amended as follows as submitted to be referred to Committee on Finance with favorable recommendation. Amend printed bill page 4 after line 26. Insert Section 7 of Colorado Revised Statutes 3555 113. Amend 1, 2A, 3, and 5 as follows. 3555 113 Veterinary Inspection Rules 1A. An accredited and licensed veterinarian shall inspect all livestock consigned and delivered on the premises of any licensed public livestock market before strike. Being unstriked, the livestock are offered for sale. Strike shall be inspected by an authorized veterinarian of the Department of Agriculture. Unstrike, the veterinarian shall strike, examine, unstrike, inspect, or test as indicated or required animals consigned to the public livestock market for the purpose of determining their condition of health and freedom from infectious or contagious animal diseases. If in the opinion of the strike examining, unstrike, inspecting veterinarian, strike said unstrike, the animals are free of strike symptoms, unstrike, clinical signs of infectious or contagious diseases, and have not, to the best of strike, his unstrike, the veterinarian's knowledge, been exposed to any infectious or Page 520, Senate Journal, 77th day, March 21st, 2019. Contagious diseases, strike he, unstrike. The veterinarian shall issue a strike health, unstrike, signed certificate, strike signed by him, unstrike, of veterinary inspection to any purchaser who so requests. Strike said health, unstrike. The veterinarian shall deliver the certificate. Strike shall be delivered, unstrike, of veterinary inspection to the purchaser at the time of rendering the account of sale or bill of sale. B, in addition to the requirements of this subsection 1, for all interstate movements, livestock must meet federal, interstate, and state of destination requirements. The veterinarian and the public livestock market shall immediately isolate and hold all animals strike found to be unstrike affected with any recognized infectious or contagious diseases. Strike shall be immediately isolated, quarantined, and held unstrike in conformity with the health requirements of the Colorado law and the rules, strike, and regulations unstrike of the Department of Agriculture. Strike all fees or taxes for veterinary services prior to the sale of livestock shall be paid by unstrike, the operator for the public livestock market. Strike all livestock intended for interstate shipment on which unstrike shall pay all fees or taxes or veterinary services. The buyer, the person who intends to ship through interstate commerce, shall pay the expenses for inspections or tests that are required by the United States Department of Agriculture. Strike requires specific inspections or tests, unstrike, and that can only be made by an approved and licensed veterinarian. Strike shall be made at the expense of the buyer or the party who intends to move them interstate. Unstrike to a swine may be moved from a public livestock market if upon inspection the swine are found free from strike symptoms, unstrike, clinical signs of strike, cholera, or other unstrike, contagious, infectious, or communicable diseases, and in a strike thriving unstrike condition of health. 3, feeding swine and breeding swine, strike, going unstrike, that are being moved from a market to a farm. Strike shall, unstrike, must be identified by an approved ear tag, individual tattoo, or ear notch, as each is required by 9 CFR 71.19. Sows and boars, strike, going unstrike, that are being sent to slaughter. Strike shall, unstrike, must be identified in accordance with the market swine identification program prescribed in the swine brucellosis control eradication state, federal, industry uniform methods and rules. Strike for brucellosis eradication, unstrike, published by the USDA Animal Plant Health Inspection Service Agency. Strike in effect July 1st, 1981, as amended from time to time thereafter. Unstrike APHIS 9155042. 5, if in the judgment of and strike, authorized unstrike, accredited and licensed veterinarian strike of the department, unstrike, an animal presented at the public livestock market is injured, disabled, or diseased beyond recovery, the veterinarian shall humanely euthanize the animal or direct the consignor to immediately remove the animal from the premises of the public livestock market. The consignor is responsible for all expenses incurred for euthanasia and disposal of an animal under strike. The provisions of unstrike this subsection 5 strike are the responsibility of the consignor. Unstrike, the consignee is not responsible for collection of expenses. Strike shall not be the responsibility of the consignee on strike. Renumber succeeding sections accordingly. Agriculture and Natural Resources, after consideration of the Mayor's Committee, recommends that House Bill 1026 be referred to Committee on Finance with favorable recommendation. Agriculture and Natural Resources, after consideration of the Mayor's Committee, recommends that Senate Bill 184 be postponed indefinitely. Finance, after consideration of the Mayor's Committee, recommends that House Bill 1010 be referred to Committee on Appropriations with favorable recommendation. Finance, after consideration of the Mayor's Committee, recommends that Senate Bill 145 be referred to Committee on Appropriations with favorable recommendation. Senate Journal, 77th day, March 21st, 2019, page 521, Introduction of Bills, first reading. The following bills were read by title and referred to committees indicated. Senate Bill 205 by Senators Danielson and Zinzinger, also Representatives Michelson, Janae, and Duran, concerning the creation of a license plate to honor women veterans of the United States Armed Forces, Transportation, and Energy. Senate Bill 206 by Senators Perula and Tate, concerning the continuation of the Standing Efficiency Accountability Committee in connection therewith, implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies, Business, Labor, and Technology. House Bill 1024 by Representatives McKean and Monteo and Senators Todd and Corm, concerning creation of the Colorado Youth Advisory Council Review Committee in connection therewith, making appropriations to state veterans and military affairs. House Bill 1192 by Representatives Gonzalez, Gutierrez, and Monteo, Benavides, Buckner, Carveo, Coleman, Duran, Galindo, Herod, Jackson, Jaquez, Lewis, Kennedy, Lonte, Melton, Mullica, Singer, Sirota, Tatone, Valdez A, Valdez D, Weissman. Also Senators Gonzalez, Garcia, Moreno, Rodriguez, concerning the inclusion of matters relating to American minorities in the teaching of social contributions in civil government and public schools, and in connection therewith establishing the History, Culture, Social Contributions, and Civil Government and Education Commission to make recommendations including the history, culture, and social contributions of American Indians, Latinos, African Americans, and Asian Americans, lesbian, gay, bisexual, and transgender individuals within these minority groups, the contributions and persecution of religious minorities, and the intersectionality of significant social and cultural features within these communities, and the teaching and content standards for history and civics, and making appropriation education. House Bill 1206 by Representative Coleman and Larson. Also Senators Bridges and Lundin, concerning removing equity gaps in higher education by ensuring more students have access to supplemental academic instruction. Education Committee of the Whole. A motion of Senator Danielson, the Senate re-resolved itself into the Committee of the Whole for consideration of general orders. Second reading of bills. Senator Danielson was called to act as chair. Committee of the Whole reconvened. General orders. Second reading of bills continued. The Committee of the Whole, having risen, the chair reported the following bills, reading at length, having been dispensed with by unanimous consent, have been considered and action taken thereon as follows. Senate Bill 10 by Senator Fields, also Representatives McLaughlin, Valdez D, concerning professional behavioral health services for schools. Amendment number 1, Health and Human Services Committee Amendment, printed in Senate Journal, January 18th, pages 73 through 74, and placed in members' bill files. Amendment number 2, Appropriations Committee Amendment, printed in Senate Journal, March 19th, pages 487 through 48, and placed in members' bill files. Amendment number 3, L005 by Senator Fields, amendment printed bill, page 4, line 11, after 3F, insert and 7. Page 522, Senate Journal, 17th day, March 21st, 2019, page 6, after line 4, insert 7, grant applications and reporting will be designed to limit administrative burden on applicants and recipients, as amended order and gross place accounted for third reading and final passage. Senate Bill 3 by Senators Zenzinger and Quorum, also Representatives McLaughlin and Wilson Rankin, concerning the Educator Loan Forgiveness Program to address educator shortages. Amendment number 1, Education Committee Amendment, printed in Senate Journal, January 25th, page 109, and placed in members' bill files. Amendment number 2, Appropriations Committee Amendment, printed in Senate Journal, March 19, page 488, 489, placed in members' bill files as amended. Order and gross place encounter for their reading and final passage. For further action, see amendments to the report of the Committee of the Whole. House Bill 1129 by Representatives Michelson, Janae, and Escar, Duran, Herod, Valdez A, Galindo, Jaquez, Lewis, Tatone. Also Senators Finberg, Moreno, Janal, concerning prohibiting a mental health care provider from engaging in conversion therapy with a patient under 18 years of age. Amendment number 1, L006 by Senator Finberg, amendment and gross bill, page 4, strike lines 12 through 19, renumber succeeding sections accordingly, page 7, line 6, strike 6, 7, and 8, and 9, and substitute 5, 6, 7, and 8, page 7, line 7, strike 6, 7, 8, and 9, and substitute 5, 6, 7, and 8. As amended, order revised place accounted for the reading and final passage. House Bill 1173 by Representatives Garnett and Neville Becker, also Senators Finberg and Holbrook, concerning the authority of an ex officio member of the Legislative Council to appoint a temporary replacement for that ex officio member at a meeting of the Legislative Council. Order revised place accounted for the reading and final passage. House Bill 1209 by Representatives Froelich and Valdez A, also Senator Bridges, concerning repealing aeronautical reporting requirements. Order revised place accounted for the reading and final passage. House Bill 1166 by Representatives Singer and Larson, also Senators Zenzinger, concerning name-based criminal history record checks in connection with requiring certain persons and entities to submit to a name-based criminal history record check as a condition of employment, resignation, licensure, or certification. Amendment number 1, Judiciary Committee Amendment, printed in Senate Journal, March 19, page 496, and placed in members' bill files. As amended, order revised place accounted for their reading and final passage. Senate Journal 77th day, March 21st, 2019, page 523, House Bill 1177 by Representatives Sullivan and Garnett, also Senators Cord and Pedersen, concerning creation of extreme risk protection order in connection with making an appropriation laid over until Friday, March 22nd, retaining its place on the calendar. Senate Bill 5 by Senators Rodriguez and Janal, also Representatives Hawkins Lewis, concerning wholesale importation of prescription pharmaceutical products from Canada for resale to Colorado residents, laid over until Friday, March 22nd, retaining its place on the calendar. Amendments to the report of the Committee of the Whole. Senate Bill 2 by Senators Winter and Finberg, concerning the regulation of student education loan servicers. Senator Gardner moved to amend the report of the Committee of the Whole to show the following: Winter Floor Amendment L004 to Senate Bill 2 did pass. Amend the Education Committee report dated February 7, 2019, page 13, line 38, after the period add: if a student loan servicer is not also the loan holder or is not acting on behalf of the loan holder, the student loan servicer satisfies the requirement established by the subsection 5A by providing the new student loan servicer with information necessary for the new student loan servicer to honor all benefits originally represented as available to the student loan borrower during the repayment of the student loan education program, reserving the availability of the benefits, including any benefit for which the student loan borrower has not yet qualified. Page 14, line 10, strike complete and substitute notify affected student loan borrowers of. Page 14, line 12, after the period add: the notice must include 1, the identity of the new student loan servicer; 2, the effective date of the transfer of the student loan borrower's student education loan to the new student loan servicer; 3, the date on which the existing student loan servicer will no longer accept payments; and 4, the contact information for the new student loan servicer. Majority of all members elected this and having voted in the affirmative, the amendment to the report of the Committee of the Whole is passed on the following roll call vote: yes 27, no 8, excused 0, absent 0. Bridges, yes. Cook, yes. Corum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, no. Janal, yes. Gonzalez, yes. Hill, no. Heisey, yes. Holbert, yes. Lee, yes. Lundy, no. Marble, no. Moreno, yes. Pedersen, yes. Priola, no. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, no. Sonnenberg, yes. Story, yes. Tate, no. Todd, yes. Williams, yes. Winter, yes. Woodward, no. Zenzinger, yes. President, yes. Page 524, Senate Journal, 77th day, March 21st, 2019. Senate Bill 3 by Senators Zenzinger and Quorum, also Representatives McLaughlin and Wilson Rankin, concerning the Educator Loan Forgiveness Program to address educator shortages. Senator Lundy moved to amend the report of Committee of the Whole to show the following: Lundy Floor Amendment L006. The Senate Bill 3 did pass. Amendment Printed Bill, page 8, line 25, strike position and substitute position. Page 8, line 27, strike before for insert or for an educator rated as highly effective up to $7,000. Less than a majority of all members elected to the Senate having voted in the affirmative, the amendment to the report of the Committee of the Whole was lost in the following roll call vote: yes 15, no 19, excused 1, absent 0. Bridges, excused. Cook, yes. Corum, no. Court, no. Crowder, yes. Danielson, no. Donovan, no. Finberg, no. Fields, no. Foote, no. Gardner, yes. Janal, no. Gonzalez, no. Hill, yes. Heisey, yes. Holbert, yes. Lee, no. Lundin, yes. Marble, yes. Moreno, no. Pedersen, no. Priola, no. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, no. Tate, yes. Todd, no. Williams, no. Winter, no. Woodward, yes. Zenzinger, no. President, no. Adoption of the report of the Committee of the Whole. Motion of Senator Danielson, the report of the Committee of the Whole is adopted on the following roll call vote: yes 34, no 0, excused 1, absent 0. Bridges, excused. Cook, yes. Corum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. The Committee of the Whole took the following action: passed on second reading. Senate Bill 2 as amended, Senate Bill 10 as amended, Senate Bill 3 as amended, House Bill 1106 as amended, House Bill 1007, House Bill 1129 as amended, House Bill 1173, House Bill 1209, House Bill 1166 is amended later until Friday, March 22nd. House Bill 1170, House Bill 1177, Senate Bill 5. A motion majority with Finberg and with majority of those elected in the Senate having voted in the affirmative. Consideration of resolutions calendar. Senate Resolution 5 of Thursday, March 21st, 2019 was later until Friday, March 22nd, 2019, retaining its place on the calendar. Senate Journal, 77th day, March 21st, 2019. Page 525, consideration of House amendments to Senate bills. Senate Bill 106 by Senators Cook and Zenzinger, also Representative Tipper and Larson, concerning an additional process by which a Board of County Commissioners may initiate the withdrawal of current employees who are peace officers from a defined contribution retirement plan offered by one or more local governments. Senator Cook moved the Senate not concur in House amendments Senate Bill 106 as printed in House Journal March 14, page 669. That a conference committee be appointed. A majority of all members elected to the Senate having voted in the affirmative, the motion was adopted on the following roll call vote: yes 34, no 0, excused 1, Absent 0. Bridges, excused. Cook, yes. Quorum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zinzinger, yes. President, yes. Consideration of governor's appointments, consent calendar. Motion of Majority Leader Finberg. The following governor's appointments was confirmed by the following roll call vote. Members of the Emergency Impact Assistance Advisory Committee for term expiring August 24th, 2021. Roy H. Out of Greeley, Colorado. And Kismet, the resignation for Kelly Eugene Arnold of Windsor, Colorado. Appointed, yes. 34, no, 0. Excused, 1. Absent, 0. Bridges, excused. Cook, yes. Gorham, yes. Cord, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundin, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, yes. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. Appointments to Conference Committee. Senators Donovan, Chair. Janal and Crowder were appointed to Senate Conferees on First Conference Committee on House Bill 1029. Page 526, Senate Journal, 77th day, March 21st, 2019. Committee on Reference Reports continued. Local government, African Service and Mayor's Committee recommends that Senate Bill 192 be amended as follows. As submitted before Committee on Finance with favorable recommendation. Amended printed bill, page 9, after line 18, insert F. The term of office of board members is 3 years, except that the initial terms of members appointed pursuant to subsection 3D3 of this section are 2 years. Page 11, line 22, after C, insert 1. Page 12, line 5, strike 1 and substitute A. Page 12, line 10, strike 2 and substitute B. Page 12, line 13, strike 3 and substitute C. Page 12, after line 14, insert 2. The policies and procedures specified by the board must include the following limitations for grant applicants that are either a waste hauler or a landfill owner or operator, which the board shall apply only to the portions of an application that relate to infrastructure or equipment. A, only 50% of infrastructure or equipment can be funded through the grant program. B, if the board awards a grant to a waste hauler or landfill owner or operator for infrastructure or equipment, the grantee is ineligible to receive a grant for the following 5 years. Page 12, after line 22, insert 2, not allocate more than 20% of the annual fund balance in any single grant award. Read number succeeding subparagraphs accordingly. Local government, African Service and Mayor's Committee recommends that Senate Bill 157 be referred to Committee on Finance with a favorable recommendation. Health and Human Services, African Service and Mayor's Committee recommends that Senate Bill 195 be amended as follows. As submitted before Committee on Appropriations with a favorable recommendation. Amendment printed bill, page 8, line 3, strike Title 12 and substitute Title 12 or professional person as defined in Section 2765, 102, 17, page 10, strike lines 17 through 20, and substitute 4. Read letters succeeding subsections accordingly. Page 11, 9, strike 2024 and substitute 2025. Page 13, line 13, after 4, insert continue counties, and page 13, line 14, strike and county. Page 20, strike line 19 and substitute 1, 2 county representatives who are either a county commissioner or director of county department of human or. Senate Journal, 77th day, March 21st, 2019, page 527, Social Services with 1 representative from an urban county and 1 representative from a rural county. Page 20, strike lines 22 and 23, with numbers succeeding subparagraphs accordingly. Page 21, line 3, strike or psychiatrist. Page 24, line 9, strike 2024 and substitute 2025. Page 26, strike lines 26 and 27. Page 27, strike lines 1 through 8 and substitute Section 3 in Colorado Revised Statutes 2 through 1203. Add 16A4 and 16A5 as follows. 2, 3, 1203, Sunset Review of Advisory Committees. Legislative Declaration Definition Repeal 16A. The following statutory authorizations for the designated advisory committees will repeal on September 1st, 2025 for the Children and Youth Behavioral Health Policy Coordination Commission created in Section 2426.045. The Children and Youth Behavioral Health Policy Coordination Advisory Council created in Section 2426.07. Health and Human Services. African Service and Mayor's Committee recommends that House Bill 1065 be referred to committee of the whole with favorable recommendation. Recommendation placed on the consent calendar. Message from the governor. Thursday, March 21st, 2019, Colorado Senate, the 72nd General Assembly, First Regular Session, State Capitol, Denver, Colorado, 80203. Honorable members of the Senate, pursuant to the authority vested in the office of the Governor of the State of Colorado, I have the honor to inform you that I have approved and filed with the Secretary of State the following acts. Senate Bill 19019, County Fireworks Restrictions, July 4th, approved Thursday, March 21st, 2019 at 4:22 p.m. Senate Bill 1943, increasing number of district court judges, approved Thursday, March 21st, 2019 at 4:04 p.m. Senate Bill 1971, child hearsay exception, approved Thursday, March 21st, 2019 at 4:15 p.m. Sincerely, Jared Polis, Governor, signing of bills, resolutions, memorials. The President has signed Senate Bill 16, 17, 35, 68, and 103. Page 528, Senate Journal, 77th day, March 21st, 2019. Journal correction, page 501, line 70, strike court and insert quorum On motion of Majority Leader Finberg, the Senate adjourned until 9 a.m. Friday, March 22nd, 2019. Approved, Lee William Garcia, President of the Senate. Attested, Cindy L. Markwell, Secretary of the Senate.
Mr. Carpenter, please add Senator Bridges to the roll call. Committee reports.
March 22nd, 2019, Committee on Appropriations, F. Consideration of Mayor's Committee as following. Senate Bill 203, referred to Committee of the Whole, the favorable recommendation, March 22nd, 2019. Committee on Appropriations, F. Consideration of Mayor's Committee recommends the following. Senate Bill 133 be amended as follows. As submitted, referred to Committee of the Whole with a favorable recommendation, March 22nd, 2019. Committee on Appropriations, F. Consideration of Mayor's Committee recommends the following. Senate Bill 137 be amended as follows. As submitted, be referred to Committee of the Whole with a favorable recommendation. Recommendation placed on the consent calendar, March 22nd, 2019. Committee on Appropriations. After consideration of the Mayor's Committee records following, Senate Bill 154 be referred to Committee of the Whole with a favorable recommendation, March 22nd, 2019. Committee on Appropriations. After consideration of the Mayor's Committee records following, Senate Bill 162 be referred to Committee of the Whole with a favorable recommendation. Recommendation placed on the consent calendar, March 22nd, 2019. Committee on Appropriations. After consideration of the Mayor's Committee records following, Senate Bill 164 be referred to Committee of the Whole with a favorable recommendation. Recommendation placed on the consent calendar, March 22nd, 2019. Committee on Appropriations. After consideration of the Mayor's Committee records following, Senate Bill 52 be referred to Committee of the Whole with a favorable recommendation. Recommendation placed on the consent calendar, March 21st, 2019, the Committee on Education has had on consideration and had a hearing on the following appointments, recommended appointments in place on the consent calendar and confirmed. Members of the Board of Trustees for the Colorado School for the Deaf and the Blind for a term expiring July 1st, 2020. Andy McElhaney of Colorado Springs, Colorado, Republican, reappointed for a term expiring July 1st, 2020. Nancy Inez Brown of Colorado Springs, Colorado, Republican, reappointed. Michelle Ann Butler of Colorado Springs, Colorado, unaffiliated, reappointed. Alan G. Ward of Poncha Springs, Colorado, an unregistered voter, appointed. March 21st, 2019, the Committee on Education has had on consideration and heading on the following appointments, recommended appointments in place on the consent calendar confirmed. Member of the Colorado Student Leaders Institute Executive Board for term expiring July 7th, 2019, Brian David Yates, one of his Colorado service person from the community who has an interest or experience in education occasioned by the resignation of Letty Garcia Eckstein, reappointed. March 21st, 2019, the Committee on Education has had consideration and had hearing on following appointments or recommends appointments to be placed on the consent calendar confirmed. Members of the Colorado Commission on Higher Education for term expiring July 1st, 2019, Stephanie F. Donner of Denver, Colorado, a resident of the 1st Congressional District, and a Democrat occasioned by the resignation of John L. Anderson of Durango, Colorado, appointed for term expiring July 1st, 2022. Barges Madivi, PhD of Denver, Colorado, is a resident of the 1st Congressional District and Democrat appointed. Manisha B. Kerr of Aurora, Colorado, a resident of the 6th Congressional District and Democrat reappointed. March 21st, 2019, the Committee on Education has had on consideration and had hearing on following appointments or recommends appointments to be placed on the consent calendar confirmed. Members of the Board of Trustees for Fort Lewis College for term expiring December 31st, 2022, Janet Kier Lopez Vilsack, PhD of Mountain View, Colorado, a Democrat appointed. Alan G. Hill, Denver, Colorado, an unaffiliated reappointed. March 21st, 2019, the Committee on Education has had on consideration and had a hearing on following appointments and recommends the appointment be placed on the consent calendar confirmed. Member of the College Invest Board of Directors for term expiring July 31st, 2022, Sarah R. Williamson, CFPCI, MACDFA of Denver, Colorado, reappointed. March 21st, 2019, Committee on Education, after consideration of the Mayor's Committee records following, Senate Bill 171 be referred favorably to Committee on Appropriations. March 21st, 2019, Committee on Transportation and Energy, after consideration of the Mayor's Committee records following, Senate Bill 96 be amended as follows. As so amended, be referred to Committee on Appropriations with a favorable recommendation.
Senate Services.
Correctly printed, Senate Bill 205 and 206. Correctly engrossed, Senate Bill 2, 3, and 10. Correctly revised. House Bill 1007, 1106, 1129, 1166, 1173, and 1209. Correctly enrolled, Senate Bill 109.
Mr. Majority Leader.
Thank you, Mr. President. I move that we proceed out of order for a moment of personal privilege for Senator Janal.
You've heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the motion is adopted. The Senate will proceed out of order to take up a moment of personal privilege from Senator Janal. Senator Janal.
Thank you, Mr. President, and I request a moment of personal privilege.
Granted.
Thank you. Members, I am wearing a red tie today. I don't normally wear red ties or ties, but this red tie is very symbolic. It represents bleeding disorders, and today is Bleeding Disorders Awareness Day. In fact, walking in right now are members of the Colorado chapter of the National Hemophiliac Foundation. They are here today in their red ties, too, and that's how you can distinguish them. In fact, will some of you please stand? They just walked in. Thank you. I'm asking you all to please talk to these folks to learn more about fighting against these inheritable bleeding disorders. Hear their challenges, children, and what these children have to do every day or every other day with hemophilia or other bleeding disorders, as well as adults and what the families have to do and have to learn to do both medically and cost-wise. These are people who live with hemophilia and bleeding disorders every single day, and their voices and their personal stories are so important for you all to hear. And now I'd like to read a tribute on their behalf. I'm shortening it a little bit to save my voice. So, the Colorado State Senate convened in the first regular session of the 72nd General Assembly hereby extends heartiest congratulations and commendation to Bleeding Disorders Awareness Month. This Awareness Month will generate greater awareness and understanding of not only hemophilia, but also other inheritable bleeding disorders, including von Willebrand's disease, which alone impacts an estimated 1% of the United States population. Doesn't sound like a whole lot, but it is more than 3.2 million individuals. Moreover, this Awareness Month will foster a greater sense of community and shared purpose among individuals with all inheritable bleeding disorders. This Awareness Month will elevate awareness and engagement in the inheritable bleeding disorder journey beyond our community to the general public, enabling the prevention of illness and unnecessary procedures and disability. On the request of Senator Joanne Janal, given this 22nd day of March 2019, State Capitol, Denver, Colorado, signed Leroy M. Garcia, President of the Senate. Members, take a chance to come and meet folks with blood disorders and talk to these families and learn about what they have to do and how they cope with this from day to day. And just want to welcome you all here today. Thank you so much.
The Senate will be in a brief recess to welcome our guests.
Further discussion on the State Affairs Committee report. Senator Gardner.
Thank you, Mr. Chairman. So, I'm just trying to really understand what the changes were in state affairs. And I found the explanation a little bit perfunctory, and my apologies, but could I ask the sponsors to go through, for instance, lines 1 and 2 do a particular thing, 3, 4, and 5 seem to do something, 6, 7, and 8. 9 is very important because it struck the word corroborated, and I would be interested in what the effect of striking the word corroborated, which is generally associated with the term evidence, and then what is the effect of 10 through 18?
Senator Pedersen.
Thank you, Mr. Chair. We thought that it was really important that we provide information on how to get help if an ERPO is actually being served. We also have we had some technical amendments to ensure that the information wasn't kept in the NICS storage database. That was actually an error in the drafting from an amendment in the House, so we had a technical amendment to that.
Senator Gardner.
Thank you, Mr. Chair. Well, I find the committee report very alarming. It says, at line 9 of the committee report, says page 11, line 26, strike the word corroborated. Now, I'm not surprised to find this in the committee report, the striking of the word corroborated, because it was a House amendment to put that in front of it. So let me read, just so there's context, I'm going to need to start back. This entire section starts on page 10 at line 16. Hearings on petition grounds for issuance, for order issuance. And I won't read all of it, but it basically says upon the filing of the petition, the court's going to order a hearing be held, give notice, etc. The next thing says, before the next court day, the court clerk shall forward a copy of the notice to a law enforcement agency. A copy of the notice of hearing must be served on the respondent. The court may issue a temporary extreme risk protection order pending the hearing. And then it goes on, it sets a requirement of clear and convincing evidence, but it goes on, and then at 3, starting at line 24, it says, in determining whether grounds for an extreme risk protection order exist, right now it reads, the court may consider any relevant corroborated evidence, including but not limited to any of the following. And it says a recent act or credible threat of violence by the respondent against self or others, whether or not such violence or credible threat involves a firearm, which is critical, by the way, because you might say offhand, and I don't advise it, I always advise my clients to be careful in their speech, but you know, people say things that don't involve the use of a firearm that sound sort of violent, and that's at the top of the list, although it's not given priority. So to be very candid with you, members, when I read the re-engrossed bill as it came over from the House, and I saw that they had added the word corroborated in front of evidence, I breathed a certain sigh of relief. I breathed a certain sigh of relief because it indicated that our colleagues in the House understood that if a court is going to issue this red flag order against a citizen who has not committed a crime, that whatever evidence they use needs to be corroborated. It has to not be simply the evidence of the spouse, a family member, a household member, maybe a roommate who has an axe to grind all of a sudden. And so that word corroborated carried loads of meaning to me as an attorney. I'm sure the senator from Boulder County will understand that that carries a lot of weight to simply say the evidence must be corroborated. I mean, right now, a unhappy family member, a household member, again, a housemate who, you know, imagine the scenario. We've dealt with issues of squatters and people who stay in your home, and imagine you have this housemate who hasn't paid his rent, and you've decided it's time for him to move on because he doesn't keep house very well, and you happen to be a firearms owner, a gun advocate, a hunter, and you say to your housemate, I really need you out of here by next month. And the housemate says, well, I'll show you. And the housemate goes and signs an affidavit and says, my landlord, so to speak, the owner of the home in which I'm renting a room, he said to me that if I don't leave, and maybe they did have a few words, he said to me, if I don't leave, he'll make sure I don't see the light of day in this house again. And, of course, the bill already says whether or not such violence or credible threat of violence involves a firearm, so that's enough. I mean, what if the owner says, well, yeah, I did say that, and what I meant was I was going to call some people to have him removed. Now, that may invoke other things in the law, but there wasn't any threat of a firearm, and that's a credible threat, perhaps of violence. And better yet, what if the homeowner has a history some years before of a violent crime, has served his time, is out on parole, maybe has served his parole, back in the community, had rented the room to someone trying to get by, and then that person says, you're not going to get rid of me so easily. I'll just have all of your firearms taken. Maybe that person has a hypersensitivity to the fact that there are firearms in the home. And what if that homeowner who has access to, I mean, one of the things is ownership access to a firearm, says, I never said such a thing. Says to the judge under oath, penalty of perjury, I never said such a thing. Oh, yes, by the way, the petitioner said under oath, under penalty of perjury. He darn sure did. I swear to it, Your Honor. They both swear to it, Your Honor. Who else was there? You're not going to get a perjury conviction off of that. I don't think the good senator who's a deputy district attorney would prosecute that case for perjury, because that's going nowhere. And so, to not be, in case you've lost the thread of this discussion about the committee report removes the word corroborated back there on page 11, which was a very important protection. A very important protection for an innocent citizen. Let me repeat that, an innocent citizen. You say, well, he's not so innocent. Well, wait a minute. Hasn't committed a crime, he's not charged with a crime. He's just been accused by someone in an affidavit of having conveyed maybe a threat. Maybe it wasn't a very precise threat. And the way this is structured, and we'll go through it in detail later, but the way it's structured, it could be a simple affidavit without any cross-examination. What exactly did the respondent, we refer to the person who's being drug in to have his firearms taken away or her firearms taken away. We'll talk about that scenario later today. This corroboration here requirement is incredibly important, particularly when you're allowing these orders to be issued on affidavit or by a telephonic hearing, which might be subject to cross-examination, but it's a good deal more difficult to do and to test the credibility of a witness in a telephonic hearing. Those of you who have done teleconferences know they have their limitations. So I am incredulous that after the House, in its sort of surprising wisdom, had put the word corroborated in front of evidence here to require that whatever evidence it is have some other support other than just one witness against the other. And you say, well, will that ever be clear and convincing evidence? Well, if the judge says it is and he or she's convinced, then it's going to happen. And it isn't going to get reversed until sometime later, if at all. But that word corroborated has a lot of meaning to judges. And it was going to limit the instances of these, what I believe to be unconstitutional red flag orders. It was going to limit them. It was going to limit them in a way that protected the rights of citizens and really sort of protected the courts, I think. I think the whole issue is going to be a difficult one for judges and magistrates in our state. Darn if they do and darn if they don't. Don't want to use the real words. Because at least it gave them some guidance about what evidence had to be. As it is now, you're going to get maybe a very credible sounding petitioner. Maybe you're going to get a frantic family member who themselves maybe they have some problems. You know, these situations don't come in clean, neat packages. Those of us who practice law, those of us who've prosecuted cases and defended cases, as I have, know that they don't come in nice, clean packages where it's like, okay, that person's clearly telling the exact truth. I mean, we had a disagreement about what was said about moving an amendment yesterday, and I went back and watched the video of that and found that what my recollection was exactly as I thought it was, and others' recollection wasn't. And that's just an example of how these recollections of what was said and what was intended and what was meant was there. And that's why the corroboration was so important. Members, we should reject the committee report. And while I could talk for several more hours about the committee report itself because of its objectionability, that pales next to the entire bill, and so I will take a moment and perhaps let one of my colleagues offer an amendment to the committee report, or something else.
Senator Gardner, for the record, I always had the utmost confidence you'd find your way back to the committee report. To the committee report, Senator Tate.
Thank you, Mr. Chair. I too am troubled by removing the requirement to have evidence corroborated. And I ain't no country lawyer. I'm not a city slicker lawyer either. I'm just a country businessman, I guess. And so I don't have the full understanding about the need for corroboration of evidence and testimony that my colleagues might have and be able to educate me further on. But certainly what rang true to me is the importance of, the importance of how corroboration protects innocent people. And so my challenge to the bill sponsors, I suppose at this juncture, is to explain why was that removed, especially since in the bill it appears to me, and again, I'm an amateur when it comes to reading law, but it seems to me the burden of proof overall for the petitioner is lower than for the respondent as it's structured in the bill. And here we have the need for corroboration removed in addition. So I'd really like the bill sponsors explain to me, a layman, why that's necessary. Thank you, Mr. Chair.
Senator Foote.
Thank you, Mr. Chair. And as the chairman of the committee that heard this bill, I guess about a week ago, I'm happy to comment about a couple things about the bill and about the committee report, specifically regarding the issue that's been brought up by my colleague from Colorado Springs in particular, and that's the corroboration requirement. So one thing I'll say at the outset, which is always what I try to do when amendments are offered on bills, is my experience has been I've typically regretted just putting them on the bill without any kind of in-depth analysis. And the reason being is that sometimes amendments sound good, they sound appropriate, you don't disagree with them, but as it turns out, they aren't necessary or they cause some issues down the line that have not been completely considered. And so in the context of that experience is the way I look at the corroborated amendment, which was put on in the House in committee after a suggestion at the end of the hearing, and as I understand it, was adopted because it sounds like a good idea. And there's nothing wrong with the idea of corroboration. So, but upon further reflection, it seems as though that the amendment is not necessary, and I'll give you some idea of why. But first, I want to give you a little bit of background about the genesis of the bill and why it was written the way it was, as I understand it. First of all, there are models to draw upon in other states. Many other states have a variant of this extreme risk protection order process. And also, we here in Colorado have a model of search warrants, for example, in the criminal context requiring probable cause before the warrant is issued. We have child protection procedures where if the child is in danger, then they are at least temporarily taken away from the custody of parents. And so there's a number of models to draw upon when deciding how to put into this new procedure. But we also don't necessarily need to stray too far away from the models that we have that have seemed to work in Colorado. In this case, when there are presentations made to a court, let's take the child protection cases. When it's the child protection case, the petitioner that's asking for the child to be taken out of the custody of the family, of the parents, or their guardians at the time, they have to meet their burden by clear and convincing evidence, which is actually what was adopted in this case for the year-long extreme risk protection order, clear and convincing. There's no requirement in that particular statute that there needs to be quote-unquote corroborated evidence, but they do have to meet a high burden. The high burden is clear and convincing. That's an extremely high burden, very difficult to meet, and justifiably so in the child protection context, as well as this extreme risk protection order context, a very high burden to meet. And that's a good thing. The petitioner has to meet that burden. But nowhere in that particular statute, nor anywhere in the criminal search warrant issuance statute or rules does it require quote-unquote corroborated evidence. It does require to meet the burden of proof. And so however the petitioner tries to meet that burden of proof is up to them. But if they don't meet the high burden of proof, if they don't meet the clear and convincing evidence in this case, burden of proof, then that's on them. So to the extent that they can bring in what they consider to be or what they offer as corroborated evidence, that's fine. That might help them meet their burden of proof. But anyone that has worked in law enforcement or in the courts in general know that just because somebody brings in a witness that supposedly is corroborating what they say doesn't make it so. Somebody can bring in a family member or a friend that backs up the person making a claim. That doesn't necessarily mean that that's going to be corroborated, and that's an issue. So the court obviously and ultimately is going to decide whether or not the petitioner's met the burden of proof. In this case, the burden of proof doesn't change. It's still a clear and convincing burden of proof that the petitioner has to meet, regardless of whether or not this word corroborated is in there. And I would opine and believe that it's not necessary. If the petitioner wants to bring in what they consider to be corroborating evidence, then they should do that. They will have to know they have to meet a high burden. However they meet it is up to them. So I would ask for an aye vote on the committee report.
Senator Tate. Senator Tate. Tate.
Sorry. Okay.
Thank you, Mr. Chair. And again, I thank the senator from Boulder for some of those expository remarks. But I do have a follow-up question because, again, I'm not a lawyer. It struck me, though, again, looking at the bill in terms of the burden of proof standards, you mentioned that the lack of corroboration requirement wasn't really a factor with a high burden of proof of clear and convincing evidence. But my initial reading of the bill, and correct me if I'm wrong, again, because I'm not a lawyer, is that for the petitioner at this stage, the burden of proof is not clear and convincing. It's a lower standard. And so, and maybe there's not that much difference between those standards, and maybe the lawyers here can help explain that to me. But with the lower burden of standards, shouldn't we thus have a higher standard for evidence? And I asked my legally minded colleagues to help explain that to me. Thank you.
Senator Pedersen.
Thank you, Mr. Chair. And thank you, Senator Tate. You're speaking to the bill. And with that, I ask that we adopt the committee report and move on to the bill.
Senator Tate.
Thank you, Mr. Chair. And just for a point of clarification, I was speaking about the role of corroborated evidence and the requirement that corroboration be a part of the process that was specifically removed in the committee report. And so I definitely am still talking about the committee report. Thank you.
Senator Foote.
Thank you, Mr. Chair, and happy to clarify. And so the committee report in the corroboration requirement was specifically referencing the extreme risk protection order that would issue after the temporary order. And so the temporary order would be put into place. That has a preponderance of evidence standard. And that's the temporary order that goes into place for no more than 14 days before you have to have a permanent extreme risk protection order hearing. And the corroboration requirement that was put in the House only applied to the more, it's not a permanent hearing, it's a 364-day or less extreme risk protection order hearing. So I think as we go on in this debate, we want to make clear that there's actually a couple of procedures that are outlined in the bill. There's the temporary extreme risk protection order process, which requires a preponderance for no more than 14 days, and then a more 364-day or less extreme risk protection order. So that has a clear and convincing burden of proof, and that is where the word corroboration was put in, and that's where the committee report would then take the corroboration out. But it does nothing to affect the burden of proof that still is in effect for the 364-day or less extreme risk protection order hearing.
Senator Gardner.
Thank you, Mr. Chair. So, my good friend, the senator from Lafayette, says, well, you could have corroboration and that doesn't change the burden of proof, but it certainly is an additional protection for respondents in that burden of proof. It's very clear. I mean, you may have a second witness that's corroborating witness, and you might not believe them either. In fact, they may be inconsistent with the first witness in material ways to the point that it detracts from the original testimony. But we've probably talked about that enough. I have further questions about the committee report. Now, the committee report says that at page 5, lines 26 and 27, they're to be stricken. And so page 5, lines 26 and 27 currently say, and I think the important and operative things here are, and above that, there's a phrase: a hearing by telephone must be recorded and provided to the respondent prior to the issue of an extreme risk protection order. And that sentence, really, the practical effect is that sentence has been replaced by a copy of the telephone hearing must be provided to the respondent prior to the hearing for an extreme risk protection order. And I'm wondering why this change was made. In some sense, those two sentences might be functionally equivalent. It says a hearing by telephone must be recorded and provided to the respondent prior to the issue of an extreme risk protection order. It's being replaced with a copy of the telephone hearing. Well, that's very inspecific to me. Does that mean a transcript? Does that mean the audio recording itself? Does that mean one or the other? I'm trying to figure out what fulfills this new requirement. And because I'm simply asking why did the change even get made? There must have been concern on someone's part about the language that it was amended in the House. So what is the import of the language change?
I suspect that as long as it's 300 words per minute or less, we're good to go. Senator Fields.
Thank you, Mr. Chair. And members, I urge that we adopt the committee report. And I want to use a real live example as it relates to domestic violence. Because oftentimes, if you're stuck in a situation where domestic violence is taking place, a lot of times that's done in secrecy. Your spouse or your partner can be calling you every single day, harassing you, intimidating you. And there's no one else to really witness or to verify that these comments are taking place. Do we dismiss that when that person is still in harm's way? People who commit domestic violence are very calculating. It's the same with abuse. They do things that you can't always see, and there may not be anyone else around to verify that it took place. But the person who is the subject of the kind of abuse or attack knows what's going on. Sometimes it cannot be collaborated, but it's real. And there's other forms of evidence that can be used. I'm not a lawyer. I just want to give voice to those who are trapped in domestic violence situation where someone is constantly harassing them and there's no one around to see it, but they're experiencing it. They're experiencing it to the point that they want to have someone intervene in their behalf. So what I would like for you all to do is just to think about those types of scenarios where there's a lot of secrecy that's going on in that home or in that relationship or maybe in the workplace, whatever. And it's just between two people, but it's real. So members, I urge a yes on the appropriation bill, on the appropriation report, and let's move forward and talk about the bill.
Further discussion on the State Affairs Committee report. Senator Court.
Thank you. I renew my motion to pass the committee report, please.
Senator Gardner.
Thank you, Mr. Chair, and I appreciate the comments of the senator from Arapahoe County, because it is very true that sometimes crimes are committed, often crimes of domestic violence and many other crimes are committed in secret. But we still require a level of proof and a level of evidence. This was an important change in the House. It was a thoughtful change. But really, I had moved on from that, and I had asked the sponsors a very straightforward question, and it is an honest question, not a question interposed for delay. It is at least less than 200 words per minute. What is the functional difference between the language in the bill right now that says a hearing by telephone must be recorded and provided to the respondent prior to the issue of an extreme risk protection order? That's what it says now. I look at that and I say, well, that seems to be a good requirement because it's talking about a telephonic hearing for the temporary hearing, and it says you've got to provide that copy to the respondent prior to the, I don't know, I want to say permanent. The sponsors say, well, it's not permanent, it's 364 days. That's a long time. But the language that's being changed is from that to a copy of the telephone hearing must be provided to the respondent prior to the hearing for an extreme risk protection order. And as I've said, on their face they seem functionally equivalent to me, but someone saw the need for the amendment, and I'm imploring you, please tell me, what am I missing about those two statements? What's the change being made? And there must have been a motivation for it, and it must be functionally different. And I'm asking the proponents of the committee report if you can tell me what the difference between those two sentences in practice would be.
Senator Foote.
Thank you, Mr. Chair. Again, I'll preface this by going back to my thoughts on amendments that are somewhat on the fly and why it's really are good. It's good to consider these rather than adopting, especially late at night after a committee hearing. In this case, the discussion was centered around whether or not a transcript would be required or just a copy to be required. And so there was a good discussion about that during the amendment phase of the bill. And what the committee came down on the side of was, no, it still should just be a copy to be required to go to the respondent before the hearing. And the reason being is that, and this goes back to the extensive due process also that's built into the bill, which is that the temporary hearing happens, and then you have the hearing for the more permanent order, the 364-day order that happens. And it's such a quick turnaround, it has to be within 14 days. Now, that doesn't mean that it can't be 3 days after or 4 days after. It can be no more than 14 days. And the practicality of turning around and changing it into a transcript was very difficult. So the courts could still turn it into a transcript if they wanted to, or if they had the ability to, but the bill doesn't require that. What the bill requires for the respondent to have is a copy of the hearing before, the temporary hearing before the more permanent hearing. That's why that's in there. So during the course of the discussions, the amendments ended up where they were, but there's really nothing that I think you're missing, I would say to the senator from Colorado Springs. I think it's just part of what our discussion process was in committee. Bottom line is this bill and this committee report continues to ensure extensive due process, which means that if the court decides to have a second hearing within 4 days after the temporary order is issued, the court can do that, and a copy of the entire hearing can be made available to the respondent prior to that hearing.
Senator Tate.
Thank you, Mr. Chair, and I'll come mention something else, give my colleague from Colorado Springs time to digest the legal reasoning from my colleague from Boulder County. I want to draw members' y'all's attention to a different portion of the committee report, and just kind of surprised it's something's being taken out, honestly. I've always thought it'd be really nice to have recourse against somebody who makes a false complaint against you, and someone who makes a false complaint for whatever personal gain purpose. Well, members, in the bill, on page 29, there is a provision that reads, that's been struck by the committee report. I'm making that clear, Mr. Chair, because I am talking about the committee report. What's been removed by the committee report is a section that reads, a respondent who had a malicious or false petition for a temporary extreme risk protection order or extreme risk protection order filed against him or has a private cause of action against the petitioner. Why wouldn't we want to provide recourse for someone who's had a false complaint against them? I don't even know how to say anything more about that, honestly. I think it's important to keep that in. And I'd like to know further, I guess, from the bill sponsors, in their judgment, why we shouldn't have that in there for a respondent. Thank you.
Further discussion? Senator Gardner.
Well, I thank the senator from Centennial for raising that issue, that down at the very bottom, you know, sometimes in committee reports things can be incredibly deceptive. There's one little line that says, page 29, strike lines 8 through 13, and the good senator from Centennial read that to us, so I won't read it again, but what it is and it was added in the House, our legislative colleagues in the House, where the majority party here is also the majority party there, so it must have had support. Says, you know, and again, I won't read it again, it says it provides a remedy for a malicious or false petition for a temporary extreme risk protection order. The senator from Arapahoe County talked about how things are done in secret, surreptitiously. Malicious complaints are made as well. And this ensures that there is a remedy. I think it would be very difficult to prove this kind of a case in the same way that it would be difficult to obtain an extreme risk protection order when we require corroboration. But the committee report is removing an important protection and an important safeguard against false petitions. It's in many ways better than the I swear under penalty of perjury, which means that I have to depend upon the district attorney to prosecute my case. This allows a respondent who has been vindicated. I think almost certainly it would only be used when they subsequently are able to prove that the petition was falsely done. And it provides a remedy for them. And in this one little line in the committee report, it is stricken. I would ask the proponents of the bill in the committee report to tell us why it is that this protection has been stricken in the committee report and why they are supporting the idea of striking a protection for one who might have a false report filed against him or her.
Is there further discussion? Seeing none, the question before us is the adoption of the State Affairs Committee report. All those in favor say aye. Aye. Opposed, no. A division has been requested. The question before us is the adoption of the State Affairs Committee report. A division has been requested. All those in the chamber not entitled to vote, please be seated. Concerning adoption of the State Affairs Committee report, all those in favor, please stand and remain standing until the count is taken. Please be seated. All those opposed to the committee report, please stand. The committee report is adopted. To the bill. Center Court.
Thank you, Mr. Chair. Members, I'm wearing purple today. I wear purple a lot because I love purple. It's a pretty color, but it also is the color of our state. We are a purple state. We are a bipartisan state. We are a state that recognizes everyone comes from different parts of the state, and we all have different opinions. But we are a purple state. This is a purple bill. This is a bipartisan bill. 80% of Coloradans support extreme risk protection orders. 73% of Trump voters support extreme risk protection orders. I will say that again. 80% of Coloradans support extreme risk protection orders. 73% of Trump voters support extreme risk protection orders. This bill is about saving lives. This bill is absolutely constitutional, and we can discuss that in more detail. It is a civil, not a criminal process. There is more due process in this bill than there is when your children are taken away from you. This bill is, in Ben Franklin's inimitable words, an ounce of prevention worth a pound of cure. It is not primarily about mental health. It is about removing firearms from people who are in danger for whatever reason of hurting themselves or others. Again, this bill is about saving lives. It is supported extensively by members, citizens from all over our state. I urge a yes vote, and I look forward to the debate. Thank you.
Thank you, Mr. Chair and members. I am proud to be here today to introduce this bill as a Senate sponsor. I am also not a country lawyer, but I am a Colorado native, grew up in Jefferson County. I was at Chatfield when Columbine happened. I was in 10th grade. And that was the beginning of tragedy after tragedy that we have experienced here in Colorado from gun violence. I'm here in support of this bill because it honors due process, it honors the Second Amendment, but it ensures that we actually have a high threshold, a process in place to protect each other, our community, those who are at risk, who are going through a crisis, and our first responders. I want to acknowledge where this bill came from, which is it is the Zachary Parrish III Violence Prevention Act. Thank you to the Parrish family for being strong, for standing with us to pass common sense gun safety legislation that will ensure that people in Colorado, our first responders, are not put in the position that Zachary Parrish was, without a process in place to ensure that they were able to take weapons away from somebody who was going through a crisis. There was escalating behavior, and it was well known that this person, his murderer, was at risk to our community. They were unable to do anything to take his weapons away. Oh, inside voice, or is this the Gardner voice? I also want to recognize one of my constituents who has inspired me over the years, who is with us today, Jane Doherty, who lost her sister in Sandy Hook. And as she acknowledged, it hasn't been 6 years, it was 7 years now. She reminds us to stay strong like her sister was, who ran to the person who was going out to shoot students in Sandy Hook. Thank you for being an advocate, thank you for being strong, and thank you for being with us today. This piece of legislation will only apply to the very rare instances that somebody has these escalating behaviors, goes through this due process, this high threshold, and actually gets their weapons taken away. It also provides a process to either give their weapons back if they can prove that they are now in a better place, that in fact they've had the help that they need, they are not at risk for hurting themselves or others. So they'll either get the weapon back, or there is another court process on whether or not those guns should be kept for another 364 days, but that is also up to the discretion of the judge. They do not have to say 364 days. They can have a much smaller time frame and bring them back if they choose to. This is not just about the mass shootings that we have seen in Colorado and across the United States. This is also about suicide. Colorado ranks one of the top states in the country for the highest percentage of people who die from suicide every year. We know that the most effective form of suicide, in fact, 85% of people who attempt suicide and use a gun are successful. So we know that when somebody is at risk to themselves and others, and they have a weapon, if we are able to provide this process in place to take it away, that they are less likely to actually succeed with going through with a suicide. This is important to me. My older brother died from suicide. We know that when people are having a crisis, if we take away their weapons, if we give them the help that they need, they are much less likely to die or hurt others in our communities. So while we're going to go through the particulars and question every piece of text in this bill through who knows what time tomorrow morning, maybe, I just want us all to remember what this really is about. This is common sense. This is protecting the Second Amendment, and it's also protecting our community, and I ask for your support.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L077?
Amendment L077, House Bill 1176.
Senator Tate. Senator Tate.
Oh, thank you, Mr. Chair. I move Amendment L077 to House Bill 1177.
To the amendment, Senator Tate.
Thank you, Mr. Chair, and I'm introducing this amendment immediately, just since we had the discussion some moments ago. This amendment deals with the committee report where the recourse for a respondent who's had to deal with a false complaint was taken out. I feel very strongly that a respondent should be able to have recourse against a malicious or false complaint, and I ask for your support, members of Amendment L077. Thank you.
Discussion on the amendment. Senator Foote.
Thank you, Mr. Chair. And of course, I think, I guess I can speak for myself, but I would assume I can speak with others that, of course, anytime any procedure like this is put into place, there's concern about the possibility of the system being abused. And that's why there's a number of protections already in this bill that are designed to make sure that that doesn't happen. Just above the section that's at question on page 29, the re-engrossed version, it says, a person who files a malicious or false petition for temporary extreme risk protection order or an extreme risk protection order may be subject to criminal prosecution for those acts. Now, that language actually is not even required to be in there, I don't think, because anytime that somebody files a false report or anytime somebody commits perjury through a sworn statement that's provided to the court is subject to prosecution. But it is in there again, I think, just to reassure. And the other thing that I'll point out is that there are civil remedies already available for this kind of act. If something that is done in front of the court that is a false statement that causes the deprivation of civil rights or any rights of a victim, they can file a course of action or a cause of action in federal court now under 1983 and other sections. So these things already exist. And I think it's my view, and I would think with the sponsor's view as well, that this language is just not necessary to make sure that those still exist. So they already exist. There's already recourse, and we'd ask for a no vote on this amendment.
Senator Smallwood. Senator Tate.
Thank you, Mr. Chair, and I appreciate my colleague from Lafayette, as they would say in Tennessee, for responding to that. And yeah, I appreciate there are other remedies available. But, first, just thinking about the observation that the paragraph above provides a remedy related to criminal prosecution. Well, that is related to, the DA bringing charges for a crime having been perpetrated. And this, of course, then is dependent on the DA taking action. And secondly, my colleague mentions that there already is protection in terms of when civil rights have been violated. Well, I agree that's very important. I'm glad to know and be educated that that's something that's available. But I think, this paragraph does bring in just general damages that might be beyond just the narrow concern of civil rights, a very important concern, but just general damages. And so I think, again, while I appreciate the additional explanation, and I'm glad to know that those protections are there, as my colleague mentioned, I believe after hearing that information, I am more persuaded now that this recourse is necessary and important, and I remember I urge y'all to take a aye vote on this amendment. Thank you, members.
Senator Smallwood.
Thank you, Mr. Chair, and I also rise in support of Amendment L77. Colleagues, if you look through the bill and you see what changes the House made, and I understand we're our own chamber and we do our own thing, but there was a tremendous amount of debate over this bill in the House, and there weren't that many substantive changes made to the bill. This was one of them. The House felt that this was reasonable. They felt that it was important, and I wholeheartedly agree. And as the senator from Arapahoe County has already mentioned, when we're talking about a citizen of our state needing to fight something like this, if it was truly, as the bill reads, malicious or false, if one of our citizens has to fight this, how many of us have the resources to go and do that, knowing that if they lose, they're potentially out a tremendous amount of time, a tremendous amount of money? To me, this is a real common sense addition to the bill that says, again, if there's been a malicious or false petition for a temporary risk protection order or an extreme risk protection order filed against him or her, that they have a private cause for action against the petitioner. And what I found most important is that they are, in statute, entitled to not only actual damages, but attorney's fees and costs. Colleagues, we all know how expensive litigation is. To give our citizens this basic protection to know that if they fight something that truly is wrong, truly is malicious, truly is false, that they can, if nothing else, have their attorney's fees paid for them. So I would strongly ask for an aye vote on Amendment 77.
Senator Smallwood, you are out of order for suggesting that the House did something right. Colleagues, the court rule is relaxed for the staff and guests as well. Further discussion on Amendment L077. Seeing none, the question before us is the adoption of Amendment L077. All those in favor say aye. Aye. Opposed, no? Amendment L077 is lost. Senator Sonnenberg. Senator Lundin.
Thank you very much, Mr. Chair. These comments are really directed more to people outside the building than to those of us inside the building. It's kind of to set a context for what's happening here today. We begin this conversation in broad agreement. We want the public to be safe. We want an individual who is having potentially a mental break to be cared for. That's important for everyone here. We all want to do that. And that's when you hear comments about polls where people say broadly they support the idea. Of course, everyone supports the idea that we want people to be safe. The question of do we want people to be guilty until proven innocent, however, gets a dramatically different response. And that's what the course of this debate today will be about. It will be about defining the words and phrases that end up in the red books that are the law of Colorado. Now, I would encourage the people who might be watching this debate to be patient. Pay attention to the details. Engage with us, if you would, in the conversation about drawing precise lines that honor and defend our Constitution, that seek to provide support to people who may be in crisis, and that are something that we can live with appropriately every day. So, again, I speak to the people outside the building and say, please join with us today as we work diligently to craft law that honors our Constitution and, in fact, provides service to people who need it, but doesn't do violence to the principles of who we are as a people and as a country. Thank you, Mr. Chair.
Senator Sonnenberg.
Well, thank you, Mr. Chair. Colleagues, I think the previous speaker hit the nail on the head when he said that we all want our friends, our neighbors, people of Colorado to be safe. And the question arises as to what do we do to make that happen? Obviously, this bill says, let's take your guns away, and then we'll give you an opportunity to get them back if you can prove that you're safe. We heard horror stories, potential nightmares for families in committee about exes, about people who used to be a part of the family, how one person currently, young lady, carries a gun just to make sure her ex-husband, who has a restraining order against him, does not come and harm her, and in her words, kill her. If he went through this process and said she was crazy, or she was a threat to the children, and left her vulnerable by taking the guns away,
Her fear was she would never see the day in court to try and prove herself innocent. We also heard from law enforcement about how the potential for them to be hurt or killed when trying to confiscate these guns. In an attempt to try and follow a court order, they put themselves in an unnecessary harm's way and a potential escalation which would have never happened without that threat of a SWAT team knocking on the door. So what is the answer? I think first we have to figure out what is the problem. We talk about mental health on a regular basis. We talk about the mental health of people that do mass shootings. We talk about the mental health of people that abuse their families, their children, who bully others. The one link we have in all of these travesties, these disasters, is the mental health. So why not deal with the mental health? Why not create a situation in which you can still call, you can have an affidavit put before the court, and when you put that affidavit in front of the court says, yes, that person potentially has the ability to hurt themselves or others. Let's have them talk to a psychologist. Let's have them talk to somebody so we can determine if we need to help them or if we need to do something further. Instead of taking the guns, ladies and gentlemen, let's try and get to the root of the problem. And as we try to get to the root of the problem and allow the courts to help those that need help, ladies and gentlemen, that is a more reasonable answer that, quite frankly, helps everybody and stays within our Constitution.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L072?
Amendment L072.
Senator Sonnenberg.
Thank you, Mr. Chair. I move Amendment L072, which does just that. If you look at Amendment L00 or L072, it says you still have an affidavit sworn or affirmed before a judge, but then treatment and evaluation is to be conducted by a psychologist. And then the psychologist shall file a copy of the evaluation with the district court where the person resides, and the court shall then determine how to proceed. Here we deal with the root problem of mental health. Instead of taking someone's guns away, we allow that person to figure out whether or not they truly are a problem to themselves or their neighbors. I ask for a yes vote on L072.
Senator Pedersen.
Thank you, Mr. Chair, and thank you for highlighting what we need to do to support people in Colorado who are suffering with a mental health issue. And we don't do enough. We are working on multiple bills to address support services here, but that is not this bill. And to strike all of the language that we have to put protections in place for people who pose a risk now, where minutes and hours matter, could mean life or death to many. Going through that process does not actually put the protections that are necessary in place. Not everybody who is going through a crisis has a mental health issue. In fact, it's not even a majority of people struggle with a mental health illness. But there are people who are going through a crisis at that moment. And that is why we need immediate action to ensure that they don't have access to their weapons. So this is not going to actually address the issue at hand. And this is not about mental health. This is about somebody who is a risk now, who is in a crisis, who has access to a weapon that was made to kill.
Senator Court.
Thank you, Mr. Chair. There are only about 4 or 5% of cases of diagnosed mental health problems when suicide by firearms. This is current statute dealing with mental health. This is what we already have on the books. Is it sufficient to take care of everything? No, it is not. But there is already a great deal. This is not a bill that is specifically or exclusively about mental health. This is a bill about dangerous people. We spend in 2013, which is the most recent year I have, nearly $100 per person in Colorado addressing mental health. So it is something that we are aware of. It is something that we know we have to do, as my colleague, my co-prime sponsor from Jefferson County said. We continue to work on this issue. But this bill is about removing firearms from people who are in danger of hurting themselves or others, not specifically or exclusively because of mental health issues. We urge a no on this amendment.
Senator Sonnenberg.
Well, thank you, Mr. Chair. And boy, that highlights something for me. All of a sudden, they want to take your guns away just because somebody thinks that even though you're mentally stable, that you could hurt somebody. So does that mean that because the good assistant minority leader is bigger than I am, is he a threat to me? Well, in some ways, yes, but does that mean I should take his guns away? I thought we were talking about trying to deal with violence. Everything in committee was about how mass shootings, how people were causing havoc, unstable people. Surely we don't think we can take away a gun from everybody that makes us uncomfortable. Ladies and gentlemen, the good senator talked earlier about taking guns away from somebody now, and we need that process. This process is just as quick. It goes through the same process. You do an affidavit with the court, law enforcement takes that court order, goes in, and instead of takes guns, takes the person and says, let's go have a conversation with a psychologist. Doesn't change the order at all. Doesn't change the time frame at all. But now, instead of having to prove yourself innocent after being told you're guilty, you actually have a conversation to see if you actually have the potential to hurt somebody. And if the good assistant minority leader I feel threatened by, and I swear that affidavit to court, they can have that conversation. Perhaps they have him talked down if his intent may have been to hurt me. But ladies and gentlemen, let's don't be misled by what this bill does. If we're not going to talk about mental health, This bill is nothing more than a gun grab. I want to help. I want our society to be safer. And I want to get people the help they need when they are mentally unstable. Help us do that here. Help us protect society here without doing a gun grab. I ask for your support on L072.
Senator Lundin.
Thank you very much, Mr. Chair. I rise in support of this amendment, L072. I'm not the sharpest knife in the drawer, but I learned long ago the sooner you can get to the root problem you're trying to address, the better chance you're going to have of success. The more likelihood you're going to solve the problem you're trying to deal with. The cliches we use in society go along these lines. You're just treating the symptom. Why don't you do something about the actual problem? This amendment goes to the root issue. That's highly beneficial. It gets us where we want to go in solving this problem. Furthermore, this amendment seeks to address caring for an individual who is in crisis. That is what we should be about. It does not, this amendment, as the bill does, kick over 5 or 6 or 7 other cans of worms that the bill kicks over. This amendment gets where we need to go. It deals with the root issue. It treats the problem instead of chasing a symptom. It makes a ton of sense. The cans of worms that the bills unnecessarily kick over involve due process. I mentioned it earlier. Do Americans believe that you are guilty until proven innocent? No. That is not part of our core structure. That is not a core value. But that is a question that is raised by this bill. The amendment would solve that problem. There are other constitutional issues. That can of worms of constitutional issues that the bill kicks over, that this amendment gets at the root problem without kicking over that can of worms. Fourth Amendment. We have a right under the Constitution to be secure in our homes, in our papers, in our property. That's a can of worms the bill kicks over that this amendment resolves. I mentioned earlier the idea that we are in America innocent until proven guilty. This bill flips that idea on its head. You have to prove your way out of the problem. And here's another can of worms that the bill kicks over. The person who's making the claim against you that you have to prove your way towards innocence from may not be as closely related to you by reference in the bill. That's how things get really complicated in the statutes, is when you don't call out something specific, when you don't say someone you may have been in a dating relationship with previously in your life, but you by reference bring that same person back into the conversation. That's a can of worms this bill kicks over that this amendment resolves. Another can of worms that the bill kicks over that this amendment resolves is the idea of an ex parte hearing. Big fancy legal words. I am definitely not an attorney. I'm recovering from my 4 years on the House Judiciary Committee. I still feel the pain. The fancy word ex parte hearing means simply somebody got to make a claim against you and you don't get to be there to answer. In your absence, they make claims against you that may have an effect on your person, on your property, on your reputation, and you do not get to be there to defend yourself. That's a can of worms this bill kicks over that, in fact, this amendment solves. And I also mentioned this idea of who may make claims against you in this whole process that is so complicated as to be removed from the root issue, which is what this amendment is about, and that is a person in crisis. This amendment says, let's get psychological help to that individual. Let's go to the core issue. Let's stay focused on the core issue. Let's deal with the problem that is at hand instead of seeking other symptoms that may have nothing to do with the crisis the individual's in. Now, I ask you this. How caring is it to not speak into someone's life when they're in crisis, but to just put them in a box, take something from them perhaps? Doesn't seem caring to me. I think we ought to do something for that individual instead of simply removing things from them, their private property, their personal property. In this specific case, removing their guns, but leaving with them other potentially deadly weapons that they could use on themselves or on others. Let's get to the root issue. Let's get to the question of mental health and caring for an individual who is in crisis. And that is exactly what this amendment does. I urge you to seriously consider this amendment. I urge you to take on the challenge that the people have put before us. Safety in our homes, in our communities, in our persons. Do that by addressing the root issue. Support this amendment that does exactly that. Thank you, Mr. Chair.
Senator Pedersen.
Thank you, Mr. Chair. And we wanted to engage on the mental health piece of this because it came up a lot in committee, just to differentiate what this bill does and is and what is different from the amendment here. And so I think that we'll have a longer discussion on this piece, but this does not actually fit underneath the title, and so I ask for a title ruling, Mr. Chair.
We will be in a senatorial 5. Senator Sonberg.
Thank you, Mr. Chair. I respectfully withdraw L072 as I await the new amendment. Thank you, Mr. Chair.
To the bill. Senator Fields.
Thank you, Mr. Chair. Members, I sit on the State Veterans and Military Affairs Committee, and I heard the full debate on House Bill 1177. I believe we had almost close to 10 hours of debate. And so I heard things a little bit differently than what was just described here. But what was most compelling to me was the story about why we are hearing and debating 1177. It happened in Douglas County. I attended the funeral services. I heard the wife of Zachary Parrish explain the devastation of losing her husband, and her children no longer have their father. The sheriff supports this bill, and so did many other sheriffs and police departments support this bill. The reason they support this bill is because it provides them an opportunity to have effective tools to save lives. The scenario as it took place with Sheriff, the deputy, is that he was known, this guy, I think his name was Rio, Matthew Rio. He was known to have issues relating to behavioral health. For some reason, things started to escalate, and law enforcement did not have all the information that they needed. But Zachary Parrish was doing his job, he was doing the right thing, and he was trying to calm down the situation. Law enforcement came to the apartment or the townhome twice. Once, I understand, it was at 2 o'clock in the morning, and then again they came back at 5. When they came back at 5, there was some exchange of bullets, which cost him his life, and the gunman died as well. This bill is not a can of worms. This bill is truly about saving lives and keeping our community safe, and law enforcement is asking for it. He's asking for it for his whole entire department because they suffered the loss and the tragedy. This is not about grabbing anyone's guns. This is truly about saving lives and protecting our community. And you know what? 14 other states have this law in place already. It's my understanding is that New York City just passed it this month. This is not extreme. This is not over the top. This is not about grabbing people's guns. This is about protecting our community. And this whole argument about false and malicious accusations, well, there's books on the laws for that. That's illegal. And there's consequences to be paid for false reporting. And false reporting may not just happen in this scenario. Police are dealing with false reports all the time. I remember somebody ran a bill, I think it was the senator from Weld County, when people just call emergency vehicles, people to kind of deploy at different parts, and there's no reason for them to be there. But there's consequences associated with that. So to try to say that this bill is a can of worms because of the potential of somebody filing a false report doesn't make a lot of sense. Because if you do that, you're going to get in trouble. The police is not going to tolerate resources to be deployed for a false report. People who investigate crimes are extremely smart, and they can sniff out a lie or something that's deceitful really, really quick. This bill is not a can of worms. If you know anything about recent issues that relate to mass shootings, we want to say that it's all about mental health issues, and sometimes it's not. I don't know why we want to declare that everyone that has a gun has a mental health issue. I don't think that's what you're saying, because that's just not true. And the people that are involved in mental health issues will tell you that the majority of people that may have a behavioral health issue are not violent. But yet we just saw an amendment that says that you have to go see a psychologist. Who's going to pay for that? Some people don't even have access to behavioral health or primary health care. Who's going to pay for that? And why are we making these broad assumptions? Is just because you have some issues going on at home that you have a behavioral health issue and you need to see a psychologist? Who's going to identify that person? I think it's important that we don't criminalize people who have behavioral health issues. We know through statistics and data that if there's a gun in that home and there's issues going on inside that home, there's violence, most likely somebody's going to end up being dead or shot. And that could be because of the behaviors that have been demonstrated in that home. And if there is a record or a background of violence in that home, I believe the gun should be removed. I think there was a bill that was passed in 2018 that suggested that when it was about domestic violence. It passed. If there's violence in that home and someone is frightened, then we should confiscate that gun, because there's patterns to suggest that the likelihood of that gun being used inside that home to harm somebody is very, very likely. If 14 other states can do it, surely Colorado can. Law enforcement is asking for it. We should provide them with the adequate tools that they need to keep our neighbors, our friends, and our community safe. I urge an aye vote on House Bill 1177.
Senator Cook.
Thank you, Mr. Chair. I'd like to address what I just heard about law enforcement asking for this. Oh, that's not quite accurate. We have 22, I think, at this time, and possibly more, counties in open rebellion, and rightfully so. The sheriffs have said, we're not going to enforce this law. Once again, it is an issue of rural counties being taken advantage of by the Denver metro area. We have 22 county sheriffs saying, we won't enforce this. That doesn't sound like to me law enforcement is asking for this bill. As a matter of fact, what they're saying is this bill makes it more dangerous for law enforcement. They're worried about their deputies going in on a surprise visit with a search warrant possibly and a extreme risk order to take somebody's gun. It's already a volatile situation, and now you're going to put law enforcement into that volatile situation where their deputies could get killed or shot at. This is also, well, let me back up just for a second. I've heard from line officer police officers, the ones that actually work the streets, the ones that actually have to go out and enforce this order. And they came to me, as a matter of fact, they came on First Responder Day, and they said, please, please do everything you can to defeat this bill, because it's putting my life in danger. It doesn't sound like to me that law enforcement wants this bill at all. It's also more dangerous, I think, to the public. I've got a little story here that 1 month after Maryland implemented this very same bill, a person by the name of Gary Willis, a 61-year-old black man, has already been killed by this type of bill, by this type of law. Last fall, a month after the Maryland new confiscation went into effect, police in Ferdinand, Maryland, showed up at the man's house at 5:17 a.m. announcing they had come to confiscate his guns. They talked for a while, then argued, and then the police shot him to death. The victim's niece said that her late uncle likes to speak his mind but wouldn't hurt anybody. I'm just dumbfounded right now. They didn't need to do what they did. So not only does it put law enforcement at risk, it also puts the general public at risk. So I would ask for a no vote on this bill.
Senator Pedersen.
Thank you, Mr. Chair, and thank you for bringing up law enforcement and the Maryland law. This is actually significantly more narrow. The Maryland law has a much more expansive definition of who can actually bring an order like this, and so they have a higher percentage of filings. So this is not the same law, and still only 60% of those were actually moved forward with an ERPO. So back to law enforcement in Colorado, I want to thank those who have stood with us in their courage to support this legislation. When we bring up that this is going to actually put our first responders at risk, that is what puts them at risk, is continually sending them back to a place where they know somebody is in crisis and they are a threat to themselves and the community, and they have no tools available to them to actually ensure that they can take away their deadly weapons. We know that law enforcement also, it is highly likely that they have had numerous calls about these individuals. They talk about it as, there's escalating behavior, there are clear warning signs, you've heard from their families, you visited their house, and you're not going to just show up while they're there if you have an ERPO. You're going to wait until it is a safe time for you to enter, which is why you'll wait till they go to the store, or you're going to know what their daily routine is. You're going to be watching them so that you are not putting your first responders at risk. And then it's likely that in this way, that's when the first responders, our law enforcement, will enter, take away their weapons, and then go through the rest of the proceedings. So this is not a situation where they are going to show up, break down a door. They are going to make sure that this is done in the safest way possible to protect their team and to protect the community. And so we heard that over and over from people who were there to testify, who do this work every day, and for those who are actually involved with the shooting for Deputy Zachary Parrish.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L086?
Amendment L086, House Bill 1170.
Senator Sonnenberg.
Thank you, Mr. Chair. I move L086. Mr. Chair, thank you very much for your indulgence for those watching at home, both of you. I wanted to explain, since you don't have an opportunity to look at the amendment, I had explained what the amendment did, but there was a question whether or not this amendment fit under the title. So that you understand, all I did to change this amendment from the last amendment is on line 9, where it says gravely disabled and the person is in need of extreme risk protection. I added the word order so it had the entire title except for the appropriation that was included in the title. So indeed the title ruling, and I appreciate the chairman, although it does change the bill immensely, and does change the bill, it does fit under the title. When you have a title that broad, and the title on the bill is concerning creation of an extreme risk protection order and in connection therewith making an appropriation. So now that I have the full title with the exception of the appropriation, it's fairly clear that this does indeed fit under the title, so let's talk about what it does. I want to re-emphasize that this talks about the root of the problem. Now, we heard during the discussion earlier, and I'm actually thankful for the little bit of the break, part of the question was, this is about, or part of the assertion was, this is about dangerous people. Do you realize that dangerous people is not once referenced in this bill? The word dangerous is referenced once, and that's on the top of page 9, where it talks of future dangerous acts by the respondent. Mental, dealing with mental health, is actually referenced in the bill 4 times. Now, does that mean it's a mandate that we ought to be dealing with mental illness here or mental instability? No. But if you have common sense, you would look and say, do we actually want to deal with the root of the problem to make people safer? Or do we want to do a fly-by-night gun grab in hopes that they don't find anything else, in hopes that law enforcement got all of their guns, in hopes that they didn't have guns in a different place? Ladies and gentlemen, let's deal with the root issue. Let's deal with mental health, and let's get those people the help they need, the evaluation they need, so that all of us can be safer. I ask for your support for L086.
Senator Court.
Thank you, Mr. Chair. Well, I understand the reasoning that the good senator from Sterling put in the language that he did, but now this says that is to be gravely disabled and the person is in need of extreme risk protection order. Well, an extreme risk protection order is all about going in to the home and making certain that the person who is in danger of hurting himself or others does not have access to firearms. That's what an extreme risk protection order is. So the rest of this amendment makes no sense now, because if the person is in need of extreme risk protection order, then that's what has to happen. So the rest of the amendment absolutely makes no sense because it removes extreme risk protection orders. So it contradicts itself and makes no sense whatsoever. I urge a no.
Senator Pedersen.
Thank you, Mr. Chair. And thank you, Senator, for highlighting that we don't define who a dangerous person is. What is defined, actually, is already in statute, is a danger to self or others, which is what we reference in the bill. That is, with respect to an individual, that the individual poses a substantial risk of physical harm to himself or herself is manifested by evidence of recent threats of or attempts at suicide or serious bodily harm to himself or herself. And so we are talking about the danger to that individual and to others in the community, and that is how it is defined in statute and what we reference in our bill. So back to this amendment, I still believe that this does not fit under the title because it completely takes away what this entire bill is about, which is about ERPO. It is about the order in which this entire bill is framed and what is in the title. So this redefines it. It's also a 2-page amendment on the day of. And so I ask for another title ruling, Mr. Chair.
Committee will stand, or we will be in a senatorial 5. The chair rules Amendment L086 does not fit under the title. Senator Sonnenberg.
Well, thank you, Mr. Chair. Then it appears the vast majority of amendments that we put before us do not fit under the title. The cited section in the Colorado Constitution, and Mr. Chair, I ask for a little leeway to talk about this, although it's not specifically related to the bill, with your indulgence. Section 7, no law passed, but by bill amendments. No law shall be passed except by bill, and no bill shall be altered or amended on its passage through either house as to change its original purpose. I would argue that the original purpose of this bill, as in the title says, concerning creation of an extreme risk protection order. The amendment talks about the need of an extreme risk protection order. Although it changes how we accomplish that, I would argue does not change the intent of the bill. We still have an extreme protection order, only this time we use a different process. It's unfortunate that we're not able to look at this bill and actually continue the discussion on mental health, because that truly is the root problem. The other side, my colleagues on the other side, have the ability to have the votes to kill this amendment, so why not have that conversation? Why use this as an avenue to not allow the amendment? Interestingly enough then, I would ask the question, many times we do bills here that turn bills into studies. We have a bill, I think most recently this week, that the original bill was one thing, but instead we're going to turn it into a study which was not the original intent of the bill. Would the Supreme Court of Colorado say that that bill is unconstitutional because we changed the original purpose? Is that not how we negotiate and find common ground? Is introduce a bill, have a conversation, figure out where our common ground is, and then move forward with that bill? The question then becomes, is the original purpose to one person different from those in the other? Since this amendment has been ruled to not fit under the title, I still want the people of Colorado to know that we need to deal with the core problem of violence, and that core problem is mental health. And until we solve that problem, until we get those people the help and the evaluation they need, it doesn't matter how many gun laws added to the 50,000 that we have nationwide. Criminals will still be criminals. Evil people will still do evil things. And if this isn't about mental health, this is about a gun grab. Ask for your no vote on the bill.
Thank you, Senator Sonnenberg, and thank you for not appealing the ruling of the chair. As we all know, under the rules, that's not allowed. Mr. Minority Leader.
Thank you, Mr. Chairman. I rise in opposition to House Bill 1177 and ask for a no vote. Why? The answer is found first in this Constitution of the United States. Article 6, Section 3, oath to support the Constitution. The senators and representatives before mentioned, that would be United States Congress, and the members of the several legislatures, that would be us, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, that of the United States of America. But no religious test shall ever be required as to the qualification to any office or public trust under the United States. Section 2, just before that, is the Supremacy Clause of the United States Constitution. This Constitution, that of the United States, and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. That means that if we adopt a law that is contrary to this U.S. Constitution, it is nullified. It is unconstitutional. Let's look at what this Constitution grants or identifies in the Bill of Rights. My opposition to this bill starts in the Fourth Amendment. Searches and seizures regulated. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. What is probable cause? According to the website FindLaw, probable cause to search. Probable cause to search exists when facts and circumstances known to the officer provide the basis for a reasonable person to believe that a crime was committed at the place to be searched, or that the evidence of a crime exists at the location. Probable cause to seize property. Probable cause to seize property exists when facts and circumstances known to the officer would lead a reasonable person to believe that the item is contraband, is stolen, or constitutes evidence of a crime. This bill is here before us because of the frustration that some have that there isn't enough evidence to take the person, the citizen, into custody. Why? Because there isn't evidence yet of a crime having been committed. So the proposition under this bill is to violate, in my opinion, the Fourth Amendment and ignore that a crime has not been committed, ignore the standard of probable cause, and to make a person, a citizen of this country, of this state, subject to a search and seizure based on an accusation. The next place that I find opposition to this bill is in the next amendment, Article 5, grand jury, indictment, jeopardy, process of law, taking property for public use. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia,
when in actual service, in a time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Let me repeat that. Nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Sixth Amendment. The rights of the accused. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. This is not about a crime. We're taking property, violating the Fourth Amendment before a crime has been committed. Which district shall have been previously ascertained by law and to be informed of the nature and the cause of the accusation. We have made the point repeatedly that this bill would allow law enforcement to show up at the door of a citizen without any prior notice, without any crime having been committed, and the force of government coming through that door and putting that person, that citizen, at risk of the force of government. To be informed in nature of the cause of the accusation, there is no such information provided before government shows up at the door. To be confronted with the witnesses against him, that is not allowed. The person does not even show up in court. They can file this accusation by phone. To have compulsory process for obtaining witnesses in his favor and to have the assistance of counsel for his defense, this would require a citizen to endure significant legal costs at his or her own expense, to disprove a negative at a higher burden of proof than the accusation was made originally. The 16th Amendment, citizenship defined. Privileges of citizens. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Members, Mr. Chair, House Bill 1177 fails those constitutional tests, in my layperson opinion, on every one of those accounts. Then we turn to the Colorado Constitution, which has to be subject to that U.S. Constitution with the Supremacy Clause. And Article 2, Section 13 says the right of no person to keep and bear arms in defense of his home, person, and property, or in the aid of the civil power when thereto legally summoned shall be called into question. This bill calls that right into question without a crime having been committed. But nothing herein contained shall be construed to justify the practice of carrying concealed weapons, which is another conversation we've had. We have concealed carry. It doesn't prohibit that. It just says this doesn't enable that. But here we have a bill that repeatedly violates the U.S. Constitution and clearly violates the state constitution. The prior amendment ruled out of order, does not fit under the title, sought to correct the many errors in this bill, to reach into the life of a citizen and violate his or her constitutional rights without trial, without a crime being committed, to seize property. That is fundamentally backward. And I appreciate the good senator from Sterling proposing an amendment that would turn that around and say, if there is a person that is causing us concern, if there is a person threatening others, if they are demonstrating mental health issues, that we would reach into the life of that person and try to get him or her help, not take his or her property away. The Fourth Amendment describes the specific, the precise property to be searched for the items for which they are searching. I have heard people justify this bill to say, well, we'll use the firearm registration database to know what firearms might be there. There is no such thing. How do you know? Think, members, think, Mr. Chair, your neighbors. Do you know which of them has a firearm or firearms? Can you describe those items in any detail? Do you know how many? Do you know where they're kept? Do you know that they're kept on that property? This is an accusation, and it is a recipe for disaster, as we have heard from the other state. People, a person at least, has already died through these good intentions. That is why we have a Constitution that identifies your and my constitutional rights as citizens. We come first here, not government. Please do not support this bill and allow government, the force of government, to come through your door or my door or your neighbor's door without due process. Thank you, Mr. Chairman.
Senator Crowder.
Thank you, Mr. Chair. To pin a comment that I like from my esteemed colleague from Colorado Springs, this is outrageous. Do the people of the state of Colorado really know what's going on here? Do we say that we are purple and red and whatnot? Let me say this, the American veteran actually is the one that actually protects and establishes your rights. The over 1 million people that died in this country to give us a Constitution, this, in my opinion, this bill dumps on them. What this does is it places a theory that we as man can come up with a solution to solve a problem that does exist. We cannot. The reality of mental health, evil, it all exists. The gun is a tool. But the Second Amendment should stand. This is a gun grab bill, without a doubt in my mind. But to say that we in the entire state accept that is not correct at all. I will tell you there's been talk up here about how sheriffs support this. Over 26 sheriffs has already come out and created, through their county commissioners, a sanctuary situation. Those are the people that are actually supporting the Constitution. The Attorney General come out this week and said any sheriff who is involved in a sanctuary county that cannot fulfill a court order should resign. I'm making the statement that those are the Americans in this field. Those who cannot support the Second Amendment are the ones that should resign in this state. This has gone far enough. The reality is, ladies and gentlemen from Colorado, the reason we can't get the amendments in is this side knows that there are people going to vote for that, and that's why the restriction of this comes up. But I will tell you that as a veteran of a war, I stand with my veterans. I stand with the 2nd, 4th, 5th, and 14th Amendment of the Constitution of this country, and this is an outrage. Thank you.
Senator Quorum.
Thank you, Mr. Chairman. It's great to have civil discourse, difference of opinion, conversations, and that's what our republic is about. We're talking about guns, and we're talking about an inanimate object. A gun, like any other source of power, can be used for good. It can be used for evil. It is neither in itself. It is solely dependent on who possesses it. The good senator from Sterling, I think, ran, a good amendment, something that I could support. Because I think mental health is the issue that we need to address. You know, I'm about to waste away at 240 pounds. I am rather strong for my age. I can use even a crippled hand if I so desire to commit homicide. That is evil. I hope no one takes my hand away, at least without due process. And I think that's what we're talking about here today. We're talking about due process. This, in the hands of a 240-pound man, is a lethal weapon, should I decide to use that power. I have a Kenworth that runs down the road about weighing 85,000 pounds. Well, I'm a little over that at times, but we won't go into that. But that also is a lethal weapon, should I decide to use it. So we have to decide here in this body is what is common sense. I think common sense is that we have to address mental health issues. You cannot legislate your way out of this. You have to use common sense. And if I decide to do evil on someone I really love, I would not be in a mental case to do that unless something is severely wrong. And I need to be evaluated. I had a friend a few years ago who was going through some problems. Wasn't a danger to anyone other than himself. They took his guns away. Well, they thought they took his guns away because there was one that no one in the family knew about. And he killed himself. If he was in a solid mental state, that would have never happened. But depression took over his life. And he had someone there saying, we need to get you the health you need and make sure that that happened, I believe that he would be alive today. And that's what I want to talk about, is giving those the mental health that they need. I don't believe anybody in a sane mind can go out and take the life of another. But what we know over the years, I think probably the vast majority, if not all, of our mass murders, it's either terrorism or mental health issues. We must address mental health. And to simply say that we're going to take a gun away is not going to solve the problem. I have owned weapons for over 60 years. Frankly, I have weapons stashed everywhere. I don't think there's any way that a court-ordered taking of my weapons could find them all. But to force me into mental evaluations where I can seek the help that I need is the solution to the problem that we are trying to solve here today. I ask for a no vote on this bill as is.
Senator Williams.
Thank you, Mr. Chair, and I rise in support of House Bill 1177, and as I observe everyone with their views, I just want to say that I really, it's an honor to serve here because we are having a civil conversation, and although we have different views on this, and I think that's the great part of serving in the Colorado Senate. And what I want to share with you is some testimony from Judy Amabil, who testified when the bill was in committee. This isn't fake news. We didn't make it up. This is real. This is from a real mother who told her story about why extreme risk protection order is so important. She said, I have an adult son with mental illness. This includes severe depression, substance abuse, mania, and psychotic episodes. He can be aggressive during these psychotic episodes, especially when alcohol is involved. About 2 years ago, he started talking about wanting to get a gun and kill himself. I worried about his safety and for the safety of my entire family. Naively, I called the Colorado Bureau of Investigation and asked to put his name on a list of people who cannot buy guns. The agent I spoke to told me this was not possible unless he was convicted of a felony or a court ordered him to committed to a mental institution. Neither of those things happened, nor have they happened since. At the time, I had access to my son's debit card. I noticed he had a small charge at a gun shop. I called him and asked him what could he purchase for the amount he charged. The man on the phone said it was for a background check. At that point, I told him my son's name. I told him my son wanted to buy a gun and kill himself. He said the background check did not come back instantly, and the gun had not yet been sold. My son's father and I went to the shop. The store owner showed us the handgun that our son had put aside to purchase when the background came back. We cried. We begged him not to sell our son that gun. We thank God that the background check had not come back instantly. He said our son seemed like such a nice man, a young man. And our son is a nice young man, but he also suffers from mental illness, which he cannot control. He agreed not to sell the gun, and he made a note on the background check not to sell the gun. But he did tell us that he had no legal obligation not to sell our son the gun. 2 days later, our son was hospitalized after a standoff with police. He's still alive today, but every day we wonder what would have happened if he had gone to Dick's Sporting Goods or if he had chosen some other place and we hadn't found out about it. Wonder when he might try to buy a gun again. There is absolutely nothing stopping him from making that purchase. And he has tried to kill himself. He has tried to hang himself, and the light fixture gave away. He tried to use pills and was unsuccessful. But a gun that would be fired, sure-fired, and no pun intended method. Every time there is a mass shooting, people say, why didn't the family do something? How could we not have known? Well, often we do not know about our hands are tied. There is nothing we can do. The Extreme Risk Protection Order will give us a tool to stop our loved ones from hurting themselves and hurting other people. I don't kid myself that any of you should care whether my son lives or dies, but please consider that the next time it might be your son or your daughter or your husband or your neighbor who finds him or herself the victim of preventable gun violence. It is well past the time to pass this common sense legislation. It will give families like mine a tool to keep our loved ones safe, even when we have to keep it from themselves. Colleague, this is a real story. This is a real mom. It's a real son. And it could be any of our loved ones. We need to vote yes on House Bill 1177 to protect our loved ones and to help protect those who might have mental illness for the sake of life. Thank you, Mr. Chair.
Senator Foote.
Thank you very much, Mr. Chair. And I wanted to address a little bit about the constitutionality of this bill that's before us. You know, as many of you know, I'm an attorney by training, and I've received, as everybody else, I assume, a lot of emails about this bill. And in those emails that are against the bill, I think they universally say this bill is unconstitutional. So there have been a couple of times that I've responded to those, particularly those that are my constituents, and I asked them, why is it that you think that? As an attorney by training, I always, at the end of every sentence, look for citation to case law or citation to the statute as just a way to show that what somebody's saying is actually shown by the law and backed up by the law. The typical response that I've gotten back is, it's unconstitutional just because it is, without much more backing it up than that. So I would challenge anyone listening to please cite, using case law, using the statute, as to why this is unconstitutional. Let's start with the Second Amendment. And let's start with the claim that the Second Amendment bars this bill. Since 2008, we had, I think everybody will agree, a seminal decision from the U.S. Supreme Court, the Heller case. The opinion written by the late Justice Scalia. And the Heller case said many things, of course, but most relevant to this discussion is that just like any other right under the United States Constitution, the Second Amendment right is not unlimited. There are long-standing exceptions to the Second Amendment possession of firearms that were recognized specifically by Justice Scalia as not being a violation of the Second Amendment. In short, what the justice said was, in the majority opinion, the Second Amendment does not entitle anyone to have access to any weapon at any time for any reason. There are exceptions that he specifically recognized. Weapons in the possession of those that at that time are suffering from mental illness, for example. Those that have felony records was specifically cited by the justice. Since 2008, there have been at least 200 decided opinions on the Second Amendment. Gun advocacy groups have not been very shy about taking cases up to district courts, courts of appeals, and even the U.S. Supreme Court. There have been a couple of decisions since 2008, including 2 decisions on similar laws, extreme risk protection order laws in Indiana and Connecticut. The Connecticut case specifically mentioned that an extreme risk protection order was not a violation of the Second Amendment. The Indiana case specifically mentioned that the extreme risk protection order law that they had in that state was not a violation of constitutional rights. That is the case law that we have available in front of us. And I think has been noted before, this particular extreme risk protection order bill is more narrow than other states, including the Connecticut and the Indiana extreme risk protection order laws, which, by the way, the Indiana one has been on the books for at least 13 years, I think 14 at this point. The Connecticut one's been on the books for at least a half a decade. There have not been any successful constitutional challenges to extreme risk protection order laws, Second Amendment or otherwise, in any state that has this law. So when I say let's have a little backup for that claim, that's what I'm looking for. I'm looking for a court that has considered this, that has come out and said, no, this is actually unconstitutional. Under the Second Amendment, Fourth Amendment, 14th Amendment, Fifth Amendment, or whatever amendment that you want to cite. I haven't seen it, and nobody that I've asked to provide it has provided it. So I don't think it's out there. Now let's move on to the Fourth Amendment. The Fourth Amendment of the U.S. Constitution was read by the minority leader earlier. And I'll cite a couple bits of language from that amendment. First, it prohibits unreasonable searches. Unreasonable searches. And there is a boatload of case law to talk about what's unreasonable and what's reasonable. But one thing is for sure, that a warrant that's issued by the court is much more likely to be considered to be reasonable. It's the warrantless searches that are routinely, although not always, found to be a violation of the Fourth Amendment, with some notable exceptions. In this case, in this bill, like any extreme risk protection order bill, a warrant is required before the firearms can be seized, searched and seized. A warrant is required. That's the case in this bill. That's the case in all the extreme risk protection order bills. Now, as I read through the Fourth Amendment again, it's not long. It says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Colorado equivalent of the Fourth Amendment, Article 2, Section 7, I believe, says essentially the same thing, except it actually requires the petition to the court for a warrant to be written down, which the Fourth Amendment in the U.S. Constitution does not. But when I look at this language, the plain language of this amendment, as the same goes to Article 2, Section 7 of the Colorado Constitution, is that it does not limit it to criminal matters. There's nothing in the plain language that limits this to criminal matters. And indeed, there are warrants executed in civil fashion by agencies like the IRS or the SEC when they're doing civil investigations, not criminal but civil. Of course, those can go into criminal at some point. So, again, looking at the plain language of the Fourth Amendment, it doesn't apply to criminal matters, nor should we read it into only criminal matters. Let's talk a little bit about the due process argument. I find this one particularly interesting because when you look again at this bill and the different processes that are outlined in this bill creates due process. This bill creates a due process for the temporary seizure of firearms. Just like Colorado law creates due process for the taking away of children under certain circumstances. That's what this bill does. It creates due process. And the due process in this bill is high, extraordinarily high. It requires, first of all, a preponderance of evidence to be proven by the petitioner before a temporary extreme risk protection order is granted. And then on top of that, within 14 days, no more than 14 days, it requires the petitioner to establish by a clear and convincing evidence standard that the firearm should remain seized for a period of time up to 364 days. That clear and convincing standard is the same that we have outlined in the Children's Code for the seizing of children. We have it within our ability through the Colorado Legislature to lay out what the specific due process should be. And the due process in this bill is extensive. I hope that over the course of this debate and as it continues, that the people that are concerned about this bill and opponents of this bill will take this into consideration, because I find that it's very easy to say that something is unconstitutional, but in this case, not very easy to actually cite case law and the law that's outlined in our statutes and otherwise to back it up. Thank you, Mr. Chair.
Senator Smallwood. Senator Gardner.
Thank you, Mr. Chair, and I appreciate the erudite comments of my colleague from Lafayette, and I will accept his challenge to talk about the constitutionality of this bill. I first want to comment about this thought about people asserting to us in their emails that it's unconstitutional and that there's no case that says that and so forth. And I don't want to go too far down this road, Mr. Chair. I want to respect the fact that I need to talk to the bill, but I wish to make this point. Yesterday, I think it was, or perhaps the day before, I was speaking about campaign contributions and their constitutionality and their prohibition and so forth. And I had occasion to further research that and to look at the case law and so forth. And I found that 3 members of the United States Supreme Court would hold that any limitation on contributions was unconstitutional, and 3, for all intents and purposes, would uphold almost any limit on contributions, and 3 in the middle would say otherwise. And enough on that, but my point is that the United States Supreme Court and our state Supreme Court on state constitutional issues are right because they're last, not last because they're right. And so when our constituents assert to us that something is unconstitutional and they are not attorneys, I think they are asserting their firmly held belief as Americans that something is, in their view, prohibited by the Constitution. And we, as elected officials and as a separate and independent branch of government, are bound by our oaths to support the Constitution of the United States and the state of Colorado. And so this assertion that something is unconstitutional may, in their view, be a plea to us that we ought to ourselves read the Constitution and believe and hold as a legislative matter that something is unconstitutional. I think one of the mistakes, I hesitate to say mistake, but one of the refinements of my views as I came to the General Assembly well over a decade ago was to not think as in the context of being a representative or a senator, not think in the context of what I might do in front of the the Colorado Court of Appeals or the state Supreme Court across the street, or even across the other street and across the park, what I might do in the trial court, but to think in the context of my oath as a legislator to my constituents and their understanding of the Constitution, because their understanding of the Constitution, while it might not comport with the majority holding of the United States Supreme Court, it might well comport with the holding of a dissenting opinion. And, you know, I only need point to 19th century decisions of the United States Supreme Court on issues of people as property and separate being equal, which have been disavowed, overturned, and held in disrepute, and properly so, to say that just because the United States Supreme Court fails to see and understand something does not make it, in the minds of citizens and the public, constitutional. It just means it's a holding of the law. So I don't think the purpose is to denigrate the opinions and views and understandings of our constituents, but when I read those, I hear what they're saying. Now, I have said to my constituents, I don't think that your focus on the Second Amendment here is exactly the right one. I understand why, because this is about firearms, and the Second Amendment is the right to keep and bear arms. I think this is first and foremost a case about property. Because what this red flag order and bill allows is for the state to come and take my property. To come and take my property from me because they consider my property dangerous and they consider me dangerous. I mean, isn't that, in lay terms, exactly what this bill says is someone can go to the court, swear out an affidavit, make it sound pretty credible by preponderance of the evidence, and a judge, a state actor, will say, law enforcement, go to Bob Gardner's house. Someone he had a close relationship with, someone that lived in his home in the past, says that he owns firearms and that he said really bad, threatening things, and there's this underlying justification to come and take my property because that particular property is considered dangerous. It's not a bill to take my knives. It's not a bill to take my sticks. Not a bill to take my car. It's to take my guns. And so I understand why the Second Amendment, but I have tended to analyze it as a bill in taking of property. Now, as to the constitutionality and the constitutional problems, I look over to my left to our friends of the Fourth Estate, and I ask you to listen closely. I ask those of you to my right, I'm disappointed to see some are not here in the chamber, but I hope you will hear or listen to this on channel 165, as it will be at a speed of less than 300 words per minute.
Senator Gardner, don't forget about the chair. The chair is listening intently. Senator Gardner.
Thank you, Mr. Chair. my friends, and I ask for the attention of the press because I'm going to make a prediction here, and I would like my prediction recorded because I want it recorded in a way that a decade from now, when this happens, when this becomes commonplace, and when there's a court case about it, that someone will, I hate to say that might be a bit of a vanity on my part, but that someone will say, well, the senator from El Paso County warned about this, and this is what I'm going to warn you about. Since this bill allows local police and sheriff's departments the independent power to seek orders, these ERPOs, without the request of any family member. If you take a good look, doesn't require a family member. In fact, if law enforcement asks for this order, it has a certain credibility that a family member wouldn't have. And if they can be the petitioning authority, there's no particular context for why they have to or could ask for these orders. In fact, local law enforcement could simply, without notice to any citizen, someone of color, a minority, or just any citizen at all who is a problem to them, they could, by affidavit, say, Bob Gardner poses a significant risk of causing personal injury to himself or others because he said wild and crazy things in the well of the Senate. Oh, maybe I'm protected by the speech and debate clause, maybe I'm not. And he said he owned a firearm. And he's behaved so erratically this week, he's not been using his inside voice. He's behaved like a crazy man. And he owns a firearm. And I really worry about him, says law enforcement, because they're concerned for me. He's really behaving erratically this week. And so he might pose a significant risk of causing personal injury to self or others. Now, I love my colleagues, so don't be concerned. But others might think so. So they would enter a temporary extreme risk protection order against me. And while they're doing it, you say, well, that'll never be sustained, because you can't sustain a clear and convincing evidence based on that. But if law enforcement made this affidavit, it has a certain cachet to it that it wouldn't have of one of my family members or something, who I could say, well, they just want to get to my para-retirement or something. But what can law enforcement do? Well, the bill says, it doesn't even give an option. The bill says, if the petitioner is a law enforcement officer or agency, the officer or agency shall concurrently file a sworn affidavit for a search warrant pursuant to Section 16.3.3015 to search for any firearms in the possession or control of the respondent at a location or locations to be named in the warrant. You say, well, my colleague from Lafayette County says, we have probable cause warrants all the time. Fourth Amendment talks about probable cause and reasonable searches, and warrants on probable cause are far more likely to be found reasonable because they're done by a magistrate in a court. So I was reading through here and I said, well, what's section 16.3.3015? And I was just going through the bill the first time and I clicked over on my computer and I won't use the proprietary name of the database we use, to find 16.3.3015 and it's not there. And I thought, oh, 16.3.3015 is a new section created by this bill. It's a new statutory probable cause warrant. So we're not using our existing warrant authorities and statute here in Colorado. We're creating a new one. You say, well, why are we creating a new one? Well, we're creating a new one because all the others have to do with crimes, suspicion of crimes, or contraband, or, something that somebody's already done. This is a new thing. Any court may issue a search warrant to search for and take custody of any firearm in the possession of a named respondent in an ERPO or a temporary extreme risk protection order if the application for the warrant complies with all the required provisions of section 16.3.303 and also provides facts sufficient to establish by probable cause what? That the named person is a named respondent in an extreme risk protection order or temporary order. And the named person is in possession of one or more firearms, and the location of such firearms, and any other information relied upon by the applicant. So you say, well, really, Bob, because you can call me Bob when we're not down here in the well. Really, Bob, what's the big deal? I mean, we have a temporary extreme risk protection order about firearms, and this person has said something that causes the judge to think that they might be a risk. Well, I think when law enforcement figures out that they can use this against any young gang member, it might be a really good tool. Because if you run in a certain crowd saying things that are pretty threatening is probably your general language. And the fact that you probably own a firearm is maybe so. You say, well, that's all good. Bob, what's your problem? Well, once you have a legal search, once you have a search by probable cause, once you can conduct that search, once law enforcement can go in, you can ask my colleague from Lafayette County, you can ask my friend the sheriff. Once they can conduct that search, there's something, I don't know what they called it when my younger friend from Lafayette County went to law school, but when I struggled through twice, they called it the elephant in the matchbox rule. Once you can search, I can search anywhere and everywhere. I can't search for an elephant in a matchbox, but I can search for a firearm in a home anywhere it might be. Cabinets, closets, under the floor, in the ceiling. I can search your house if you're the subject of one of these orders. I can pretty much search your house top to bottom. And oh, by the way, if I find any other evidence of a crime while I'm at it, of any other crime whatsoever, that evidence is admissible in court. So, while they're searching for my weapon, if they find heavens, Heavens, I think of all the things that I dare not say they might find at my home, but they won't find a body. But a hypothetical person, they might find a tax return. While they're looking in the drawer, they might find a tax return that has some credit for a firearm or something that's you know, they might find some record. They might find some other contraband. Now, you could say, as law enforcement often does, they say, well, you know, I was there legally. I was conducting a legal search. I found evidence of another unrelated crime. What am I supposed to do? I found the evidence of the crime. Well, I mean, that is the United States Supreme Court holding, and I believe it is good law. But every time I see the ability of law enforcement to conduct a further search in someone's home, an extension of what constitutes probable cause, an extension of probable cause not for a crime, but probable cause for property that is legal, otherwise legal, I ask myself, has the power of government, have we as a legislature extended the power of government in a way that violates the Fourth Amendment of the Constitution? I think this case runs like this at the United States Supreme Court. Respondent committed no crime. Respondent is alleged to have made threatening statements. Respondent was subject, on preponderance of the evidence, to a temporary extreme risk protection order. Law enforcement swore out an affidavit for a warrant on probable cause that they would find those weapons in respondent's home. They executed their search pursuant to this probable cause warrant. Not probable cause that the respondent committed a crime, not probable cause that respondent was in possession of illegal property, drugs, stolen money. Respondent was in possession of property which he or she had a legal right to possess. And by the way, what if respondent handed his guns over to his brother-in-law and said, you know, I don't want them in the house. I think, you know, it's the other brother-in-law, because he says, I think my ex-wife wants to get a protection order against me because we got in a big argument and I said she was going to be sorry. And she always hated the fact that I owned guns. So would you come and get them, or I'll bring them over to you. So they do their warrant and they go in and they don't even find the firearms. But they find his stash of marijuana. Oh, that's legal in Colorado. Well, they find he's running an unlicensed grow operation, and the United States Attorney thinks that that's probably not okay. And now, this person is charged with a crime on a probable cause warrant. I think that person and their attorney, if he or she is halfway worth their salt, files a motion to suppress, asserts their Fourth Amendment rights and the correlative rights under the Colorado Constitution, and says you had no probable cause to believe that I'd committed any crime or that I possessed any contraband at all, and that evidence should not be admissible because that search was not pursuant to the kind of probable cause the Fourth Amendment talks about. You know, I don't know how many of you are avid moviegoers are fans of pop culture, but not so long ago there was a movie, ironically entitled Minority Report. And the premise of the movie was this, that we had advanced in our technology to the point that we could predict whether or not the senators from El Paso County or the senator from Lafayette or the senator from Douglas County might commit a crime in the future. And if you might commit a crime in the future, you could be arrested. You could be detained for your own good. This is a little like that. It's a little like that sci-fi proposition because these extreme risk protection orders, apparently they're of only one sort. You can't have them for mental health. You can only have extreme risk protection orders to take people's property. They're given because we suspect or we believe or we just fear that you might do something in the future. Well, I believe this bill is well-intentioned. I do. Colleagues, those of you who come down here and implore us, I say to the senator from Denver in her lovely purple sweater today, I say to her, I know it is well-intentioned. I wore a blue tie in honor of the election, as opposed to my red Trump tie. I do, seriously, believe that this bill is well-intentioned. But the problem is this. If we can make our society perfectly secure. I can tell you about some societies in this world that are far more secure than ours. Civil rights and liberties hardly exist in those societies. The presumption is that everyone's going to commit a crime against the state. And because that's the presumption, and because there isn't a protection for life, liberty, and property, the state imposes without limitation, without notice, ex parte, orders to confiscate all sorts of things. Cell phones and automobiles, various substances, many of which are legal, but in your hands they might be dangerous. Members, setting aside whether or not this is constitutional or unconstitutional, it is a question of balancing liberty against security. I contend to you, and we will talk more this afternoon, that this bill will not improve security in the way that its sponsors assert, and it will do so at the cost of the liberty of our citizens on presumptions with limited, even no notice, resulting in searches of homes, invasions by people in your home at 6:30 in the morning with guns, they don't come without them, who may decide that you're such a risk that they don't need to knock. My friends of the Fourth Estate, please write about this risk. That the minority said to the citizens of Colorado today that one of the reasons, a principal reason that we oppose this bill is because of the risk that it creates for the safety, security, and civil liberties of the people of Colorado. We are mindful, we are cognizant, and we care as much as our friends on the other side of the aisle about safety and security and the risk of firearms in the hands of those who should not have them. Many of us have taken steps in the case of a family member or someone to ensure that those are not available to them. But to invoke the power of the state on no notice and creating the right for agents of the state to break down your door in the early hours of the morning, to look for firearms, and oh, by the way, anything else that we might find that would be an evidence of a crime, it'll just be permitted as evidence in court. That is a sacrifice of our civil liberties that we do not believe is a good trade for what this bill will actually do. We urge a no vote.
Is there further comment on some of Tom Cruise's finer cinematic work? Or House Bill 1177? Senator Court.
Thank you, Mr. Chair. While I completely respect the concerns about property, I'm concerned about saving lives. I just saw this headline. Gun deaths of school-aged children in the United States, school-aged children, have increased at an alarming rate with 38,942 fatalities among 5 to 18-year-olds from 1999 to 2017, according to a new study by Florida Atlantic University Schmidt College of Medicine. Folks, this bill is about saving lives by taking firearms out of the hands of people who are endangering to themselves or others. Period. End of discussion. That is all this is about, saving lives. And I see that my colleague from Colorado Springs is reminding me to use my inside voice, as I always remind him to do. So I will bring back my inside voice and remind everyone this is about saving lives. I care more about life, quite frankly, than I do about property. I care about children's lives. I care about adults' lives. I care about the lives of people who have firearms, who might be a danger to themselves or others. I encourage you to consider this headline: 38,942 fatalities among 5 to 18-year-olds. This is an epidemic of gun violence in our country. We have got to protect people who are in danger to themselves or others. We must pass this bill. Thank you.
Senator Pedersen.
Thank you, Mr. Chair, and thank you to my colleague from Colorado Springs for bringing up the loss of property. Up to 14 days that you might be without a weapon for somebody who is at risk, proven to be at risk to themselves or others. I'd like to remind us about the real loss that this bill is focused on. The people that have lost, who have had the ultimate cost, who have lost a loved one, the people who are sitting in this balcony who have testified to share their tragic stories of their loved ones that they will never see again. To advocate for stronger laws and giving a tool for us to actually take away their weapons. I want to especially acknowledge my constituent Dane Doherty, who is with us today. And I'd like to read her testimony about her experience with the real loss that this bill is focused on. 6 years I have been coming down to the Capitol for 6 years to honor the promise I made to my sister Mary and to try and save lives. This does not get easier. In fact, it gets harder. My reason for supporting this bill is very personal. My sister Mary was the courageous school psychologist that charged towards a disturbed young man armed with an AR-15 assault rifle and 2 handguns that he brought from his home. He should have never had access to these weapons. My sister was running a meeting when she and a school principal heard the shooter blast his way through the front entrance. Mary tried to intervene and protect her kids. Knowing my sister, I think she thought she could either talk the shooter down or take him down. At close range, 5 bullets struck Mary. 2 were catastrophic. Mary and the principal did not survive. Together, they died on the lobby floor. 20 first graders and 4 other educators were also shot and killed that horrific day. As a family member of gun violence victim, you think about all of the what ifs. What if the shooter did not have access to these guns? What if the guns had been locked up? What if there was a way for my family member to have had the guns legally removed from the home before this crisis? What if all those lives could have been saved? What if my sister didn't have to act as a first responder, as a psychologist? Here in Colorado in 2013, after the Aurora Theater and Sandy Hook mass shootings, laws were passed that have saved lives, but there is still much more work to be done. As a law, IRPA will give Colorado families a tool to temporarily remove a gun from someone showing signs of being a danger to themselves or others and prohibiting future purchases for the duration of the order. This bill can prevent mass shootings, domestic violence, street violence, suicides, and protect our law enforcement. People who use firearms to harm themselves or others often show clear warning signs before doing so. This is the time for intervention. Temporarily removing the gun from someone in crisis will save lives. It's that simple. If you are a responsible gun owner of sound mind and no malice towards another's life, this bill will not affect you or your guns. We owe it to our communities to do everything we can to prevent future tragedies. My sister Mary was incredibly brave. She gave her life that morning. You, as our elected leaders, have the power to protect and save lives. Today, you need to be brave like my sister Mary and vote yes on the Zachary Parrish III Violence Protection Act. It is the right thing to do for Colorado. Be brave. Thank you, Jane, for being with us today, and thank you for your courage in reminding us about the true loss that this bill is about.
Senator Smallwood.
Thank you, Mr. Chair. Colleagues, thank you for engaging in this debate. I rise in opposition of House Bill 1177, not because I disagree with the intent that I think we all have. We all want to be safe. We want to be safe in our neighborhoods. We want to be safe in our schools. But to me, especially knowing that the very common sense amendment that the senator from Eastern Colorado presented that was defeated, I'm not sure that we agree in the best way to keep our families and our neighbors safe. I I keep hearing that this is not a gun grab, but as the Supreme Court Justice so famously said in the 60s, I know it when I see it. We're talking about taking people's guns. To me, that's a gun grab. We're not talking about taking people's knives or their machetes or their bomb-making equipment or their vehicles. We're talking about taking their guns. And I feel strongly that this situation can be improved, but it can be improved by focusing on the individual that needs help, and to assume that we can go into a person's residence not knowing how many firearms they have and assume that we can find them all is ambitious at best. It'd be one thing, Mr. Chair, colleagues, it'd be one thing if we knew for sure how many guns this person had. We've got to go in and we've got to find one gun. We've got to find 4 guns. We've got to find 11 guns, and you check them all off. And now, okay, now we know we've got all the guns. But that's not the case. And as the senator from Montrose courageously stated, so I will echo it, if you came to my house, you would not find all of my guns. You just wouldn't. So to assume that we can do that, I just don't think is realistic. And I'm very, very worried, colleague, that in taking 3 of the 5 guns or 7 of the 8 guns and leaving that individual in that same state of mind is extremely dangerous to our communities. I think it's extremely dangerous to law enforcement. It's extremely dangerous to the neighbors. We've seen it. We've seen what happens when people with mental or psychological disorders go through a traumatic experience like that and then are left in their residence with whatever weapons are still available to them. And I just feel strongly, colleagues, that a person intent on harming somebody is going to find alternative solutions. Maybe you're successful in taking their guns away. So the issue isn't guns any longer. But we remember Columbine. There were 2 propane bombs in that school. There were gasoline bombs in the perpetrators' cars. They'll resort, in my opinion, to other solutions. And I think the same is true also in suicides. We keep hearing how this bill is going to reduce suicides. You all know, especially in the female population, firearms aren't the #1 choice of suicide methods for females. It's poisoning, it's pills. For men, yes, it's firearms. But do we really think that somebody intent on harming themselves, you show up and you take their guns away, that they're all of a sudden going to say the next day, without any treatment, without any counseling, without any therapy, are just going to say, well, my guns are now gone, so now I guess I'm not going to attempt suicide after all. We really don't think that absent the guns, they're not going to resort to a different method. There's already more suicides happening when you combine strangulation, hanging, and poisoning pills together. There's already more suicides using those methods. I just don't think it's realistic for us, colleagues, to think that by taking their firearms away, we've now saved their life. What we need to do is get them help. That's what we need to do. And I would gladly support that amendment. But to get laser focused on firearms as if it is somehow magic and it's going to change people's behavior and they're not going to want to harm other people anymore and they're not going to want to harm themselves anymore does not make any sense to me. Very recently, colleagues, you probably heard, in October of 2017, someone in a rental truck in New York rented a truck in New Jersey, drove into New York, and started running over people on a bike path. 8 people killed, 7 people injured. In Nice, well, in Berlin, December of 2016, vehicle was used, a country that I spent a lot of my formative years in, country with very strong gun control laws. 12 people killed, 56 people injured with a vehicle. In Nice, July of 2016, listen to these numbers. 86 people killed, 458 people injured with a vehicle. So what happens, colleagues, when we go in and we confiscate somebody's firearms and we leave them with their truck or with their car? And now they're infuriated and now they're agitated. How do we know we're not going to see a repeat of something like this? Why aren't we focusing on the individual? Time and time again, all of this evidence that shows that, yes, firearms are important. I'm not taking anything away from you with that. I fully understand it. But it's one part of the problem. It is not the entire problem. So if we really want to do what's right, if we really want to make a difference, if we really want to keep our schools safe, and we really want to keep our neighborhoods safe, why in the world are we not focusing on the individual? Why are we focusing on one of many weapons that they have at their disposal that have all been proven here in this country and abroad to be extremely effective in killing large numbers of people? Why are we ignoring those? We heard that the bar is set really high for this bill. I'm not naive enough, despite some of my colleagues' opinions, to think that this bill won't pass, and apparently it's not going to pass with any amendments on it. We've heard that the bar is set really high, and I am not a lawyer. I don't understand burden of proof the way some of the great minds in this chamber can. But as I read the bill and we talk about preponderance of evidence being the starting point to which to step in and take action, when there are other burdens that are higher. If we want to set the bar high, and we're going to say that we're going to set the bar high, why aren't we starting with something like clear and convincing evidence? If that's what it takes to get your firearms back after you've been proven that this was all either incorrect or worse, colleagues, malicious or false, why don't we have the same standard set? If we're going to announce that we've set the bar high, then let's set the bar high, or at least be honest with the state. Again, to the constituents in my district in Douglas County, and my colleague from Douglas County has already touched on the points that we hear from our constituents about the constitutionality of this. It's not up to me to determine what's constitutional and what's not, although I would absolutely agree with the senator from Douglas County on his points. What I will tell you is that I know a gun grab when I see it. When we're ignoring all of these other factors and focusing on guns, to me it feels like a gun grab. I know to you it feels like a gun grab. Your emails and phone calls and letters have not gone unheard. I wish that I could do more other than ask for a no vote on 1177. Thank you, Mr. Chair.
Senator Danielson.
Thank you, Mr. Chair. Of all the people who are demanding that we step forward and pass some very common sense gun safety legislation, what's moved me a lot in the last year has been the young people across the country who have done just that. They've come to us time and time again, and it's an impressive thing to see teenagers speaking with such passion about an issue that impacts so many people. To be inspired by young people banding together to come forward to make change is an inspiring thing. And some of what they have said to me has deeply resonated. I'm inspired by them. I am saddened that they have to come forward and do this, because basically what they're saying is, we are tired of the adults not protecting us. They are tired of adults not protecting them. And so they have to come to our nation's capital. They have to come to the state's capital to plead with us to pass something as common sense as this gun safety measure. I applaud them and their efforts, and I assured them when they visited with me that there are some of us who are listening intently. Part of what struck me is that most of us, I think I would say all of us in this chamber serving as members of the state Senate, have not had to endure the daily tasks that they have to endure just to go to school or to go to their jobs, to do what they need to do on a daily basis, because we are not members of what they have to call the active shooter drill generation. The active shooter drill generation. Do you not regret that that's where our kids live? Some of us in the chamber remember the drills from earlier about getting under your desk, for nuclear war threat. It was a little bit theoretical, I think, back then, but this is a daily reminder of the danger that these kids are in. And it's not just the day that they have to go through the drill. It takes a toll, because now they've been going through this for years on end. These kids came to talk to me about what it has done to their lives. And some of them all of 13, 14, 17 years old. The impact on their mental health is real and tangible and is a problem. And they're dealing, because they're very strong, extraordinarily strong young people. But what they described to me, I am ashamed that we're putting our kids through this now, because we haven't yet taken a step forward like this measure. It is time for us to step forward and protect our kids. It is overdue. Now, my daughter is going to be 2 in June. If she is still part of the active shooter drill generation when she's in high school, I don't know how any one of us can look ourselves in the mirror. And so I would like to read from the testimony of the committee, where a young person came forward to tell the story in her own words. The following is taken from the testimony of Maren Struther during committee. I am here as a member of the active shooter drill generation. I am here because lockdown drills are the new normal. I am here because I learned how to silently hide in the corner behind the locked door in the same classroom where I learned how to read and write. I'm here because when my brother got his first job at AMC Theaters, he quickly had to learn active shooter protocol. I am thankful I have never personally been through the terror of a shooting, but I will tell you that not a day goes by without some level of fear that today could be the day. A year and 1 week ago today, 14 kids in Parkland, Florida, were killed before their lives truly began, before they got to go to college, before they had the opportunity to get a job or have families of their own. That day, I cried all the way home from school. I cried because I was scared, and I cried because I felt helpless. And those feelings still exist below the surface every day. But today, I also feel hopeful. Hopeful that Colorado will be the next state to pass the red flag bill. I am not naive enough to think that this bill alone would solve our gun violence problem, but it is a step in the right direction. I truly believe that if this law saves even one life by allowing law enforcement to intervene in someone's worst moment of crisis, it is completely worth it. We will never know, but if this law had been in place at another time, maybe 12 people would have left that Aurora movie theater and gone home to their families and friends. Maybe 20 kids from Sandy Hook Elementary School would start high school, and 14 kids from Parkland may have lived to graduate. That is why I am here to ask for your yes vote on House Bill 1177. Thank you. I don't think any of us could have said it better. They have shown us extraordinary courage. They've exposed how difficult it is to attend school because of the constant threat. They have begged us to take action. They have pleaded with us to do something, to finally do something to protect the youth in our community. And that is only part of why I rise in support of House Bill 1177. Only part of the reason that I support this measure, to protect the kids in the communities that we represent. We owe it to them. Thank you, Mr. Chair.
Senator Marble.
Thank you so much, Mr. Chair, and thank you, colleagues. Thank you to everyone who is listening in. House Bill 1177, I want to be sure everybody knows the correct number of counties who have come out against this bill, and it's up to 32. And many more are considering this act. And then there's others who are waiting for the final language after this bill passes. When we look at the dangers of this bill isn't like all other ERPO bills or red flag bills that have been adopted around the country. It's a little bit different. And that's why those 32 counties have come out criticizing the dangerous and very concerning language. If you look at how it was testified to in committee that the accused will be picked up in a coffee shop or on the street, that's not protocol for every law enforcement agency. In fact, it's very, very much not like what happened in Maryland. In 1177, they are creating a new type of search warrant. And this search warrant is specific to gun owners only. It's a civil search warrant. I had a friend look around the United States at all the other bills that had passed for red flag laws to see if other states had this language in it. And to date, she's come up empty-handed. There isn't any. That's why people find this so alarming. It is true that almost anyone can request an ERPO without even showing their face or providing their address. A simple phone call. They don't even have to be in the state of Colorado. The definition of family or household member, ex-lovers, how about somebody who just states they had an affair with you? They can do it, and they will do it. If people just told the truth, we wouldn't have problems like this, and we probably would have a lot less people in our jails. There are some other things about this bill that are very alarming to the people across the state, and I'm going to read you off some that they have put out, and they find it very, very alarming, very dangerous, very concerning. The initial report and hearing can be done over the phone, all while the accused is completely oblivious that proceedings are taking place to have his or her firearms confiscated. The first time the accused learns someone has reported them will be when law enforcement shows up at their door with an order and a search warrant prepared to raid their home. All this when the accused has never committed any crime. 14 days later, this is really something that bothered attorneys who testified in committee against this bill, is that 14 days after that raid is the first time the accused will have a chance to defend themselves against this non-crime. The attorneys who are testifying goes, we don't have enough time to get our defense, our appropriate defense for the accused. We need more time. And of course, with more time, here's somebody who has not been accused of a crime, is spending a substantial amount of money waiting to see the verdict from the courts that involves no crime. There is zero accountability for false accusers. This was huge in committee. The filing fee is $0, and compare this to a temporary restraining order. A filing fee in Colorado is $97. The bill is being touted as a suicide prevention bill when in fact the fear of having your firearms confiscated will make people terrified to ask for help when they really need it. Suicide was a huge component of the testimony in committee. Let's shoot back to one of the people who testified, stating that in Connecticut, where they do have a red flag bill, suicides didn't drop, but suicides by gun did. And there were people who testified to the fact that of different ways that their family members, friends, had decided to commit suicide instead of by firearm. One was jumping in front of oncoming traffic, semis, trucks. It was a brother of one of the people who testified, and it was a horrific scene. I don't think there's anyone here who is immune from knowing anybody who has committed suicide, my family included. It leaves you empty. It leaves you angry, feeling guilty for why did this happen? Why couldn't I have done something? Just like my son's friend who, they got a call. She didn't have a mean bone in her body, but decided that today was the day she was going to end her life. Got in the bathtub and began to cut herself. Her parents found her. It was devastating. We loved that young girl. Nothing could have stopped her suicide. But we all grieve, and we all feel the guilt. We could all go on and on about those stories, the horrific ways that people, if they want to do it, they are going to do it. And this bill does not in any way address the mental health and the ways that we can help those people. There's not a word in there about that, but a lot about how much they're going to take the guns. We had other people testifying about their stalkers or their abusers and how those abusers had called in reports that they had done something violent or evil or wrong, and they hadn't. So in this next point is made that this bill is so rife for abuse. It can easily be used by someone's stalker or abuser to have their victim disarmed legally. It works both ways, folks. The ERPO will go on a person's permanent record even if this case is dismissed, meaning that this is going to show up on their background check forever. It will be on their federal record. They will never be able to buy a gun again, so even if they are found to be fine, they're going to have to deal with a lifetime of clearing their name and getting their life back to normal. In talking to the law enforcement who had come down to testify against 1177, they made it very clear that if people didn't lie, we really wouldn't be having these problems. But it's unfortunate that it seems to be a human trait that we just can't legislate and make better. We see people who are easily triggered by just things they see on the street. They don't seem to be able to prioritize normal occurrences in their lives, but somebody's going to pay if they get angry about seeing something they don't like or hearing something they don't like. Things really have changed in our culture, and I can't say that it's changed for the better, because this bill is going to devastate and hurt a lot of innocent people. We heard the stories in testimony in committee. We've heard things said on the floor today. But this is not about mental health. This is not about stopping suicide. It's just stopping people from using a gun to do it, and it's not giving any aid to those people who so desperately need the mental health. And it was said in committee, this isn't about mental health. This is about taking guns. Nothing could be more clear and more dangerous sounding to the communities within the state who are honest, law-abiding gun owners, family members, workers, business owners. This takes people under a microscope just because somebody made a phone call. That's not justice. That's not right. And this needs to be stopped.
Senator Cook.
Thank you, Mr. Chair. I want to get back to just the law enforcement thing for just a moment. We heard that how much law enforcement supports this. Well, I've got a resolution here by the Western State Sheriff's Association, which is 16 states from North Dakota to South Dakota, Texas, and everything west of Colorado, to include California. And I'm not going to read the whole resolution, but there's just two paragraphs that I want to talk about because they're talking about the red flag bills. And it just says, whereas one method being proposed to identify said individuals is often referred to as a process to red flag individuals who are deemed to be at risk to themselves or to public safety and to secure an order to confiscate all of their firearms. And whereas the membership of the Western State Sheriff's Association believes this would be logistically impossible to carry out, and likely would be a violation of the Second, Fourth Amendments as well as the Due Process Clause of the Fifth Amendment of the Constitution. So once again, law enforcement does not support this bill. We also heard how, from one sheriff during testimony, that, well, they'll just wait. It's not going to be an issue of safety. We'll just wait till the person steps outside, and then we'll just go in and confiscate his weapons, or take care of him, and everything will be okay. Well, I also heard the good senator from Lakewood say, these are the professionals who have been doing it 30 years. Well, I too have been doing it for 30 years, and that's not how it works. The situation usually determines how law enforcement responds, not the other way around. What if the person that comes outside is carrying a firearm concealed? The situation is going to determine a whole different response from law enforcement. Also heard the good senator from Lakewood say, well, they're not going to come and kick in the door. What if they have to? What if the person doesn't come out? They're going to have to kick in the door. The situations determine it. It determines how we respond in law enforcement. And these things have a huge potential of going badly very quickly. Also heard that this bill gives law enforcement the tools that they need. Well, they already have the tools that they need. The good senator from Aurora held up the book, and I too had the book, and she's right. Here is all the stuff on behavioral health. And they have the tools. They don't need this, because let me tell you what the standard is for taking somebody into custody for a mental health code. 2765-106, court-ordered evaluation for persons with mental health disorders. Any person alleged to have a mental health disorder and as a result of mental health disorder to be a danger to others or to himself or herself. And that's what this bill talks about. I can nearly drop my jaw when I heard that this bill wasn't about mental health issues, because this talks about being a danger to yourself or others. That's what this bill is about. That's what the mental health issue is about. That's how law enforcement can take people against their will and get them committed. Emergency commitments, 2782-107, talks about law enforcement taking somebody in against their will if they're having a mental health crisis. So if this bill is not about mental health, then it's purely about gun confiscation. If this bill allows for legalized government theft of people's firearms. That's what this bill is about. We just had a title ruling on an amendment. I think we need a title ruling on the bill, because what this bill says is that it's about extreme risks. The text of the bill says the opposite, though. Rather than addressing extreme risk, the bill mandates confiscation based on a finding of significant risk. Not extreme risk, but significant risk. Maybe a law about significant risk would be a good idea, but it would garner less public support than a bill about extreme risk. The extreme risk bill titles and public relations campaign deliberately deceives the public, because if we called it a significant risk bill, the public would probably not support it, because they probably don't understand it. Now, I do want to kind of go over some of this bill, and I heard it's not a can of worms, but I must disagree with the good senator from Aurora. Recently, there was a bill passed in Rhode Island. Now, I'm not going to talk about the Rhode Island bill. I'm going to talk about this bill. But the ACLU did write a letter, a 16-page brief, basically, about the Rhode Island bill. And the two bills virtually mirror each other. There's a few little differences. So I'm going to talk about what the ACLU said regarding the Rhode Island bill, but it also applies to the Colorado bill. This is what the ACLU, that right-wing conservative organization that gets funded by the Koch brothers, had to say. I cannot argue with the goal. They don't want to do that. They cannot argue about the goal of this bill, but they do have concerns about the breadth of the legislation, its impact on civil liberties, and the precedent it sets for the use of coercive measures against individuals not because they are alleged to have committed any crime, but because someone believes they might someday commit a crime. Before going through the bill in detail, they are emphasizing that the legislation to allow courts to intervene in potentially major and intrusive ways on a person's liberty and property interests without any indication, much less suggestion that the person has engaged in any criminal conduct, or even that he or she may do so imminently. In that regard, the bill places judges in an inevitable, indeed impossible position of trying to predict who may and may not become a mass murderer. Psychiatry and the medical sciences have not succeeded in this realm, and there is no basis for believing courts will do any better. The result will be likely a significant impact on the rights of many innocent individuals in the hope of preventing tragedies. So let's go to specifically the bill. Page 5. The ACLU wrote that there are a number of points to be made about the standard for this bill. First, it makes no attempt to define what constitutes a significant danger. And that's in our bill right here on page 5, lines 10 through 16. But on line 12, it says the respondent proposes a significant risk of causing personal injury to self or others. Doesn't define what significant risk is or significant danger, nor does it impose of any sort of temporal limitation on the anticipated danger, in contrast to a separate provision in the bill authorizing ex parte orders when the danger is imminent. Nor does the potential harm even need to be a threat of serious personal injury. Any type of possible injury will suffice to trigger a red flag bill. Any possible threat of any small little injury. Indeed, the way the bill is worded, one does not even have to claim that the feared injury is likely to be caused by a firearm, only that the person's possession of one creates a significant danger of inflicting some type of injury. I believe the good senator from Colorado Springs talked about how this could impact minorities, people of color. And I'll read from what the ACLU feels. One can easily imagine the bill's petitioning authority being used in scenarios far outside the context that has prompted it. For example, almost by definition, individuals targeted by police as gang members, who, it is worth noting, are most often people of color, would fit the statute's standards of potentially significant danger or injury to self or others by having in their custody a firearm. What is to stop the police from using this law to file petitions against them in order to seize any lawfully owned firearm they have? Filing or being granted such a petition has additional bonus of serving as a general search warrant that could conveniently allow police to stumble across evidence of unrelated illegal activity, because the bill allows police officers granted a red flag to conduct any search permitted by law. Similarly, the increased practice of law enforcement trolling on social media for harmful or threatening posts could vastly increase the use of the bill like this against innocent people who engage in overblown political rhetoric. Let's go to page 9 of the bill. A second major concern with the legislation involves a wide range of criteria and the judge given to consider in deciding whether to issue an EPO. They don't object to the lengthy list, but we do question the weight of some of the factors may be given and the lack of prioritization. And what they're talking is about what the judge has to consider by ordering a red flag bill. For example, it seems that the granting of an ERPO should be premised on allegations of recent acts of violence or threats of violence by the respondent. But that is not required. Under this bill, the judge can consider those factors which one would presume exist, but they do not need to be present or even critical consideration in issuing the ERPO. And, they're talking about in this bill things like drug use can be used, Alcohol abuse can be used for a reason. You don't have to have any of the personal threats. You can have, if you abuse alcohol, you can get a temporary restraining order, a red flag bill. Now, if that's the case, the other night, I probably would have been served with one. But yeah, well, it was a rough day the next day. You know, guns in Weld County, it's in our DNA in rural Colorado. I have members in my county, I have constituents that have gun safes. Some of them have 2, 3, 4 gun safes, and they all have 25, 30 guns. Law enforcement's supposed to come in and take them? What if the guy doesn't give them up? How are they going to take the gun safes away? How are they going to store them? It's just totally impractical. Page 13 and 14 of the bill. Another disconcerting aspect of the court's power under the bill is that in addition to confiscating any firearms, the judge can order a mental health or substance abuse evaluation, presumably against the respondent, will and upon contempt of court if he or she fails to comply. That's on page 13 and 14 of this bill, and they have issues with that. They have issues with the length of the red flag bill. Page 18 of the bill. After a year has passed, the burden is on the respondent to prove by clear and convincing evidence that he or she is no longer a danger. How does one prove this negative? The ACLU is asking a valid question. How does one prove this negative? And how does one do it with such a high burden of proof? He or she can't even necessarily rely on the fact that they have committed no violence in a year, since it's a catch-22 response from the state, that they can say that it's only because the ERPO was in effect that the respondent did not engage in violent behavior. So how are they going to prove this negative? The burden should be on the petitioner to prove by clear and convincing evidence that it should remain in effect, not on the respondent to halt its continued imposition. The bill establishes a separate, though related time, compressed ex parte procedure for imminent threats, and that is where we believe the focus of any legislation effort should be. Again, back on page 9, the ACO wrote, the petitioner is authorized to omit his or her address in the petition. That's in our bill. If the petitioner feels that they're in danger, they can have their address withheld. That disclosure of the address would risk harm to the petitioner or family member. We believe that a court should make an independent determination about that rather than rely solely on the petitioner's statement. Like impaneling anonymous juries, the mere fact that the address is withheld seems to lead more credence to the allegation, rightly or wrongly. Page 27. ERPOs are entered into police databases. That's true. That's part of our bill. They're entered into a police database. And they're supposed to be removed once the restraining order gets taken out. The problem is they're not taken out of the judicial records. They're still in the judicial files of the court. This is what they have to say about that. ERPOs are entered into police databases, and the bill makes provisions for removing the information once an ERPO is terminated. However, ERPOs are also entered into public judicial databases, but there does not appear to be a comparable requirement for removing terminated ERPOs from that system. A publicly accessible record showing that a person once had their gun rights taken away based on being an extreme risk could erect barriers for them for decades, where they undergo a background check for employment or housing and could end up just being harmful as if they had actually been convicted of a violent felony. Again, colleagues, this bill is ill-conceived. I thought it had everything to do with mental health, but a good amendment was shot down. And if it's not about mental health, like I heard today, then it's only about one thing, and that's gun confiscation. So I would ask for a no vote on this bill, please.
Senator Fields.
Thank you, Mr. Chair. I believe it was the good senator from Fort Collins that said that this bill is going to cause a lot of harm. That's not the purpose of the bill, to cause a lot of harm. What I'd like to do is to stick to the facts about what this bill is all about. This bill is designed to reduce gun violence by providing a tool for families and law enforcement to remove a firearm from a home where there is an elevated level of risk or danger to themselves or others. Basically, what we're trying to do is to try to prevent homicide or suicide. It's not about creating harm. There are currently 14 states that currently have extreme risk laws on the books. And you heard my colleague from Boulder indicate there's no case law that has documented that anyone's constitutional rights were violated. This House Bill 1177 doesn't harm. It's designed to save lives. How does it do so? Because we know that in a home where there's abuse and a gun is involved, statistics will show that there's going to be a homicide related to some kind of domestic violence abuse. I'm reading here a statistics that says 4.5 million American women alive today report that they have been threatened with a gun by an intimate partner. You heard the senator from Weld County mentioned in the bill on page 5 about really not having a clear definition about significant risk. That's not clearly defined. But if you're in a relationship where domestic violence exists, or you have a loved one, a child, or someone that's dealing with some kind of behavioral issues, you understand significant risk when you see it. Law enforcement evaluates significant risk every day. When I worked at the airport, we would ask customers and travelers to notify law enforcement when they saw a risk about to happen. That's not an unfamiliar term. We see danger when we know it. This bill is about saving lives. And we know that far too often, guns are used in mass shootings. I'm just going to highlight recent ones. Because in many of those situations, their behavioral risks were identified, but maybe it wasn't shared with law enforcement. Let's start with Las Vegas. October the 1st, 2017. A gunman opened fire on a crowd of more than 22,000 concert goers. This was in Las Vegas, killing 58 people and injuring 500. July 7th, 2016. This is in Dallas. A military veteran ambushed and conducted a sniper event, killing 8 people. June 12th, 2016, Orlando, Florida. A gunman goes into this nightclub, kills 50 people. California, December the 2nd, 2015. A gunman goes in and kills a dozen people, leaving at least 14 dead and 17 wounded. Colorado Springs, November the 27th, 2015. 3 people were killed and 9 were wounded with an assault rifle at a Planned Parenthood clinic. October the 1st, 2015, in Oregon, a community college. At least 10 people were shot dead. The gunman died in an exchange of firearms exchange with the police. Tennessee, July 16th. 4 Marines and a petty officer were killed after a man opened fire at 2 military locations. Charleston, South Carolina, June 17th. 9 people were shot dead at a historic Black church. They were having a prayer meeting. The ages ranged from 26 to 87. The gunman was a white supremacist. There's so many. There's so many mass shootings, and what they all have in common appears to be an assault rifle or a weapon. October the 24th, 2014, 4 people died after a 15-year-old student opened fire in his high school cafeteria. I need to get it cleaned out. Excuse me, Mr. Chair and members. This is difficult because these people were innocent. And when you have a family member that is at risk of harming themselves or other people, you want the authority to assist. We heard the senator from Weld County talk about law enforcement don't need this tool. But there's been many, many stakeholders, and I have a list of law enforcement groups that support this. But yet there is a sense of some law enforcement saying they won't carry out the request of the bill if it passes. And we heard in committee by the Attorney General that said if they did that, they would be in contempt of court. They would have to go to court and file a petition, and then if the court came back, the judge comes back with a decision, then they would have to honor the court's ruling. Because if they don't honor the court's ruling, then they really can't serve in that role, because they're supposed to serve and protect and follow the laws, and they just can't pick and choose. And I think I heard the Attorney General say if they don't want to enforce the law, then maybe they need to resign if the judge rules that it is constitutional and it meets all the merits and the elements of the law. We also heard testimony about some people using all kinds of other forms of suicide. I think someone mentioned that females, women, might choose prescription drugs. But I have some statistics that says here that the #1 method for committing suicide is with a firearm. It's 52%. These are the organizations that support this bill. Colorado Gun Owners for Safety, Golden Action for Public Safety, Giffords, Hunters Against Gun Violence, March for Our Lives, Moms Demand Action, Colorado Parent Teacher Association, Blue Rising, Brady Campaign in the Center to Prevent Gun Violence, Colorado Ceasefire, Legislative Action, Colorado Communities of Faith, United to End Gun Violence. It's my understanding as well, the bill is supported by the Douglas County Sheriff, the Police of Chiefs Association, and as you know, this bill is named after a falling officer. So let's get back to the facts. What this bill will do. A law enforcement officer or a family member will request a court to issue an extreme risk protection order based on the facts they present through a formal written application and a hearing before a judge. It's not as simple as what you're hearing, that someone out of state is just going to make a phone call and just have this false claim. That's not how this is going to happen. This is a very legal, procedural process. It's a formal process. So this hysteria that you're hearing about, that anybody can file any kind of claim, that's just not the case. It's based on facts. It has to be presented in a formal way, in a written application, and it's heard before a judge. At that initial hearing, the judge will consider the information, he will assess the information, and he will determine if the person is at risk of harming himself or others. So this sense that someone's going to knock on your door and grab your property and take your gun safes out of your house, it doesn't work that way. We need to keep to the facts. The merit of this bill. People are watching and hearing what we're saying, and I'm really concerned about the message that we're saying about this bill. The judge may issue, after he assesses the situation, a temporary emergency ERPO for up to 14 days. The court shall appoint a council member to represent the person during this hearing. Fair process. If a family or household member or law enforcement officer establish a clear and convincing evidence that the person poses a significant risk to self or others by having a firearm in his or her custody or possession, then the ERPO can be permitted and it can be processed. But only after all of those things have been done. It's legal, it's formal, it's an application, and just like judges sit on the bench all day long when they're in our courts 5 days a week, the same process will be carried through with this as well. The court can continue the hearing if the court cannot issue any order temporary removal of the gun, or they can surrender that firearm. So those are the facts of the bill. And I haven't even gone through all the other shootings. There was just one in New Zealand. I understand 50 people were murdered there. And their government were able to implement common sense gun safety measures within 1 week. And after Sandy Hook, when you have third graders just going to school, just trying to learn how to read and write, there still hasn't been justice for them. Let's talk about this city, this state. We all know that there was a Columbine shooting. We also know that on July 20th of 2012, at a theater, a gunman goes into the theater and he wounded 70 people. So members, let's stick to the facts. It is not true that this bill will cause a lot of harm. It is not true that this bill is just a can of worms. This bill is designed to keep our neighbors, our community, our families, our schools, everything that we believe is sacred, to be safe. So I urge an aye vote, a yes vote, on House Bill 1177.
Senator Pedersen.
Thank you, Mr. Chair. And just to follow up from my colleague from Weld County, just want to clarify a few things here. As you know, this is civil and not criminal, and so this is not going to come up in a background check. And part of the committee report from the State Affairs Committee was ensuring that there was not a record that stays within NICS, that this would actually go away once the ERPO is removed. And so this is not going to come up when somebody is looking for employment in the future. This is not the same as actually committing crimes. I think that this is really important. That is on page 28, lines 3 through 11. And when it comes to imminent danger, you're right. There is a statute that has a very high standard to have somebody involuntarily committed. I actually know what that process looks like because I had to go through it with my mom. I can tell you that the barrier was significant to get my mom the help that she needed and to ensure that she was actually not released into the situation that she was at. There is one person in the state of Colorado, his name's Matt. I got to know him really well. He is in charge of all of the involuntary commitments in the state of Colorado. It is completely insufficient, it is underfunded, and it is not supported. But I am incredibly grateful for this statute because it saved my mom's life. But I can tell you that this piece of this statute is not actually the answer for what we're looking for here. We need to have immediate action for people who show significant signs that they are at risk of harming themselves or others. That cannot be the same as what I went through with my mom, because I can tell you that it took a very long time. I had to go through significant hoops, and I'm lucky that my mom is still alive today. So for somebody that has had to utilize this process, there is an absolute need for a different piece of law to address a much different issue. I know that we are going to continue to talk about this at length, but I want to go back to where this all began for me. I said earlier I was in 10th grade. It's been so long, I forgot I was actually in 11th grade when Columbine happened. And I want you to remember when Columbine happened in Colorado, it was a shock around the world. I remember going out of the country that summer, and there wasn't one person who didn't read about what happened here in Colorado. Now it is common that we see this in Colorado, we see this throughout the United States, we see this throughout the world. And we're here to actually bring common sense, a common sense measure that is a small step forward in ensuring that we are protecting our communities. I'm just incredibly grateful for all of the people who have been a part of this process, all the organizations throughout the years, and also want to be on record thanking Representative Garnett for his work over the last couple of years, and Representative Sullivan as well. They put in hundreds of hours of stakeholder meetings, as well as Senator Court, who carried it last year. This has been an extensive amount of work to ensure that we are walking that fine line. So thank you for the work that you did to get us up to this point. I'm so proud of this bill.
Senator Woodward.
Thank you, Mr. Chair. Colleagues, this debate has provided me with some clarity on this issue. When the sponsor said that this bill is not about mental health, that was new to me. That's not what I had heard as I watched the bill make its way through the House. When the senator from Sterling said this bill is about grabbing guns, it became ever more clear to me that that is in fact what this bill is about. In fact, maybe we should just strike all the language about mental health and stop stop beating around the bush and just say we would like to take guns and we'll worry about the consequences later. We don't even provide any help to the people who are accused of mental health problems. My sheriff and I find it ironic that this bill is even referred to as the Deputy Zachary Parrish Violence Prevention Act. Sheriffs around the state have overwhelmingly told us that more law enforcement officers will die as a result of being forced to go and take people's guns. I do appreciate the senator from Arapahoe County, and I think it's a laudable goal that both sides of the aisle in this House say when their goal is to prevent gun violence. We have a knee-jerk reaction, we want to do something. However, there's a problem, and that's none of us can predict the future. So the only thing that we can do as we try to take action and try to prevent gun violence is guess. Guess who's going to be the violent person, guess which guns are going to be used, hope that we can find them. At a minimum, lots of legal guns will be taken away from law-abiding innocent people. At worst, law enforcement will attempt to take guns and be met with violence. The accused will become more violent with the same accuser after his guns are taken. False accusations will leave victims defenseless, and we will have chipped away at our rights of due process. In the end, I have no doubt that this bill will be declared unconstitutional. So that's my only solace as I go home today. I rise in opposition to House Bill 1177.
Senator Heisey?
Thank you, Mr. Chair. You know, I have a letter here from the Chaffey County Board of Commissioners and their sheriff, and for those of you that aren't aware, there's one commissioner there of my party, so when he's in a meeting, he's more badly outnumbered than I am here today. Dear state senators, this is just to give you the local perspective, and this came in yesterday afternoon, long before this debate started. So this is what they have gleaned from reading the bill. Dear state senators, the Chaffey County Sheriff and Board of County Commissioners appreciates the public safety intent behind 1177, extreme risk protection orders. But we have serious reservations about the bill as written. We have 4 areas of concern: legal issues, fiscal issues, lack of emphasis on mental health, and impacts to law enforcement. Legal issues. 1, the standard of proof. The admission of hearsay evidence is a lower standard than used in criminal law, and this lower threshold will facilitate the filing of false or malicious complaints. Weak bill language on the prosecution of malicious complaints encourages corruption of the process and will lead to falsely accused citizens ultimately becoming the victims. 2, due process. The respondent receives less civil recourse than those actually accused of a crime. There is no initial cross-examination of the complainant as the respondent is not present at the first hearing. The warrant can be executed without the respondent's knowledge or an opportunity to respond to the allegations. The ERPO is approved by a single judge who may or may not have any familiarity or training pertaining to mental health. There is no provision for dissolution of the order at the request of the petitioner. 3 would be permanent records. In this digital age, the very filing of a request for an ERPO will become part of an individual's record, whether the claim is found to have merit or not. This, coupled with the broad investigative and search and seizure provisions, creates a high likelihood of damage to a respondent's reputation. Due to the sensitive nature of these types of proceedings, the bill does not classify whether ERPO court records are protected court documents. Additionally, it is unclear whether Colorado's expungement statutes would allow a respondent to expunge a temporary ERPO and any associated legal proceedings from the respondent's record. Moving on to fiscal issues, 1 would be implementation. There is no adequate funding associated with this bill for implementation at the county level or for training of local law enforcement. 2, legal representation. Since the ERPOs are treated as a civil matter, legal counsel for law enforcement is provided by the county attorney. Small rural counties lack large legal departments and have not selected attorneys for expertise in mental health, search warrants, or criminal-type actions. Such counties will have to hire or retain additional specialized counsel. 3 would be the lawsuits. Due to the legal issues above, one can anticipate civil lawsuits against local law enforcement and would suggest language not imposing civil or criminal liability on any government entity who in good faith enforces any provision of this bill. This represents significant exposure for smaller counties. Storage. There is no funding for secure storage or confiscated or surrendered firearms. 5 would be mental health cost. There is no funding for mental health evaluation of respondents or for cost of commitment. There is no funding for designation of mental health beds in local facilities or for increasing capacity to accommodate mental health commitments. Moving on to the lack of emphasis in mental health. The bill fails to adequately address the underlying fundamental problems of mental illness. 2, the bill does not require a dual assessment of the respondent by a mental health professional unless the emergency commitment statute states. It does not provide standards for respondent assessment regarding disposition of firearms. 3, if whatever subjective threshold the ERPO for an ERPO is met, there is no accompanying order from the judge initiating any sort of continuum of care for the respondent. Impacts to law enforcement. 1, the aggressive protocols described in this bill will inhibit honesty in mental health investigations from both the respondent and family household members. 2, the perceived low standard of proof, lack of due process, and broad search and seizure authority will create an adversarial situation that will be more likely to escalate to violence. The attempt to forestall mental health-driven violence will actually increase its likelihood. 3, by forcing law enforcement into this form of intervention, hostility toward law enforcement will increase. This is contrary to the public health and welfare and will manifest in unfortunate ways throughout the community. All 4 of us are extremely concerned about the mental health in Colorado and Chaffee County, and we acknowledge that mental health issues is a significant contributor to gun violence in our communities. However, this bill, as written, has serious deficiencies that undermine its intent and will likely, at the risk of judicial review and/or lawsuits. We urge the legislature to slow down and take the time needed to develop an approach that addresses these deficiencies, to put more funding towards supporting rural mental health, and to propose solutions that work for all of Colorado. Sincerely, signed, Commissioners Greg Felt, Keith Baker, Rusty Granzola, and Chaffee County Sheriff Joe Speasy. This is from a county that did not declare themselves a sanctuary county. This is from a county that has concerns. They know it's going to have impacts, and they know they don't have the resources to deal with it. I would urge a no vote on 1177.
Further discussion? Senator Donovan.
Thank you, Mr. Chair. Sorry, had much more thoughtful, longer remarks to add to the discussion, which I would like to come back up to the mic and add, but considering Chaffee is my district, I've also talked to all those commissioners and the sheriff. They are not opposed to the bill. So I think the letter certainly flags concerns, which I'm working with them, and also has some misinformation as well, which I'm working with them. But they do not oppose the bill. So we appreciate the letter immensely. We appreciate the investment they've made in taking time and hosting town halls up there. At this point, they're not interested in pursuing sanctuary status. They don't think that's the right approach. And again, at this time, and they do not anticipate taking a position of opposing the bill. Thank you.
Senator Rankin.
Well, thank you, Mr. Chair. I'd like to just talk a few minutes, as I often do, about some of the differences between rural Colorado and perhaps perceptions of my colleagues from the Front Range. You know, as you probably know, I represent a big swath of rural Colorado, pretty much from the Continental Divide to Utah and north of I-70, and with the exception of the area that my colleague from Eagle County represents. So, you know, I tend to try to listen to my constituents and talk about what they're worried about. And, you know, I think it's true, and we have to pause and think about the fact that not everybody sees this bill the same way, and that we should, as statewide legislators, we should always be sensitive to the views of all of our folks. And I know we're outnumbered. I often repeat that. I talked about it on other bills as well. But the people of my district are really quite concerned about this bill. And I'd put it in the terms of, you know, we often pass bills here, and we don't really think about what I would call unintended consequences. How many times have we come back a year later, 2 years later, 20 years later, talking about Gallagher, Tabor, to try to correct mistakes or things that aren't working very well? So I've been sort of collecting inputs from my constituents that say, what are the unintended consequences? Sure, there may be some very good intentions behind the bill, and I actually won't argue with that. I've heard some very passionate arguments for good effects. But what about the unintended consequences? So I've been sort of collecting a list of those, and on behalf of my constituents and what they're worried about, and they're terrified. They do believe that this violates their constitutional rights. They do believe that it endangers them. But they also have given me some very specific inputs. First of all, the danger issue. Many of the people who I represent believe that their guns protect them, that they're not a danger to them. It doesn't really matter what we believe. They believe that their gun is their protection. I've had letters from an abused spouse whose husband was actually imprisoned, recently released. She believes that her gun is her protection. Are we going to allow some, and there's an issue with that family. The family of the abusive husband is also lined up with him. What if her gun is taken away from her? She loses her protection. So danger has two sides. Many of my constituents believe that their gun is their protection from danger. My constituents are concerned about confrontations that will occur. So we're sending our law enforcement folks out there to do perhaps a no-knock search and seizure. I'll tell you, some of my folks are not going to take kindly to that. I mean, some of them feel so strongly about their Second Amendment rights that they absolutely believe that this will create more rather than less confrontations between law enforcement and citizens who feel strongly about their rights. Those confrontations will lead to criminal actions against my constituents. So now we have court cost criminal activity that has been generated by the attempt to go seize a weapon from one of these folks who thinks that it's their protection. That's what they think is going to happen. They think this stigmatizes them. Only gun owners will be subjected to search and seizure of a gun, so that immediately puts them in a category which divides them, which essentially creates them as a subclass of people who are guilty by association, they believe. They think they're going to be high error rates. In Connecticut, where only law enforcement can institute one of these searches or seizures, 32% error rate. 32% of those attempts to seize weapons are errors, which will perhaps lead to confrontations and criminal actions or mistakes. What happens if somebody confronts the police? And, do we take credit for the fact that they were there to seize a gun that might not have even existed? They think that my constituents, and I believe this will be considered an alternative to emergency mental health care. Maybe somebody needs mental health treatment, but instead we seize their guns. Does that make sense? I don't think so. The other thing that we worry about is different judges will be making will this be consistently applied across the state? Will some situations occur in a seizure and a non-return of a gun where others may not? What's the criteria? We don't believe that there's good criteria laid down. So in summary, I just want to say, and I haven't talked as long as some of my more verbose and articulate colleagues, and I apologize for that, not explaining my points in the great detail you would prefer me to do so, but different people have different feelings about this. We're likely to really alienate about half our population with this bill, and is it worth it? Have we proven that the gains in safety and that you've talked about so passionately, are they worth it? Are they worth causing this kind of division? They're certainly not in my district. I don't know about yours. So I would just encourage us all to think about those folks that might think differently. Is this bill really for all the citizens of Colorado? Or is it one of those bills written that apply in the city and not to my constituents who have lived with guns? Some of these folks have been homesteaders for 5 generations. You know, guns hang on the wall. They carry them every day. So is this fair to them? Is this fair to all of our citizens? Is it perceived the same by all of our citizens? Some of these amendments that have been offered would in fact assure my citizens that they are actually being considered as well. Thank you.
Senator Gonzalez.
Thank you, Mr. Chair. I rise in support of House Bill 1177. I was in high school when Columbine took place, and so I'm here to read the testimony of Ms. Jessica Price, who testified during the committee hearing. I'm a 3rd-generation resident of Aurora, Colorado. I'm also a high school teacher. I'm currently wrapping up my 20th year as an educator. As a teacher, I can tell you from my own experience that this bill has the potential to save lives. Let me tell you why. Last year, at the beginning of 2nd semester, I had a new student in my class. He made a decision that he did not like me for a reason that I don't think he was ever able to fully explain. Within the first few days of class, he was writing things in his assignments that made me wonder if he might be dangerous to himself and others. So I immediately reported it to both his dean and counselor. They both agreed that his writing was something that needed to be addressed. We called a meeting with him and his mom, where we were able to show her the writing and discuss our concerns. During that meeting, his mom told us that her son had displayed concerning behavior at home as well. She told us that one time he pulled a loaded gun on her when he was angry. And another time he pulled a loaded gun on a group of middle school students who he thought were being too loud on their way home from school. She told us that after these 2 incidents, she removed all of the guns from their home and got him into therapy. Also, during this meeting, which had taken a turn none of us were really expecting, she looked me in the eyes twice and said, "I understand why you are scared, because I would be scared if I were you too." As a school, we were able to remove the student from my class, and we are doing our best to watch him carefully as he is still a student in our building. However, he's graduating this year and is soon going to turn 18 and live on his own. At that point, he'll be likely able to purchase his own firearms, and I am fairly certain that he will. Without House Bill 1177, his family will not be able to remove those firearms, even if they believe he is still a danger to himself or others. So where does that leave me? Next year, and for the next 10 years after that, I'll still be teaching. I will likely still be in the same school and the same classroom I was when I was his teacher. This puts me and all of the other teachers and students in my school in possible danger. If this young man is displaying this dangerous behavior again, his mom will not have any legal right to ask that his firearms be removed. This means that for the rest of my career, I will be scared. I will be scared that he will decide to come after me and my students. I will be scared that I will not be able to see my own 3 young children grow up. I will be scared for my students because what if they are in danger now simply because this young man has access to firearms, even if his own mother thinks that he may be a danger to himself or to others. I shouldn't have to be scared when I go to work. I shouldn't have to worry that this young man will maintain access to firearms, even when most Coloradans agree that he shouldn't if he displays dangerous behavior again. One last thing before I finish. One of the classes I teach is high school government, so I know the system. I know that some of you will not even consider voting for this bill, regardless of how many of these types of stories you hear or how many of your constituents support the bill. I know how politics work. I know why you'll vote the way you will. What I'm asking is that if this young man does come back to my high school and kills me or any of my students, can I count on you to come and explain your vote to my children, to my students, to the families of my students? I bet you won't be able to explain it very well.
The question before us is the adoption of 11. Just want to make sure folks are paying attention. Minority Leader.
Thank you, Mr. Chairman. Bills are words and numbers. Words and numbers on paper or now electronic form. And very often when we receive advocacy for or against bills from folks outside the Capitol, they have very important, valued perspectives on those bills, but sometimes those perspectives have very little to do with the words and numbers that make up that bill. Much of the debate today for or against 1177, I think, has not dealt with the words and numbers of this bill. This bill, House Bill 1177, is not what you want it to be, or it isn't what maybe we don't want it to be. It is purely what the collection of words and numbers on paper in these bill folders that are proposed to go into those burgundy colored books back there, the Colorado Revised Statutes. So whether you like it, feel good about it, or you don't like it and you feel bad about it, all that matters is what that collection of words and numbers on paper actually says. Is this bill purely about a family member voicing concern about another family member who might cause harm? No, it is not. Unfortunately, this bill, those actual words and numbers that are on paper that are House Bill 1177, this bill is about enabling a process by which virtually anyone can accuse anyone else, whether or not he or she is a gun owner, whether or not he or she actually has a firearm. But this is a government-endorsed process, if this bill becomes law, for virtually anyone to accuse virtually anyone else and have almost or quite possibly no proof other than the accusation. This bill isn't about temporarily removing firearms from someone. It is, and I know there is stark disagreement about that, but this is about gun confiscation. This is about taking property away from people who may have committed no crime, may be innocent of what they are accused, who would then be in the position of spending significant amount of money, if they have it, to disprove a negative. Could this bill save a life? I suppose it could. Will this bill ruin lives? I believe it will. Those who support the bill, who have contacted us,
very often express desires for a safer world. I understand those desires. I understand those motivations. I don't deny them. But when we look at this collection of words and numbers on paper, that is not what this bill, what this potential law would do. Again, this is a scenario that government would create where people could accuse other people, that government shows up at a door unannounced, that a person has no idea why law enforcement is at their door, and may respond in a defensive posture. That puts law enforcement and that person and anyone else in the home at greater risk. There are law enforcement officers who have expressed concern about this bill because it isn't about what you want it to be, it's only about what these words and numbers say it is. And these words and numbers on paper mean that more law enforcement potentially would be at doors, unannounced, trying to calm someone in a very stressful situation in order to take his or her property away, without charging him or her with a crime. Trying to differentiate what is his or her property from property owned by someone else who might live in the same residence. This bill isn't what you want it to be, members. It's what those words say it is, and we should not do this. We should uphold the U.S. and the Colorado Constitution. We should focus on helping those who need help the most. We could talk about from law enforcement and attorneys who have more experience in it than I, but what are the conditions that we need to change or address that might enable us to take a person into custody to get the mental health or the counseling or the timeout or whatever it might be to temper whatever situation might exist. But that's not what this bill does. This bill creates a scenario where people can accuse other people and implement the force of government. This bill is more about tyranny than helping, and I ask for a no vote on House Bill 1177.
Senator Janal.
Thank you, Mr. Chair. The American College of Physicians recommend that this is a public health approach to firearms and to related violence and the prevention of injuries and deaths. It really is a public health crisis. And I wanted to read to you some testimony from a doctor from Fort Logan, Dr. David Iverson, from a committee meeting. He states, "Each week I work with suicidal people and the loved ones of those who had taken their lives. I work with victims of mass shootings, including Columbine and Aurora, trying to help them find ways to survive the pain. I've worked with murderers, both after and before their crimes. People contemplating suicide are almost always ambivalent. The vast majority of those who have attempted suicide and survive regret it and are thankful someone intervenes and helps them. And those who contemplate murder or mass murder put out warning signs. And this bill gives us the chance to act before they do. In our epidemic of gun violence, those of us in healthcare can take certain actions under the law, as has been discussed extensively today. But it's too little under the same grand scheme. Criminal justice can act, but it is often too late. And once the law has already been broken, lives have been lost. So we have either too little or too late. These ERPO laws give us the chance to give a specific, well-timed intervention in actual emergencies, as it is happening. That is an incredibly important, helpful step. It's estimated for every 10 guns held under emergency, a life is saved. And there's even feedback from some responding, saying, I needed this. Someone should have stopped me. Essentially giving thanks for that intervention. So these laws allow for really a cooling off period. Parents in Newtown encountered the well-meaning people who said, I can't imagine, by saying, you must imagine. We must imagine losing a child, losing a spouse to gun violence, something that is preventable. In my field, denial is a dangerous sentiment. We all think it can't happen here, to me, to my loved ones, until it does. And it will continue unless we act. As Dr. Iverson, I ask that you support House Bill 1177.
Senator Todd.
Thank you, Mr. Chair. And I received an email this afternoon from the Women's Lobby supporting House Bill 1177. But before I read this, I want to also want to share from my own personal response to listening to so many people share today, that the genuine care and concern for the health and safety of our children and our families is evident. We all come at it from a little different perspective, and I'm always so appreciative when several of our rural legislators continue to remind us to keep in mind things are different. Things are treated and responded to in a different manner. So as I was kind of sitting back there listening and trying to think a little bit about, so is this an all-encompassing bill that is going to basically threaten or change the lives of people on a daily basis? And I came to the conclusion, no. I don't believe it is. I don't believe it's going to be something that people have to fear, that people have to say, this is going to change my way of life. It's going to take away something that I have and that I cherish, and that is the freedom to own a gun, to keep a gun in my home, in my car, wherever. I don't believe this bill is about taking away. What it is about is helping families know how to react and respond when they fear for their children and their children's environment. I'm reminded of a good friend of mine who is well over 90. He no longer lives in Aurora. He's moved to the Gunnison area with his daughter. He's now lost his sight, but he's a good old staunch Navy veteran, and unfortunately had a situation where both his wife suffered from Alzheimer's and his son suffered from schizophrenia. His son actually went in and bought a gun. And when he realized that his son had this gun, he was so panicked because he thought my son could have been that shooter in the Aurora Theater. It could have been my son. And he said, I didn't know what to do. So he said, I took his gun and I took it back to the store, and I said to the store manager, do you know you sold this gun to a mentally ill individual? He wasn't angry. He just simply was saying, help me. I don't want this in our home. I don't want him to be subjected to having it around, and his erratic behavior was not trustworthy. All he wanted was to figure out a way, and he said, nothing in the law, nothing gave me the tools to know how to deal with that. And so he said, I just did the best thing I could and said, I'm going to return it. He's not an anti-gun person, but he knew the risk of his son having that and having access to it, and he didn't know what else to do. So again, as I share this letter from the Women's Lobby of Colorado, I want us to remember that unless we are facing or we are seeing people that need additional help and need to have a weapon removed from them temporarily, to give them the extra support. And I agree 100% with everything that has been said today about the urgency of increasing mental health support for so many in our society. But to take a step back, Zach Parrish didn't get that shot. He didn't get that chance. But they knew and they were aware of the potential of that volatile situation for a very long time. So with that, I will go ahead and just read again for it to go into the records from the Women's Lobby of Colorado. It's a 25-year-old organization that advocates for women and their priorities at the Colorado State Capitol. Representing 25-member organization and over 150 individual members, our aim is to advance gender equity and public policy. As long supporters of legislation and excuse me, as long supporters of legislation that makes women and their families safe, we strongly support House Bill 19-1177, Extreme Risk Protection Orders, and urge the committee, all of us in the legislature, to pass this crucial bill. According to the scientific literature, U.S. children face a substantial risk of exposure to firearm injury and death. Women who are in abusive or violent situations also face risks from gun violence. It is clear that gun violence is a critical issue in our communities, and here before us is a window of opportunity to address that epidemic through clear, strategic, and carefully crafted legislation such as House Bill 1177. Simply put, House Bill 1177 would help keep women and their families safe through temporary extreme risk protection orders. The Women Lobby of Colorado support House Bill 1177, extreme risk protection orders, and we urge the committee to join us in supporting it. Sincerely, Anna Crawford, Board Vice Chair and Policy Chair on behalf of Women's Lobby of Colorado. Again, this is not a takeaway, it is a help. It is a support for those who need it the most, and those who are current gun owners should not fear, but should stand strong in aiding and giving support to those who need the help the most, and for us to stand strong. Again, care and concern for the state of Colorado and for our citizens should always be our top priority, and looking at it as a give of support as opposed to a takeaway is why I am supporting House Bill 1177. Thank you, Mr. Chair.
Senator Hill. Senator Lee.
Thank you, Mr. Chair. And I'd like to add my thanks to Senator Hill and some of my colleagues on this side of the aisle who have expanded the debate into a very robust one to bring in a lot of issues. Many of these issues were discussed last year in the red flag bill, but I think we do our best work when we work collaboratively and we talk these issues, particularly these complex and difficult issues, through thoroughly and robustly. This bill is a measured and moderate step towards addressing one part of a significant problem. The issue of gun violence has been explored and discussed by a lot of my colleagues during the course of the day, and I don't need to go into that further. What I would like to emphasize, however, is the point that was raised by many regarding mental health. Mental health is a significant issue, but rules of the legislature, protocols of the legislature prevent us from incorporating all of that into one bill. So we're dealing in this bill with a preemptive strike to prevent gun violence. This file contains several hundred pages of bills that are going to be coming forth next week, Monday or Tuesday, to deal with the mental health issues in Colorado. So be prepared. Our legislature is going to be looking at issues of how we deal with people that are at risk of going into jail because of mental health problems. We can't deal with that here, but we're going to deal with that in this legislative session. We have bipartisan support for these bills, and I look forward to a robust debate on how we are going to address the mental health issues. What we need to do, obviously, is provide services for people. This bill deals with preventing the emergency that occurs when people are suffering from trauma and when people are suffering emotional breakdowns. What we really need is Plan B, services, community centers where people can go, and that's what these bills are all about. So I urge you to think today that this is not a one bill solution to the problem. It's a multiple complex solution, and this is the other part of it. I look forward to engaging you next week on some of these other issues. The I think extent of the mental health issues that gave rise to this bill and hopefully could be addressed in the future by this bill are brought forth in the testimony of Karen Asensio, the mother of Elena Asensio, who testified in the committee. I'd like to take the liberty of reading to you her testimony. This is the mother's statement. On January 30th of 2017, I received a phone call from school. My daughter's close friend, Emma, had been killed. She was 10 years old. She had been killed by her own mother, 2 bullets to the right temple. She laid in her blood all night until her father found her in the morning. Her mother had committed suicide. Telling my daughter that she will never see her friend again, telling her that she died at the hands of her own mother, telling her that death was violent. I wanted to protect her from this horror. I knew she would have nightmares. I knew she would be scared. I knew she would have a painful grieving process ahead of her. I could not protect her innocence because she would learn the truth from others, so I had to tell her myself, and there are no parenting books to tell you how to do that. The kids were playing outside on their bikes. I walked out and paused for a second to give them a last moment of peace. As I told my daughter, what had happened, the inevitable flow of tears, her body shaking, her face torn by sorrow, the intense pain taking over her entire body. I rocked her on my lap like a baby for a while, absorbing her pain, holding her tight. There was nothing I could do to make this right. Her heart, her soul, her innocence was broken. It's been 2 years now, she testified, since this has happened. She has been diagnosed with PTSD, and she struggles with sleeping. She lives in a world where children can be killed by their mothers. She does not feel safe. Emma's life could have been saved by ERPO. When a person is in crisis, loved ones and law enforcement are often the first ones to see the signs that they pose a threat. Her mother was depressed and in a crisis, but without an emergency extreme risk protective order, nothing could be done. It is too late for Emma, but it is not too late for the next victim. Between 2013 and 2017, half of all suicide deaths were carried out with a gun. I would note parenthetically that yes, deaths are carried out by automobiles, by pills, by other methods, but nothing is as effective as a gun or as final as a gun. Killing over 2,700 Coloradans last year by guns. ERPO is designed to save lives. How many lives will it save? We will never know, but it will save lives, and that's why it matters. It will save, I'm reading the testimony, Republican lives. It will save Democrat lives. It will save veterans' lives. It will save law enforcement lives, mothers' lives, children's lives. Evidence shows that this law can help prevent firearm suicides. In the 10 years after Indiana passed its red flag law, the state's firearm suicide rate decreased by 7.5%. In fact, access to firearms, meaning personal or household gun ownership, increased the risk of suicide by 3 times. That's why reducing suicide persons' access to guns will help to save their lives. This is not about the Second Amendment. This is not about partisan politics. The author of the bill has taken steps to ensure due process, including providing counsel to respondents. I'm urging you to look beyond the misinformation to show the integrity and vote to save lives that your constituents' lives. Emma was a happy girl. Her laugh was contagious. She cared about her friends. She wanted to be a marine biologist. She was passionate about saving turtles. Her life mattered. She will be 10 years old forever. Please vote on this bill for Emma. Thank you. Again, from Karen Asensio. And this is her daughter's testimony on that same day during committee. We didn't hear this testimony in Judiciary Committee. It was heard in the Veterans Affairs Committee, but I can assure you we heard similar testimony last year in the Judiciary Committee on the companion bill. I believe ERPO could have saved my friend Emma's life. Emma was an amazing person, always smiling, laughing, helping me with art projects. She was a friend to everyone, always, no matter what. Then, on January 29th, something happened that I will never be able to forget. Emma was brutally murdered by her mother, and nobody knew until later that day. Emma's life could have been saved, her friend writes. Her death could have been prevented. Right now, Emma should be in the 7th grade with me and her friends, but she is not. I'm here today to make sure that Emma's name is not forgotten. So I urge you to vote yes on this law that could save Emma's life, and that will help make sure that tragedies like Emma's death can be avoided. So colleagues, we have an opportunity to collectively work on this problem of people dying in our communities and mental health crisis. It is a big problem with a lot of components to making a solution. We need to engage in collaborative, thoughtful, and wise decision-making to do so. On Tuesday of this week, my local newspaper, the Gazette, came out with a very clear statement that unless I vote for this bill, they will support an effort to recall me. They suggested the same thing about the President of the Senate. This is the politics of destruction. This is the politics of divisiveness. This is going over the line. This is not the way we operate in this community, in this legislature. I reject that sort of divisiveness, that sort of yellow journalism, that sort of brutal, inappropriate bullying by a newspaper. I will vote on 4,000 bills this year, or 4,000 votes this year. I voted on this bill last year and supported it. The Gazette endorsed me and supported my candidacy. To say this year that they will recall me or attempt to recall me if I vote on this bill this year is the lowest level of divisive journalism, and I reject it, and I encourage every citizen of Colorado to reject that sort of politics. Thank you.
Is there further discussion? Senator Marble.
Thank you again, Mr. Chair. Really appreciate you. I want to go into a little bit more since we have written testimony of David B. Kopel, who is the adjunct scholar at the Cato Institute, Washington, D.C., also research director, Independence Institute in Denver, and adjunct professor of constitutional law at Denver University Sturm College of Law. I'm not going to go through all of this, but I want to hit on a really important part that I had brought up in my earlier time here at the mic. And it's regarding the firearms transaction record for the U.S. Department of Justice. It's what people fill out in order to pass a background check. And the question that many people have regarding how an ERPO will show up on their record, possibly for life. And it seems as though that could be a real possibility on what David Kopel had written. It's a United States Senate Judiciary Committee full committee hearing, red flag laws, examining guidelines for state action. On the very last page, page 23, it addresses preventing federal lifetime bans. And I think this is very important for us to look at and address because these things do happen, even though they may not be intended. It states, upon termination of an order, information in databases should be revised to so indicate. In particular, the order should be removed from the National Instant Check system where it is used as firearms prohibitor. Unless the terminated order is removed from NICS, then a 6-month or 1-year order that has expired would function as a lifetime prohibition. Federal agents should not be allowed to bootstrap expired orders into lifetime bans. ERPO hearings are not criminal trials. An ERPO order does not amount to a criminal conviction. Unlike involuntary commitment hearings, ERPO hearings are not a mental health adjudication. However, aggressive federal officials might scour state ERPO records and declare that certain respondents are federally prohibited persons. For an example, an ERPO case record shows that the respondent was having mental health problems. A federal official decides that the respondent has therefore been adjudicated as a mental defective. Therefore, he is banned by federal law for life from possessing firearms. Similar issues arise under another firearms prohibitors in federal law, namely drug use. This even applies to medical use in compliance with state law. Federal laws and state laws should prohibit civil ERPO orders, which are too often stingy on due process, from being used as a basis for federal gun bans. I think he did a really good job outlining what could happen, and because we're people, it does happen. And that's the sad part about it. And I want to tell you that and remind you that I ran a bill that was going to address the federal law against medical use of marijuana, deeming that anyone using medical marijuana was going to be denied their gun rights. And that bill died. But this is a person who decided to use medical marijuana for purposes of pain control, and because they didn't want to go on an opioid or any other prescriptive drug, now they lose their gun rights. That's unfair. And the ERPO bill is wrought with problems. Otherwise, we would not be having this discussion. And these discussions are why we are elected, and this is the purpose for us being here. And I want to thank everybody for coming up and giving their sides. It's our job. And I appreciate all of the work of the outside people who have come in to give their sides, and especially those 32 counties sheriffs who really do have a problem with 1177, because in their eyes, very hard for them to take action on, and they have a lot of questions, unanswered questions about the constitutionality. So I wanted to add this in about really some other problems that we maybe have not addressed, but we need to address today.
Senator Winter.
Thank you, Mr. Chair. I rise in support of this bill. And I rise in support of this bill as a gun owner and concealed carry permit holder, something that a lot of people don't know about me. My husband grew up hunting. We have several hunting rifles in our home. We have other guns within our home that we secure safely, have a concealed carry permit, and I'm also a mother. And 2 weeks ago, my children had their active shooter drill at their school. And my daughter came home and said, "Don't worry, Mom, I'm the smallest one in my class. I'll hide the best, and I won't be shot." And my son woke up crying 3 nights in a row because he doesn't run the fastest. He said, "I'm slow, Mom." And I love my son. He's not the most athletic person. And he woke up 3 nights in a row because he runs too slow and he doesn't think he can escape the shooter. And to both my children, I said, it's not very common. It's not going to happen at your school. But you know what? That's a straight up lie. We have an average of a school shooting every 12 days in this country. How am I supposed to tell my son that wakes up at night in tears because he can't run fast enough that I can keep him safe? I am a gun owner with guns in the home. I'm a concealed carry permit home owner. I believe in responsible gun ownership. This is not going to take away my guns. This is not a gun grab. This is responsible policy that's going to keep people safe. It's going to make sure when I go home to my children tonight and they ask me, "What did you do at work today, Mom?" and say, "Well, I actually worked to make your school safer." I also have a cousin that was shot at Columbine. She survived. I also have lost 2 dear friends in mass shootings. Reverend Clementa was a good friend of mine. He was a state senator in North Carolina that was killed in his church. and Kara Russell, who worked for a recycling nonprofit that was killed by her mentally unstable husband in the building on Wine Coop in our city. So, as a gun owner, concealed carry permit holder, that rocks my child to sleep because he thinks he runs too slow, and mourning the loss of 2 of my friends to mass shootings, this is a reasonable bill that is not a gun grab, and I encourage a yes vote.
Senator Gardner.
Thank you, Mr. President. Well, I had not intended to come down and read at length from letters and editorials and so forth, but my colleague, the Democratic senator from El Paso County, came down, and if I understood his words, it was to denounce my hometown newspaper for an editorial they wrote, which caused me to go back and read that editorial because I don't think it said exactly what was portrayed. I'm sure that misinterpretation or differing interpretation is an honest one. On March 19th, 3 days ago, the Gazette, by the editorial board, wrote an editorial entitled "Defeat Red Flag Bill in the Colorado Senate." And I will omit some parts to avoid referring to fellow senators by their name here, even if I am quoting from the article, so bear with me. If the Colorado Senate passes a red flag law, Colorado Attorney General Phil Weiser expects the state's 64 sheriffs to enforce it. Weiser reminds sheriffs and other law enforcement they swore, quote, an oath to uphold the rule of law. I actually think that, parenthetically, let me say, I don't think that's really the oath they took. I mean, I think you can infer that. They swore an oath to uphold the Constitution, which supports the rule of law, naturally, but the Constitution. The Gazette editorial goes on to say, that's an interesting way to phrase it, leaving out that part about upholding the Constitution. I don't remember swearing to uphold the rule of law, said Sheriff Elder, who heads Colorado's largest county law enforcement agency. I swore to uphold the Constitution of the United States, the Constitution of the state of Colorado, and the laws of the state of Colorado. As of Friday, commissioners and sheriffs in at least 26 counties, including El Paso County, had formally expressed objection to the proposed red flag law. Some commissioners are declaring their jurisdictions Second Amendment sanctuary zones. Others are preparing lawsuits pledging to decline enforcing the proposed law or embracing various combinations of formal protest. Sheriff Elder calls the red flag bill an attempt by legislators to pass a, quote, rogue, unquote, law in conflict with the U.S. Constitution he swore to uphold. Parenthetically, I might add, apparently our sheriff, based on the advice of his counsel, and he has one, a very accomplished attorney, former prosecutor, apparently they hold a different view than my colleague from Lafayette. The editorial continues, the law would authorize a family or household member or law enforcement officer to seek a temporary extreme risk protection order from a court to confiscate an individual's guns. One or more petitioners would cause a gun confiscation by establishing a preponderance of the evidence that a person poses a significant risk to self or others by having a firearm in his or her custody or control, or by possessing, purchasing, or receiving a firearm. This is not so much about the Second Amendment, Sheriff Elder says. It's the violation of the Fourth Amendment protection against unlawful search and seizure and violations of due process forbidden by the Fifth Amendment. They are doing this in violation of a number of other pieces of the Constitution. It involves ex parte process. It requires only a preponderance of the evidence. It is a civil process and not a criminal process, and my department does not initiate civil process against individuals. There are all sorts of problems with this, says Sheriff Elder. Sheriff Elder does not plan to flout a red flag law. Instead, he plans to obtain a court injunction to stop the law's implementation. Like most rational adults, Sheriff Elder supports the bill's intent. No one wants a person legitimately unstable and dangerous to possess a gun. There are always ways to deal with those circumstances, and it does not require a blanket extreme risk protection order that allows an ex parte process to go after someone's firearms, Sheriff Elder said. The Gazette writes further, here's the big practical concern. Some relationships end in violence, or begin and end in violence. Imagine a single mother haunted by a violent, drunken ex-boyfriend or husband whose only realistic defense is her gun. Under the red flag law, the abuser could cleverly stack a preponderance of evidence case to suggest she's dangerous. He could get a court to disarm the woman and leave her defenseless, or vice versa. Not everyone leads a peaceful and orderly and safe life. That is one reason guns and self-defense are so thoroughly protected by the Constitution. Sheriff Elder is wise to fight this with judicial process, but we hope he won't need to, says the Gazette. And the Gazette goes on, its editorial board, and says, the last time the Colorado Senate passed questionable gun laws forbidding high-capacity magazines, voters recalled Democrat Senate President John Morse and replaced him with a Republican. He represented the 11th Senate District in Colorado Springs. Now, the part that I think my friend and colleague from El Paso County objects to so much says, today, our colleague from El Paso County represents District 11. The Gazette's editorial board endorsed him, respecting his wisdom. We suspect he will use that wisdom to oppose Senate Bill 1177, avoiding a recall, protecting his political future, and keeping District 11 a Democratic seat. I don't read anything here, colleagues and friends, of the Gazette supporting that recall. It just simply says they respect our colleague's wisdom and suspect he'll use that wisdom to oppose Senate Bill 1177, avoiding that recall, protecting its political future, and keeping District 11 a Democratic seat. I didn't think we'd lapse over into First Amendment this afternoon, but apparently we will. It seems to me to be a fairly legitimate observation by a newspaper, one that's still printed on paper in our state and in our community. There are further comments concerning former Senate President John Morse, comparisons to current senators that I have made at previous times and observations as well. And I will simply leave them at that. You can read this for yourself about the choice that the Senate President has to make. It does say that Senator Morse had a path of obscurity, and others can avoid the likelihood of a recall and a look to a promising future in Colorado politics. I think it's great to be an editorial writer. You can simply write and then people don't run to the well immediately and contradict what you say, but they finish by saying no one rational wants firearms in the hands of unstable individuals who pose clear and present danger to themselves or others. That does not mean we can proceed with an ends justifies the means circumvention of due process, property rights, and gun rights. My friends at the Gazette editorial board end their editorial by saying this, and I think these are words worth heeding. I think they are words for all senators from El Paso County and all senators in this chamber to heed. Let's address the real problems, which includes our state's dearth of mental health and addictions treatment, something my friend and colleague from El Paso County spoke about in the well a few minutes ago. Then consider a red flag law that obeys the letter and spirit of the Constitution. Let's not see a repeat of the 2013 recalls and a court injunction on an unjust law. Defeat Senate Bill 1177 in the Colorado Senate and keep it off of the governor's desk. Mr. Chair, I appreciate your indulgence in allowing me to read this into the record because I thought that it's important that it receive its proper and appropriate portrayal. And members, I think it makes a compelling case for why House Bill 1177 is bad policy, and you should vote no.
Senator Donovan.
Thank you, Mr. Chair, and thank you, colleagues. I think oftentimes by the time that we get down to the well and give a speech, perhaps what is lost in that process and not communicated through the Colorado Channel or in the press is the work that it takes to get to the level of coming to the mic. We oftentimes are accused of just following party line or adhering to a special interest, or perhaps our biggest donor got to us. Because by the time we've gotten to the mic and have the confidence to stand to the podium and speak to 34 other people that have the same title as us and represent the same amount of people and have done the same work to get here, that takes work. That's hard. It's hard to find how you're going to vote on this. Some bills are easier than others. Some you may have grown up in the business and have an intuition. Some you may have a personal experience that pushes you one way or another to cast that yes or no vote, the up or down. But some bills are harder. And that's where I find myself on this bill. This is a hard vote. And why is it hard? Because my district is not clearly on one side or the other. We all have our mantras. We've probably had them passed down from a mentor in some places. Mine was the great senator from Denver who served on the JPC and worked in this building longer than some of the interns who served him had been alive. And he wrote a heck of a newsletter. If that doesn't give you enough hints of who I'm talking about, then I don't think I can give any others. And what that advice that he always gave me was vote your district first. That's your job. They put you, vote your district first. That's also what I learned from my father, who served on the Vail Town Council longer than any other member of Vail ever have or will. And he always said he would vote for his town if it meant him put him out of business, because that's what his responsibility as a public official was. You vote for your constituents. And so on this particular bill, my district's split. My sheriffs are split. My chiefs of police are split. The people that I call to talk about things, my lawyers, my DAs, my judges, they're split. And many of them have risen the same for and against points that the thoughtful dialogue and extended dialogue has brought up today. So I come down to the mic to share with you some thoughts. But as I just said, this came with work. This came with being with this bill for years. This came with reading emails that were results of petition drives and emails that were results of people writing because they had experienced personal tragedy. So I have 3 spirits with me today that are contained under this title of Senator of Senate District 5. 1, my experience as an educator. And we have heard this story told by parents, but I tell it as an educator, of walking through what it meant of active shooter drills with students. It was horrible. It was horrible. You went from one moment, right? Remember the franticness of a school day? There wasn't elegant transitions, right? You went from one moment of teaching the Pythagorean theorem to the next moment trying to teach kids what would happen if someone walked into the school with a gun and what was their best way to survive that situation. And then immediately you're back to teaching about sentence fragments. That's not something I anticipated ever having to do as an educator. But that's where we find ourselves. 2, I rise with the spirit of being a rancher and a hunter. One thing serving in this building has taught me is that there are very different perceptions of what a gun is. And one of the privileges of serving in this building has been having in-depth and difficult conversations with people that didn't view and grow up with guns in the same way that I did. That when they see a pistol or a handgun, it is a tool of murder. When I see a pistol or a handgun, I see it as a tool of my profession. Something that I have on hand in case I need to put an animal down and a vet is 2 hours away. But I've also learned to appreciate others that guns are scary. And so we find both of those spirits of how we view guns coming to surface into how people view this bill. I believe this is one of the primary hurdles that we have as a political body, is recognizing that weapons are very different things to different people, and it puts us in a hard place to see that the other person isn't trying to do malicious attacks through legislation. They're trying to do what they think is best. 3rd, as a community member, I rise. And you all know I come from this wonderful place called Vail. I grew up there. But you would think that in an idyllic, peaceful little ski town nestled in the mountains, surrounded by mansions, frequented by movie stars, you know, there's no problems. We even call it Happy Valley. But Happy Valley has found itself increasingly beset by articles in the newspaper of people that have taken their lives. And yes, people can take their lives in different manners. We, of course, all know this. I had a girlfriend in high school who took her lives through pills. But I also have seen people that decide to take their lives by guns, and that's a much more immediate death. And that's when we talk about death by suicide by handgun, the need to react to that situation with a more immediate response is that we know the effectiveness of guns. They are designed to kill. And when someone decides to take their life that way, we need to be able to step and react to that. My police chief, and this is the community voice I want to share, my police chief from Vail, who I was actually on the citizen committee as a teenager who interviewed him for the job, has been testifying in support of this bill for years now. And he shares two pieces of information with me every chance he gets. One is that he has been involved with the International Association of Chiefs of Police. He is currently actually the vice president of that institution, and they support the concept of ERPO. And that's why he comes down and feels confident advocating for it in his uniform. He also shares the story with me of responding to a person in distress, and that they knew that he was in a very critical situation. They knew that he had access to handguns and firearms, but they didn't have the resources to remove those. He killed himself within the next 24 hours, and we lost that life out of our community. I don't think any of us will say that one bill will solve everything. No bill we write will singly solve any issue, particularly one as big as gun violence. I don't think any of us have ever written a bill and come up to the mic and said, here's a bill that solves all the issues that have to do with this, no matter if that issue is rural broadband or gun violence, economic development, prisons, access to food, education, full day K. We cannot make that claim. But we cannot have the expectation that we should not try. If we lower ourselves to not try to solve these issues, then it is hard to understand why we find ourselves on a Friday afternoon enjoying each other's company debating such an issue as this. I don't think any gun owner or any gun advocate wants another innocent life taken by a gun. This bill that we have in front of us, that I believe many of us have very thoughtfully considered from many angles, gives us the opportunity to give our law enforcement the opportunity to address very critical, unique, and rare situations. It gives tools the citizens to help those that they love. I think that's one of our duties. It gives tools to police officers, who I trust, to thoughtfully examine every issue and react with responsibility and adhere to the oath that they have made. It gives tools to the judicial system to listen to the community members that they know, to look at what options they may have, to address a unique situation that has come across their desk and that they have the duty to fulfill thoughtfully and with the full intent of the law and the oaths that they have made. We can revisit laws. This is also our duty. And we will have the opportunity to revisit this law. This is a hard vote for many of us, and I do not fault anyone for where they will vote today or tomorrow, because I think people have been considerate and have investigated this bill at length. I know I have. And with that, I respectfully do ask for your aye vote on 1177. Thank you very much, colleagues. I truly have been honored to be a part of discussions today.
Senator Hill.
Thank you, Mr. Chair. Colleagues, I know we've had a lot of discussion on this. I want to bring us back a little bit to a conversation about due process. And I know there's been a push from both sides about what does due process look like in this case. What does the Fifth Amendment mean? What does the Fourth Amendment mean? And I have a contention and I have an amendment to offer, and I will offer that, and then we can discuss it. So.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L082?
Amendment L082, House Bill 1177 by Senator Hill, amendment Gross Bill, page 18, line 3, strike. Respondent establishes the substitute petition is not established, page 18, line 4, strike. He or she no longer opposes and substitute. The respondent continues to oppose.
Senator Hill.
Thanks, Mr. Chair and Mr. Carpenter. I appreciate you reading that while I got to my spot on page 18 here on the bill. Colleagues, we have this broad notion of innocent until proven guilty, and that's why I've brought
Senator
Amendment
Hill.
82, and I move Amendment 82.
Thank you.
Amendment
Please
82 is designed to address the order in which we do things here. And you'll see on page 18 about the opportunities for terminating this extreme risk protection order. And what it says on line 3 is there, it says, well, starting on line 2, the court shall terminate the extreme risk protection order if the respondent establishes a clear and convincing evidence that he or she no longer poses a significant risk. So what we've done here is we've put the initial burden of proof on the petitioner. They go and they petition for this risk protection order to be implemented against the respondent. But now in order to reply to that, in order to get out from under this extreme risk protection order, the respondent is the one that has to prove that they deserve it. And colleagues, I think that all of us can look at this and say, that is indeed, without process of conviction or any of that, that is, you have to prove your innocence. And how is one supposed to do that? I know we'll be having a discussion later on this evening about many of my concerns on the military side of this and veterans in my community. But whether it's veterans or non-veterans, right now we have a situation where you have to prove that you're innocent. And that flies in the face of so much of what we have done with the United States Constitution. And so Amendment 82 switches that, and it says we're going to take what I just read out, and instead it would read, the court shall terminate the extreme risk protection order if the petitioner does not establish a clear and convincing evidence that he or she no longer poses a significant risk. So really what we're doing here is, sorry, there's a second part to that. If the respondent continues to pose the risk. So the idea here is that you asked for this, you got your 14 days, and that makes sense, but now that person has to show that they continue to pose a risk. We've had time within the process, we've had time to sort this out, and rather than putting the burden of proof on someone where it shouldn't exist, where our Constitution was designed to protect against that, this would switch it around and say, you are still innocent until proven guilty. And so if that was enough to initiate the first extreme risk protection order, it should be enough to establish it ongoing. I ask for your support on Amendment 82.
Senator Court.
Thank you, Mr. Chair. We urge a no vote on this amendment. 14 states have extreme risk protection orders. 9 states have termination hearings. 8 states do it the way ours is written. So we think that this has good precedent in those states that are already using extreme risk protection orders. We urge a no vote.
Senator Lundin.
Thank you very much, Mr. Chair. I rise in support of the amendment. Earlier today, I spoke about this concept of guilty until proven innocent. It just flies in the face of who we are as Americans. We started the day, the sponsors, saying that there is broad support, and they cited some polls. But this is exactly the place at which, when you start to get beneath the surface of we all want to be safe, of course there's broad support that we all want to be safe. But when you start talking about how you're going to do it, which is, as the minority leader said, the words and numbers on paper that become the law, that's when, in fact, our job becomes critical, and the public expects us to step up and find the way forward to get to a positive answer. The reality is, if you ask Americans in that poll that says we all want to be safe, if you ask them a second question, are you willing to live in a land where you're guilty until proven innocent or sane? They would say no, absolutely not. That's not what America's about. So this amendment is completely rational. It takes a small step that takes us a long way towards restoring our path back to our constitutional home and the traditions of who we are as Americans. I think this is a really simple ask. I think it's a really important amendment. I think it's one of those things that helps us get to a place where we can all believe we're trying to honor the Constitution and honor the objectives that we all say we're about. I urge your support of the amendment. Thank you, Mr. Chair.
Senator Foote.
Thank you, Mr. Chair, and I rise in opposition to the amendment. And let's put this in a little bit bigger context about how this all works, because it's not so easy to grasp at the beginning. But the first step in the process is a temporary extreme risk protection order, the temporary ERPO. And the burden is on the petitioner at that point to establish by a preponderance of evidence that the respondent poses a significant risk to himself or others, and then there's some other elements that have to be established as well before the temporary ERPO is issued. So the burden of proof is on the petitioner by a preponderance for the temporary ERPO. Then, within 14 days after the temporary ERPO is issued, assuming that it's issued, then it goes to a hearing for the extreme risk protection order, which can last up to 364 days. The burden at that point is again on the petitioner, the one requesting the ERPO ruling for 364 days, by a clear and convincing evidence. And then on top of that, what this bill allows the respondent, the person who is the gun owner, what it allows the respondent to do is actually sometime within that 364 days, when the court has already determined by clear and convincing evidence that that person poses significant danger to themselves or others and should not have their firearms, then it allows the respondent to actually petition the court to reverse that order. And that is when the burden is on the respondent to establish that they are no longer a risk. But it is in that context I think it's important, because in addition to the due process of preponderance of evidence for the temporary ERPO and then the clear and convincing for the 364-day ERPO, this bill also allows the respondent to petition the court to reverse that order sometime within that 364 days. It allows the respondent to say, no, we disagree, we want the court to come and look at it again. So it's under that context I think we need to look at this provision. And that's when the provision is on the respondent. But it's that additional part of due process that's in this bill that should be highlighted. It goes to show again how due process in this bill is robust, and it allows the gun owner and the respondent to have yet another bite at the apple to show that they should actually be possessing these firearms.
Mr. Minority Leader.
Thank you, Mr. Chairman. I rise in support of the amendment. It seems as though that the way the bill exists now would create a scenario similar to an inmate asking a parole board for release from prison. And yet, in this instance, the person who has had their property taken away from him or her has not been convicted of a crime. They're not in custody. They're not in jail or prison. And yet they have to disprove a negative. They have to come up with some way of convincing the judge that they're okay to have their property back. I appreciate the amendment sponsor bringing the amendment, because I agree with him that this is a standard of being guilty until you can prove yourself innocent. And that's backward. That's not how our Constitution of the United States or the state of Colorado establishes. You are presumed innocent until proven guilty, and there has been no proof here. There's no conviction. There's no crime. You've had your property, your constitutional rights taken away from you, absent that level of proof, of process. I appreciate the amendment sponsor bringing this and ask for an aye vote, because again, it does return us to the principle, the basis of innocent until proven guilty. Ask for an aye vote.
Is there further discussion on the amendment? Senator Hill.
Thank you, Mr. Chair. Colleagues, I think there might be a little bit of a mix-up by one of the previous speakers. I respect his legal mind on this. I just want to be very clear about what section of the bill this is in. This is about the first 14 days. So if you look back on page 17, let me grab this. If you look back on page 17, starting at line 18, this is section 13, 14.5, about the termination or the renewal. This is your 14-day hearing that we'll read about here in just a second. This is about whether or not you terminate the initial order or you renew it for up to 364 days. And so it says, the respondent may submit one written request for a hearing to terminate an extreme risk protection order pursuant to this Article 14.5 for the period that the order is in effect. Upon receipt of the request for a hearing to terminate an extreme risk protection order, the court shall set a date for a hearing. Notice of the request and date of hearing must be served on the petitioner in accordance with the Colorado Rules of Civil Procedure or Colorado Rules of County Court Civil Procedure. The court shall set the hearing 14 days after the filing of the request for a hearing to terminate an extreme risk protection order. So this is the initial. This is this first part. So there's a preponderance of evidence is required for the initial extreme risk protection order. Now we have a hearing. They can reply and say, hey, I want to have a hearing. 14 days later, the way this bill is written is the only way to lift that ERPO, the extreme risk protection order, is for the respondent to prove by clear and convincing evidence. So a higher set of evidence than even to put the order in the first place. Remember, preponderance to get us there, but now clear and convincing evidence on the respondent to get it lifted. So we can debate, and we will debate, the level of preponderance versus clear and convincing evidence, but this is the first 14 days. This isn't after a year. This isn't at the end of it. There's a higher standard that the defendant has to prove to get out from under it. And that's my contention, that this is legitimately guilty until proven innocent by an even higher standard than to put the order in the first place. And I ask again, shouldn't change this, but in the spirit of innocent until proven guilty, this is a small but significant and important change that we should support.
Senator Foote.
Thank you very much, Mr. Chair. I think this is valuable. This is a valuable discussion to have because it's certainly not an intuitive thing once you hear about it the first time. There's a lot of steps and a lot of procedures to this extreme risk protection order bill, and I've had the benefit of having been through a similar bill last year as well as through the committee hearing this year on this particular bill, and so I think it's very valuable to have this discussion for the public as they're trying to sort through what this bill actually does. And so what I'll highlight really are 3 steps, or really 2 steps, and then the third is the optional step. The first step is the petitioner goes to the court and asks the court for an extreme risk protection order, a temporary extreme risk protection order. That's the first step. And the petitioner has to prove to the court by a preponderance of evidence whether or not that temporary extreme risk protection order should be granted. If that is granted by the court, if they meet that burden by a preponderance and then the court decides an extreme risk protection order, a temporary one, should be granted, then the petitioner then has 14 days, or there should be a hearing set within 14 days, could be sooner, but it has to be no later than 14 days, to make that temporary order a permanent order. Not really a permanent order because it's only for 364 days. So it's an order that only lasts for 364 days. This is very similar actually to a protection order process that happens in courts, civil protection order, where somebody goes to the court and says, I'm in danger, or I want someone not to contact me or be in contact with my house. The court issues the temporary protection order, and then later on, that same petitioner has to go back to the court and say, I want you to make this a permanent protection order. They have a burden of proof, and they have to do it in a later hearing. So it's similar to that, except actually it's more difficult to do that in this case than a regular protection order. The extreme risk protection order then that is at issue at that hearing that's no more than 14 days has to be proven by the petitioner by a clear and convincing evidence standard. So first step, temporary protection order. Second step, within 14 days, is the protection order that lasts for no more than 364 days. And that's a burden of proof of clear and convincing. The third step, which is what this amendment would cover, is where the respondent, in this case the gun owner, then can go back to the court and say, no, actually, we want to have this protection order, this extreme risk protection order, terminated before the 364-day mark. Because under this bill, it has to terminate after 364 days. And so the respondent, the gun owner, go back to the court before 364 days and say, no, we actually want this protection order to terminate at the 120-day mark or the 150-day mark. And at that point is when that gun owner has the burden to show the court that they are no longer a significant risk. So I just want to make sure that that's clear. There's actually 3 steps here. It's, as I said, it's robust due process, and it also gives that gun owner yet another opportunity, an opportunity not always afforded in other types of protection orders, to terminate it before its time is actually done to be terminated.
Is there further discussion? Senator Hill.
Thank you, Mr. Chair. And again, just to follow up, one of the sponsors came up and brought up the statistics on the other states who have implemented this. And one of the discussions we haven't had as we live in the 21st century and science drives a lot of our decision making is how has this helped in other states? I know there have been plenty of studies. I haven't heard the evidence proposed that this helps. However, as we go to talk about the evidence, I think it's important to recognize that we have, when you look at so many of our founders speaking on these issues, again, founders on all sides as we wrestled with this, America was founded on this notion that you are innocent until proven guilty. America was founded on this idea that it's better to let 10 guilty people go than to convict one innocent person. And as they had seen abuse again after again after again and again and again in all the places that they had come from. And I in many ways, I believe we're disrespecting that tradition, that history. And you can say, well, it's not a big deal. It is a big deal. There's a lower standard of evidence to get into this than even is required to get back out of it. It is now the burden of proof is on someone. The argument that has been made is that this person, statistically it's going to be a male when you look at the stats, but this male or this female, this man or this woman is already under duress, and that's why the extreme risk protection order is being implemented. And so if they're already under duress, if they already have challenges, then in this case, whether it's the suicide or other people's lives are in danger as the risk, the reality here is we're saying you're already at risk, but now, in order to deal with it, you're going to have to prove by clear and convincing evidence that you don't deserve this. Colleagues, I find that to be completely antithetical to the idea of American values. Not to say that, right, we have many other parts in this process, but to say you have to prove your innocence if you're going to get out from under this. And I don't see how we can look one another in the eye and say, yes, we continue to support it simply because that's what other states do. Last time I checked, most of us got up here because we believe Colorado is unique. And Colorado doesn't do what other states do. And I ask for your support on Amendment 82.
The question before us is the adoption of Amendment L082. A division has been requested. Division has been requested. Will all those in the chamber not entitled to vote please be seated? The question before the body is the adoption of Amendment L082. All those in favor, please stand and remain standing in one place until the vote is taken. You may be seated. All those opposed to Amendment L082, please stand and remain standing until the count is taken. The chair is not in doubt. Amendment L082 is lost. To the bill, Senator Hill.
Thank you, Mr. Chair. I'd like to further discuss this issue, so I will offer Amendment 071.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L071?
Amendment L071, House Bill 1177 by Senator Hill, Amendment Gross Bill, page 18, line 4, strike clear and convincing evidence and substitute a preponderance of the evidence.
Senator Hill.
Thank you, Mr. Chair. I move Amendment L071. And so we're back on the exact same bill, page on the bill, as I know you're all tracking along here on page 18. So the last amendment was an effort to say once the extreme risk protection order has been petitioned, the burden of proof is not on the respondent. The burden of proof is, instead of being on the respondent, the burden of proof should be back on the petitioner. And dare I say, back on the system to show that they deserve to have their guns taken away from them. They deserve to have this property taken away from them for a certain amount of time. Instead of switching that around on this one, I say, well, look, at least let's be fair. At least let's have the same standard. Because right now, the standard is preponderance of the evidence for the petitioner having the extreme risk protection order put in place, but to lift it, the respondent has to have clear and convincing evidence. Colleagues, I don't think this is fair. I don't think this actually reflects an equal burden of evidence on both sides. And so rather than clear and convincing evidence to get back out from under it, if we are going to, what I would argue, burden the respondent with having to get out from under it, at least let it be the same level of evidence that existed to put the order in place at the beginning. So this amendment changes their burden from clear and convincing evidence back to a preponderance of the evidence to be fair to both sides in this argument.
Senator Court.
Thank you. It's the same standard. The 364-day standard is the same. I urge a no vote.
Further discussion on the amendment. The question before us is the adoption. Senator Lundin.
Thank you very much, Mr. Chair. This amendment gets at, in a narrower way, I'm not as enthusiastic about this as I was the previous amendment, but at least in a narrow way, it seeks to make this just aggressive failure of due process that would honor the ethos of the great country known as America. At least it tries to bring things back into order. Now, it's very narrow, it's very limited, and so I'm not going to jump up and down and scream and shout and say this solves it, but I'll say, you know, golly, if we can make incremental improvements, I think we ought to do it. I encourage, not urge, but encourage your support of this amendment.
Senator Gardner.
Thank you, Mr. President. So I wore a blue tie today, and it's in honor of respondents. The fact of the matter is that the bill sets by shifting the burden of proof to get out from under this extreme risk protection order, and raising it to clear and convincing evidence, it's a nearly insurmountable burden at that point. I could foresee judges essentially requiring psychiatric studies. It wouldn't be enough to just go for 364 days minding your own business. That might meet the preponderance, not having anything to do with the person who originally petitioned. You would need something that rises to the proof of something more likely than not. By making it preponderance, it at least gives the property owner, the firearms owner, an opportunity after 364 days to regain their property. That in and of itself ought to create a presumption. If nothing happens for 364 days, that ought to create a presumption, but that's not going to happen. I recognize that. So this is, as one of my colleagues from El Paso County indicates, I'm not going to jump up and down about this, but it would make it closer to a due process that we think meets the test of procedural due process. We ask for an aye vote.
The question before us is the adoption of Amendment L071. All those in favor say aye. Opposed, no? The chair is not in doubt. The amendment is lost. Is there further discussion on Amendment House Bill 1177? Senator Gardner.
Thank you, Mr. Chair. I don't know if you noticed I wore a blue tie this afternoon. And one of the things that we discussed earlier was this question of the evidence having to be corroborated evidence. When I served in the House, as did Mr. Chairman, I was often frustrated by House rules that prevented us from revisiting issues under the settled question rule, and I think that's a very good rule. But we don't have it over here in what lots of people like to refer to as the upper chamber. We're superior beings or something. I say that with all due sarcasm. So we don't have settled question, and that means things never get old. And for that reason, I would like to make an amendment, offer an amendment.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L083?
Amendment L083, House Bill 1177.
Senator Gardner.
Thank you, Mr. Chairman.
Looks oddly familiar. Please proceed.
I would like to move Amendment L083, and so because I would like to, I am going to, and I will state, I move Amendment L083.
To the amendment, Senator Gardner.
Thank you. Thank you, Mr. Chair. So, members, this is your opportunity to clearly vote on this particular issue. Earlier, you had the committee report, and we didn't ask for that to be severed and all of that, because you don't have to do that here, because we don't have a settled question rule. So I would like you to consider very strongly that this requirement that evidence be corroborated is an important protection, and I ask for an aye vote.
Senator Court.
Thank you, Mr. Chair. Let's see. About 6.5 hours ago, we decided this. I ask for a no vote.
Senator Gardner.
Thank you, Mr. Chair, and my apologies. I barely remember that long ago. In fact, sometimes when I have to use my indoor voice all day long, I lull myself to sleep and don't remember, but this is an important amendment. It is important to vote upon it separately, and that really, in all seriousness, is the reason that I'm offering L083 as a separate amendment. I ask for an aye vote.
Further discussion on the amendment. Seeing none, the question before us is the adoption of Amendment L083. All those in favor say aye. Opposed, no? Amendment L083 is lost. Is there further discussion on the bill? Senator Gardner.
Thank you, Mr. Chair. The interesting thing about the way that House Bill 1177 works is that once the extreme risk protection order is in place, the evidentiary requirements of the further hearing would allow there to be nothing but affidavits. And one of the things that we all in the law know is an affidavit is hearsay. There may be an exception to the hearsay rule that allows the admission of an affidavit. But, you know, one of the interesting things is that today we have had people come to the well on both sides of this issue, from both sides of the aisle, and read all sorts of things and all manner of things into the record. I mean, clearly compelling things, things that make statements, statements of fact, mixed statements of fact and opinion, and on and on. What House Bill 1177 allows is the continuation of a red flag order on affidavit only. That should not be, because you cannot cross-examine a piece of paper. And one of the important protections of due process, one of the engines of truth, in the words of the United States Supreme Court, is the ability to cross-examine. And so, for that reason,
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L070?
Amendment L070.
Senator Gardner.
Thank you, Mr. Chair. I move L070.
To the amendment, Senator Gardner.
Thank you. So, as I was talking about the problem of having affidavits only, Amendment L070 eliminates the ability to continue an order on affidavit only. It strikes the language that says you can present affidavits, and I ask for an aye vote.
Senator Lundin.
Thank you very much, Mr. Chair. So this whole process, this due process, or this violation of due process, would be my perspective, begins with an ex parte order. The inability for a person to show up and defend themselves. That is incredibly challenging if you just stop and think about it. Think about that, what that means to us in the land of the free. You can't be there to respond to the accusations being made against you. Well, the due process then rolls ahead, or again, I have to call out the lack of due process rolls ahead, and at some point, just by filing papers, the order stays in place. This idea that you can't even show up and make an argument on the front side, it happens with you not even in the room. And then it continues on just because somebody files some paper and you have, again, no opportunity to engage, to say, wait a minute, that's not fair, that's not accurate, that's not who I am. And then you've got to climb this wall of higher and higher evidentiary standards on top of it all. It's just wrong. This, again, is one of those little teeny amendments that gets at it in a small way that improves this lack of due process to make it a little bit less lacking in due process. So this small ask, surely, this small ask is worth accepting. I urge your support of Amendment L070.
Senator Court.
Thank you, Mr. Chair. Well, if it's uncontested, there's no point, and if it is contested, there's another process. I ask for a no vote.
Is there further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L070. All those in favor say aye. Opposed, no? Amendment L070 is lost. Is there further discussion on the bill? Senator Gardner.
Let me know what you decide. Thank you, Mr. Chair. We have discussed at length today, and will discuss at length this evening if need be, the fact that the initial hearing done by affidavit is done without notice to the respondent, any notice whatsoever. There's not even a requirement that you try to give the respondent notice. In fact, there's deliberately no requirement. Now, this is different than the Federal Rules of Civil Procedure, which say, even for ex parte temporary restraining orders that some of you will be familiar with, that when you get those, you have to make the very best, and you have to represent to the court that you've done your very best to give notice to the other side, even if it's not formal service or process, that you've given them an email, that you've called them on the phone, that you've written them a letter, even if you didn't have a process server go around. This procedure in the red flag bill is, we're not going to give you notice. We're going to have a surprise hearing. We intentionally are going to have a surprise hearing. That is not due process. It is not due process to not have a hearing whatsoever and not try to give notice whatsoever. So here is an opportunity to remedy that infirmity. And once it has been distributed,
There is an amendment on the desk. Mr. Carpenter, please read Amendment L073.
Amendment L073.
Senator Gardner.
Thank you, Mr. Chair. I move L073.
To the amendment, Senator Gardner.
Whether I would like to move it or not, I have moved it. And what L073 does is eliminates the ex parte aspect of the hearing. This, in all of its complication for 17 different lines, what it does is it makes the hearing no longer an ex parte hearing. It is, the first hearing is a notice hearing, and I ask for an aye vote.
Senator Pedersen.
Thank you, Mr. Chair. And this is actually a really important piece of this bill. When you think about somebody who is at risk to themselves or others who have weapons, if you notify them about this hearing, that actually increases the risk. So this is a critical piece that they are not notified. And for a quote that came from the Douglas County Sheriff Spurlock, I think kind of sums this up perfectly. He says, "It's true that all of that occurs without the defendant being notified, but of course that's the case. Nothing good could come of a mentally unstable individual who is making threats of violence being notified that someone has filed an extreme risk protection order." I ask for your no vote.
Senator Foote.
Thank you very much, Mr. Chair. And wanted to talk a little bit about this issue about ex parte hearings because, again, this has been something that's been brought up, and I'm glad that the amendment really speaks to this. Ex parte hearings are not unusual in our procedure in Colorado law and also in other states as well, but I'll just speak to Colorado law. For example, if a police officer goes to a judge and asks for a search warrant, that's going to be an ex parte communication with the judge. What this means is that the opposing party is not present at the time. And so the police officer goes to the judge, asks the judge to issue a search warrant based upon probable cause, and then the judge says yes or no, the order gets signed, it gets served, and then that's when the other party gets involved with court proceedings. So that's nothing unusual. In fact, an ex parte hearing occurs in not just criminal cases, but in many types of civil cases when there are temporary protection orders that are sought. In fact, an injunction that was sought by my colleague from Colorado Springs against the Senate President just a week ago was a result of an ex parte hearing. So there's nothing that's unconstitutional or indeed unusual about ex parte hearings, and that same kind of procedure is incorporated into this bill with extreme risk protection orders. So I believe also that this amendment should be voted down as well.
Further discussion on Amendment L073. Seeing Senator Gardner.
Thank you, Mr. Chair. Well, with respect to my colleague from Lafayette, while search warrants are given on an ex parte basis, and then there are some other proceedings, in civil proceedings, they really are the exception, not the rule. And the expectation is to say to someone who is petitioning the court, you want an ex parte order, have you notified the other side at all? Now you get these on protection orders, but it's one thing to say, Mr. Gardner, because they don't call me senator on the street. Mr. Gardner, the former sheriff from Weld County says you threatened him, and he's filed a petition, and we're going to give a temporary order. Mr. Gardner, stay away from him. They don't take any property out of my hand. They don't tell me I can't go anywhere. And they're very good about, well, if the sheriff and I work in the same place, they say, well, you know, stay at least 50 feet from him, or however, 25 feet from him over in over in your chair, and don't do anything. Ex parte orders are very limited things. And the idea that we could, on an ex parte order on a civil basis, knock down your door, essentially, in the middle of the night, early morning hours, in darkness, that is unheard of. And that's why I'm offering this amendment. I ask for an aye vote.
The question before us is the adoption of Amendment L073. All those in favor say aye. Aye. Opposed, no? No! Amendment L073 is lost. To the bill. Senator Gardner.
Thank you, Mr. Chair. So I think to bring this full circle, there's a wonderful nearly 25 pages of written testimony that our own David Kopel of the Cato Institute, Independence Institute, and DU Sturm College of Law has prepared. And I'm not one to sort of read lots of things into the record slowly or to go over them, so I won't do this exactly word for word, but it so encapsulates and summarizes the problem with red flag bills and some of the history and some of the data that we have talked about today. You know, you've heard people say, well, in Connecticut or Indiana, the suicide rate went down. Well, Professor Kopel's testimony that he has prepared, that I will review with you, and it's 25 pages, addresses those things and really rebuts much of what was said. And it's important because we do not want hasty or ill-considered legislation. So, you know, the executive summary of that testimony says that red flag laws or extreme risk protection orders have been enacted in several states, as we've talked about today. And while the idea for the laws is reasonable, the statutes being enacted are quite the opposite. They destroy due process of law, they endanger law enforcement and the public, and can be tools for stalkers and abusers to disarm the innocent. The evidence would show that about a third of these orders are improperly issued against innocent people. Now, I've heard my colleagues talk about lives are at stake, and I understand. I believe I certainly don't question your motives. In fact, I would say to you, I believe your motives in this matter are good. But we are sacrificing the rights of citizens, and this material that I'm about to go through with you will indicate that there are innocent people who have their homes invaded, and there are innocent people who are injured, and there are not as many lives directly saved by red flag orders as one would imagine. You know, Congress is considering providing funding incentives for red flag laws. And this testimony was prepared really with that in mind. You know, the model we have here really is what's been referred to as the Giffords confiscation model. After Congressman Gabby Giffords and the organization that she started and what happened to her as an elected official in a supermarket parking lot when she was having a kind of a town hall is tragic and inexcusable, and one of the kinds of things that we hope that stronger mental health protections could prevent. But it is clear that the majority is going to insist upon an ex parte proceeding, and any procedure that allows a judge to hear only one side of a case will necessarily produce a high error rate. The two states with the oldest red flag laws demonstrate this. Connecticut, the confiscation orders are issued ex parte, and as this bill is, the respondent gets an opportunity to tell his or her side of the story in court later. Once the judge under this model that we're adopting hears the respondent's side of the story, it turns out that in Connecticut, 32% of the confiscation orders are overturned. 32%, fully a third of them are overturned. In Indiana, another state that's had red flag orders for some time, similar results. Now you say, well, you know, it was only 14 days that they were without their weapons. Oh, did I say weapons? I said weapons, not firearms. Their protection. It's only 14 days. And oh, by the way, if law enforcement asked for this order, there was a search that went with it. So these 32% errors are not without very serious consequence for the respondents that were involved. The error rates for the Giffords model that we're using here are likely to be even higher. You know, Connecticut requires, and we haven't talked about this nearly enough today. I think it's been talked about a little bit. Connecticut requires that a petition be filed by two, not one, but two law enforcement officers. And they have to have conducted an independent investigation before they go after this ex parte order. So it is not a situation of one's ex-husband, ex-wife, jilted partner. It is law enforcement with an independent investigation. Indiana requires petitions to be filed by law enforcement as well. But what we're doing here today is allowing petitions to be filed by ex-girlfriends, ex-boyfriends, people who lived with you once upon a time. And as we've debated here, there's no requirement for corroboration of evidence. I mean, one of the things that law enforcement people are trained to do, I think the sheriff will give me a nod, is when they receive a statement from someone, they try to corroborate that statement. It's natural. It's the first thing they try to do is someone tells them something, they take it at face value, but they try to corroborate it. Well, without that, you have a higher error rate. Now, I know many of you know I serve on the National Conference of Commissioners on Uniform State Laws, the Uniform Law Commission. You know, in 2018, the Conference of Chief Justices asked the Uniform Law Commission to draft a model red flag law. And the Uniform Law Commission convened a study committee to do that, and they had representation or participation from stakeholders like the National Sheriff's Association, the International Association of Chiefs of Police, psychiatric experts, state courts, pro and anti-gun advocates. And you know, the committee initially, the Uniform Law Study Committee, initially overwhelmingly voted to recommend that the Uniform Law Commission move forward with the drafting of a model law. Imagine that, members. I may well have been asked by my uniform law colleagues to sponsor a model red flag law. But even though support for the model law came from across the political spectrum, legislators, law enforcement, and the courts, there was overt opposition to the model law by the Giffords Law Center. They wanted the model that is House Bill 1177 in large part. So the Uniform Law Commission ultimately concluded its effort. One of the things about the Uniform Law Commission is it does, with 350 lawyers, imagine that in a room, 350 lawyers from all 50 states plus the territories, have a geographic diversity and a diversity of thought that really does bring a model law together. So that was killed, and now we have what is House Bill 1177. We've talked about the fact that growing number of counties and county sheriffs have indicated concern about the enforcement, what it means for them. Throughout the United States, where these laws have been introduced, elected sheriffs have been announcing that they don't believe they can adhere to their oaths to enforce the U.S. and state constitutions, and at the same time trample the civil rights of the people who elected them. You know, it's been interesting to me to hear the derisive comments from colleagues about 26 county sheriffs and commissioners expressing their resistance to House Bill 1177. And the reason it's so distressing to me is whether or not one disagrees with them, the tradition of local resistance to bad and unpopular laws thought up at the center of power is as old as the American Revolution. That tradition has continued in this country, and there are state and local refusals to assist in enforcement of things like the Fugitive Slave Act, the Sedition Act of 1798, many other provisions in our history, and yet colleagues are derisive about elected officials in the state of Colorado responding to their constituents' concerns. The duty to uphold the federal and state constitutions that they take an oath to necessarily require them to make constitutional judgments. It is not their job to make the law, only to enforce the law, but one cannot enforce the law without making some judgment about the law. This places them in a very difficult situation. Now, I'd like to turn to the question, or the thing we've heard all day long, which is, again, I want to give a lot of credit to Professor Kopel for putting this together in a very topical way, and I understand he's going to present it at the United States Congress. All of these studies about the declining suicide rate. You know, there are only a few states that have more than a few months of experience. I mean, we're talking about Connecticut and Indiana. The ones other than Connecticut and Indiana, Connecticut in 1999, Indiana in 2005, you have California in 2016, Washington in 2016. That's not so long ago. Seems like a long time ago given the election, but it's not. And so our social science research is fairly sparse. There's no statistically significant research about that would show a reduction in crime. All we've heard all day long is this is going to save lives, this is going to reduce crime. There's no research that is statistically significant to demonstrate that. I mean, maybe it does, maybe it doesn't, but all we're doing is saying what we purport in our gut. And studies about suicide prevention are pretty mixed. One study looked at the suicide rates in Connecticut and Indiana. Indiana had a demonstrated aggregate decrease in suicides, while Connecticut's estimated reduction in firearm suicides was just offset by other non-firearm suicides. That's a sad thing, but I think it demonstrates that perhaps those with mental health issues will find a way to act if they don't receive the help they need. I mean, one of my criticisms from the very beginning of this debate 2-3 years ago has been that we should lead with mental health treatment and solutions, not trail with those solutions. The research showed that of 762 Connecticut recipients of gun confiscation orders, 21 did later commit suicide. 6 by firearms that they somehow got a hold of anyway, and 15 by other means, demonstrating that there are people who need the mental health treatment, not the gun confiscation order. There was another study that looked at crime and suicide in all the states that have red flag order bills, and there were no statistically significant changes in murder, suicide, or the number of people killed in mass public shootings, robbery, aggravated assault, or burglary. So, other than one's intuition, and I understand, but other than the emotion of we have to do something, here's this thing, we'll take guns away from people that other people say are a risk. We don't really, for this encroachment upon the liberties of citizens, taking their property, we don't know that there's any significant return on that. I mean, it's not to say that the laws are necessarily useful or useless. It's possible for a law to be beneficial in certain cases, but still have too low of an impact to be statistically significant. We've talked about this issue, that red flag laws endanger public safety while perhaps protecting it at some point. This particular model that we are enacting, with its ex parte order proceedings, you've heard the stories, they ensure that a very large number of these orders are going to be issued against, statistics show this, a third of these orders in Connecticut and Indiana, where you have law enforcement making the petition and doing an independent investigation. Still a third of them are against innocent people. You're going to have a very large number of orders issued against innocent and otherwise peaceable individuals. And when you have automatic no notice, surprise confiscation, I mean, it is intended, frankly, if you read the bill, you can't make any other conclusion than we're trying to do this without giving notice. There's no admonition to try to make notice. It's part of the plan. Do this no notice. A respondent never receives notice until the police show up to confiscate his or her firearms. I don't need to tell you how volatile that situation is. You know, I think it was last year, the sheriff, former sheriff of Weld County can remind me, we passed a bill punishing the crime of swatting. Crime of swatting is to make a call to send the SWAT team to someone's house, on a false call. And you send them to someone's house on a false call, and bad things happen because that person may have a firearm or they may not have a firearm, but they may pick up a stick or a crowbar or something because there's people outside their home and they haven't committed a crime. They aren't criminals. If they were criminals, they'd probably be running out the back door or out the ceiling. They'd be doing the El Chapo escape. But if they're just peaceable individuals, even reasonably peaceable individuals, and someone comes knocking at their door in the dark, and they won't knock quietly, and they have firearms, you might pick up your own weapon and go to the door, uncertain about who might be on the other side. I don't know whether the senator from Fort Collins would be inclined to do that if there was a knock on her door at 5:30 in the morning. I'd be inclined to do that. And law enforcement, I think the former sheriff of Weld County would tell us that law enforcement is trained to be on their guard for someone who's armed. And we hope they're trained to hold their fire, but we know that they are in danger. We have created by this red flag bill the most volatile of situations. It would be a far better approach, and we have argued for it today, to authorize the no notice confiscation only when the court makes specific factual findings about why that would be needed. You know, no-knock searches are generally required to have special circumstances, but that doesn't seem to be the case at all here. We haven't really answered that question. I've suggested today that you're going to see no-knock searches. But even if they are by knock, that knock at 5:30 in the morning, that knock at 11 o'clock at night is going to be a volatile situation. There's another danger, and I think this is given too short a shrift, because some of you have talked about how cunning and calculated the perpetrators of domestic violence can be. And indeed, they can be that way. They can be smart. And if we already know that nearly a third of these confiscation orders are issued against innocent people, and that will at least be that high on an ex parte basis, we know that you will end up disarming innocent people. And there may be a reason. I certainly know myself personally, I suspect others of you do, know of people who have a firearm because of a specific threat. And if they are deprived of that firearm, they are vulnerable. You know, it's no secret that many gun control advocates generally oppose firearms ownership. The argument in the Heller case, which someone from this side of the aisle argued earlier today, I think it was probably the senator from Lafayette. The arguments in the Heller case, those who argued for the idea that one could not own firearms in the District of Columbia, contended that the founders had not intended the amendment, the Second Amendment, that is, to protect the right to possess guns for self-defense and hunting. That there's no constraint on firearms regulations. So, oddly enough, this prevention of self-defense, this taking of firearms from innocent people, is almost a feature, not an infirmity with the red flag bill. A lot of people argue that the harm is only going to last for 14 days until the respondent gets a hearing, and that's you know, de minimis or something. But there are harms. When one might be the victim of an angry spouse who might say, you know, she said she was going to shoot me. She wished I was dead. And she owns a handgun, Your Honor. I, John Smith, being an adult of 18 years of age, do solemnly swear that my former spouse said she wished I was dead, and if she saw me again, she might very well shoot me, and I know she owns a handgun. And I so swear, Your Honor, on the preponderance of the evidence. Is that sufficient? Maybe maybe the ex-spouse who'd like to get at her because that divorce settlement is going along and it's being expensive, maybe he gets a friend to say, well, to corroborate that even, and say, yeah, I heard her say that several times. Probably forget to say, and he wasn't worth killing, but that's a joke, by the way. You see how easy it is? You can disarm the innocent. You know, a fair law would be one that ensured that arms were confiscated only from dangerous people and not from innocent people who are targeted by domestic abusers. But that's a real possibility here. I think it's been given short shrift. As I've said earlier, in Connecticut, this kind of an order can only be filed by law enforcement officers. Any person can meet with a law enforcement officer. Any person can make an appointment, a family member, a former dating partner, neighbors, co-workers. Abroad, I suppose any citizen at all with enough reason can go to law enforcement in Connecticut and say, I think that we need a red flag order. This person's a real danger. And then law enforcement conducts its own investigation, as is their job. Thank you. And if they find it warranted, because this is the way they are trained, to go out and gather facts, take them to the court. If they find it warranted, then they can file a petition. In Indiana, it's the same. Only a law enforcement officer can seek a confiscation order. Vermont, which is a recent adopter, requires that the petitions come from the state attorneys or the office of the attorney general. Again, people who are trained in the law and to do investigations and find facts. Unfortunately, this model of a red flag order has a very wide range of private persons, to the point that someone that a respondent may have lived with many years ago, and they may still have tension, who knows, could have their firearms taken from them. Now, I think this is born of the fact that some worry that if law enforcement officers are the only ones who can file the petitions, then the officers are going to somehow shirk their duty to follow up on a citizen request. But what's happened in Connecticut indicates otherwise. There are certainly lots of petitions in Connecticut, and even after independent investigations, there are innocent people who are found to have had to have their weapons confiscated. Now, the senator from Lafayette has indicated, well, ex parte hearings happen all the time. Well, lots of things happen all the time. We pass laws to stop all sorts of things that happen all the time that are wrong. Really, the thing about ex parte orders is that in federal civil procedure and state civil procedure, when a plaintiff seeks a TRO, temporary restraining order, on an ex parte basis, the plaintiff has to say to the judge why the defendant was not notified. I need an order, Your Honor, and I need it now, and I didn't tell the other party that I was going to you. I didn't tell them at all. I didn't call them on the phone. I didn't send them an email. I didn't try to contact them in any way. And if the court grants that order without any notice whatsoever on a true ex parte basis, under the federal rules of civil procedure and our state rules of civil procedure, the court has to explain why it was necessary to issue the order without notice to the other party. We offered the amendment to you, and it was rejected. You know, Vermont has a pretty good way to deal with this. The ex parte confiscation is issued when there are specific facts to show that the respondent poses an imminent and extreme risk of causing harm, not just sometime in the near future. We use this term, the near future. You know, I thought the near future was one thing when I was 25, folks on the bench, and I think it's a lot different now that I'm, well, another age. The near future gets nearer. You know, sometimes when a plaintiff seeks a temporary restraining order, the judge decides that the most prudent course is to neither grant nor deny, but to schedule a hearing where there's notice and an opportunity to be heard. You know, the purpose of temporary restraining order and ex parte orders is to preserve the status quo. That is an important thing we have not talked about here today. These ex parte orders don't preserve the status quo. They upset the status quo. They go into someone's home and take their property. The status quo would be simply to prohibit the respondent from further acquiring firearms. It shouldn't allow the taking of one's property without notice, without due process of law. And if there is a need for confiscation before a respondent can appear in court, the judge ought to be able to do that. That would be fine. I recognize the concerns that my friends have, but there ought to be specific findings of imminent threat, imminent risk. These orders, they're called extreme risk protection orders, so they ought to be about extreme risk. The title of the bill is extreme risk, but the text of this bill is opposite. You see terms like significant risk, of harm in the near future, not imminent. You know, one of the reasons that, and again, I make some conjecture on this point, but after some study of the matter and discussions with colleagues, one of the reasons that the mental health route is not pursued, and we have this red flag bill leading, is because mental health 72-hour holds talk about imminent harm to self or others. There's a little bit more. Now, you don't have to go to court for a 72-hour hold. That's an interesting thing. That is an interesting thing, that we could remove a person as a threat altogether by a mental health 72-hour hold, but would require a psychiatric professional to make a really firm and strong judgment of a professional nature about imminent harm. This was the extreme risk protection that my friend and colleague from Sterling tried to offer earlier today. There was no interest. We've talked a little bit about the concern that these orders can be given by affidavit, but if you notice, we talked about the telephone hearing. A petitioner doesn't need to show up in court ever for these orders. Ever. They don't even have to Skype with the court. I can't get a remote notary without doing Skype or FaceTime or something, and that's a big debate. Haven't been able to do that for 3 years because of concerns about identity and verification of identity and everything that goes around that, and yet we're going to allow telephonic hearing and testimony. Now, I grant you, in my 30 years of law practice, it has become a good deal more common for a lot of status conferences and hearings to be conducted by telephone and teleconference, and that's good. But we don't have much factual testimony by telephone. It would be required by video today. So the judge is deprived of the ability to see the witness, see the petitioner, and see their demeanor. And we think, know, and believe that looking at someone as they speak with us is one of the guarantees of credibility. There should not be permitted telephonic testimony without a showing of good cause. That the threat is so critical that this person cannot even surface to go to the courthouse. There should be in House Bill 1177 some sort of rigorous procedure to verify the identity of the person on the phone. I mean, there's nothing in the bill that really prevents someone adopting a pseudonym, filing a petition, and if it, I apologize, I don't recall, and I don't see any of the sponsors here to answer if it has to be verified, but verified is with a notary, and I have to tell you, there are 80, I've forgotten what the number is, it's in the thousands of notaries, but you can order a notary seal. You can stamp it, it's a crime, I grant you that. But it's not hard for me to stand here on my feet in front of you at the end of a very long day and figure out how I could file a false petition and have the firearms taken away from someone whose home I want to invade that evening. I could leave them defenseless. The mind reels as I stand here and I think about how this could be used. I mean, if there's false claims made to law enforcement about threats and swatting, there's easily enough. It's like, I'd really like to invade that home over there and take everything that I can, but I know that that homeowner is well armed. Now, I admit it would require a lot to go into that motive, but to go to that trouble and then disappear off the face of the earth. But we have had murders of public officials in this state that remain unsolved. The suspicion of which is that there were criminal elements that were at work. And it's not hard to see how they could manipulate the system of telephonic hearings. If I can stand here and think of it, there are others who can think of it a good deal more. Now, the fact of the matter is that there's much wrong with this bill and the standards of proof and the shifting of the burden of proof. There's not an imminent danger requirement here. It's significant risk. I mean, it was very clever on the part of the drafters, the proponents. I say that with grudging admiration because the difference between significant risk and imminence is light years. I mean, I'd be willing to say a lot more people are a significant risk than there are people who are in imminent danger. I mean, that means you think they're about to explode right now. The fact is, when we ought to require a clear and convincing evidence standard is at the very first action, because after that, the train is rolling. It's going. I do, excuse me, some might hope that I'm losing my voice, but I'm not. I do commend the bill sponsors for requiring the appointment of counsel. I do. I think the fiscal note's way too low. One of two things is true about that. Either the fiscal note is too low, because it's not nearly high enough to account for all the numbers of petitions are going to be filed, or we've underestimated or we've overestimated what we need here, because all I've heard all day long is lots and lots of extreme risk protection orders. Truth of the matter is, nobody knows. I do foresee full employment for another attorney or two in the state to do this particular thing, and to become quite adept at due process arguments before the court, and perhaps eventually an appellate case to the United States Supreme Court, as I've talked about today. One of the real worries I have about this is the lack of what is essentially a right of cross-examination. I mean, I've never seen a proceeding that allowed for so much hearsay testimony as a statutory matter. All of these affidavits are hearsay. Friends to my right, most assuredly, your left, let me say that one more time. All of those written statements that are presented to the court are hearsay. And in any other judicial proceeding, they would be inadmissible. But we're going to allow their use to create the basis for invading someone's home, because that's the trail. You know, the United States Supreme Court has said that cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of truth. The ability when someone says, My housemate is a threat. He said he would kill me. I thank the senator from Denver. This use of affidavit testimony, the reason we don't allow hearsay is because, among other things, but a big one is that you can't cross-examine a piece of paper. A piece of paper says something, and you say, well, what did you really mean by that? When he said he would kill you, was did he have his fist in the air? Was he on the other end of the phone? Was it said in a threatening manner? Were you on the basketball court? Under this model, the petitioner need never be seen by a judge or the opposing counsel. Think about that. The petitioner only needs to send a written statement that says, all of that, so help me. Can make a telephone call in an ex parte hearing. When the later hearing takes place, just mail it in. My friend Professor Kopel aptly says in his testimony, and again, I cannot give him enough credit for these talking points this evening. It's a very scholarly piece. He says it's a sham of due process. It is a sham of due process. An attorney who can't cross-examine an adverse witness cannot function effectively. Now, my friend and colleague from Fort Collins mentioned earlier today about the what I'll call corollary effects of these orders, because these orders they're public. They're part of the court record. Now, if you live in my community, I just read a piece this afternoon that in El Paso County, Colorado Springs, a lot of our economic growth in the past 2 years, and we've had, like everyone else, we've enjoyed a lot, but a good portion of it, not surprisingly for what our community is like, has been in Department of Defense contracting work. High-tech work, but we have many Department of Defense contractors. And many of those employees, if not most, have to possess a security clearance. Believe me, if you have even a temporary extreme risk protection order on your record, you are going to have difficulty with your security clearance, meaning your employment. And for those of you who are concerned about banning the box, you can't tell the federal government they can't ask. They're going to ask. Have you ever been part of a court proceeding that's denied you firearms, et cetera, et cetera? You will be marked for your entire working life. You know, we've all heard horror stories. I have served on Judiciary in the House and Senate. All 11 sessions I've been here. And for all of those 11 sessions, I have received complaints about the judicial system in various ways. But one of the most common, some substantiated, some not. I I asked the department to take a look at every one that I receive, and they do. But allegations of child abuse, sexual assault, domestic violence, discord in domestic cases, all of these come up more than any single matter for those of us who serve on judiciary. And we find complaints of people seeking revenge, perverting the law, using the law to file complaints and false complaints and malicious complaints. This bill, as it came from the House, had a protection, a remedy. Now, this bill still has in it a declaration that malicious false petitions are subject to prosecution. But the odds of a criminal prosecution are pretty low. Even with an affidavit sworn under penalty of perjury, I talked about that earlier today. If there's no witness to he said, she said, he said, she said, she said, however you want it. If there's no witness to that, that's not going to be prosecuted. No corroboration. Won't be prosecuted. Victims of these abusive claims, remember, 1/3 of them turn out to be for people who are innocent. They are dissolved. Those people should be entitled to pursue a civil remedy. They should have a cause of action and civil damages. They have been put through the ringer, and they have been put in a situation where they will have a negative reference on their record forever. Hence, if they go to get a job as a first responder, if they go to get a job, if they try to enter the military, if they are already in the military or in the reserves, this is going to have negative connotation for them. Even if it was only 14 days and it failed to carry the day, they're part of the 1/3 of people we know in the other jurisdictions who never have a permanent order issued against them. Now, we've talked a lot about due process and the denial of due process. I have to apologize to you about our truncated discussion of due process because it is course after course and semester after semester in law school, and for those of us who struggled through law school twice, we've had a lot of due process instruction. Due process isn't one single thing. It isn't a binary thing. It's a set of things, and it's a set of things across the spectrum depending on the level of harm and what you're losing. And so when we discuss the death penalty, we talk about very high levels of process. And when we talk to the senator from Denver, yes, this is about the bill because we're talking about due process and levels of due process. And when you're talking about expulsion from high school, due process is a visit to the principal's office, but there is such a requirement. Really, for suspension, expulsion requires a due process hearing. By the way, expulsion from high school will require more hearing than this will require. In fact, squatters in your home will receive more due process under Colorado law than a respondent in one of these proceedings. Let me say that again, because we did that bill last year. Squatters in your home will receive more due process before they're removed from your home than a respondent in a red flag proceeding will receive before law enforcement goes through their front door at 5:30 in the morning. It got quiet, and it ought to get quiet. That should be sobering to you, that we are extending less due process to people who have committed no crime at all than we do to squatters. In general, due process is a set of things. It's notice. It's having a neutral decision maker, opportunity to make a presentation, opportunity to present evidence, the right to cross-examine witnesses and to respond to evidence, right to representation by counsel, and a decision based on the record. Well, that's the full-up sort of civil due process, procedural due process, if you will. But we fail on the idea of notice. We fail on the idea of an opportunity to make an oral presentation for the ex parte hearing, the opportunity to present evidence at the ex parte hearing, because it's an ex parte hearing. The cross-examination, we fail throughout the proceeding because it can be done by affidavit on paper alone. By hearsay evidence, I can take your property, I can invade your home. Now, I stand to be corrected if the good senator from Lafayette has other references. I made a search, and I do rely on Professor Kopel's very recent research here. There really are only a couple of cases about red flag orders. There are going to be more. There are going to be more. Maybe the 26 county sheriffs in Colorado will help with this. The one case is a Connecticut Court of Appeals case, not a federal Court of Appeals case, but a Connecticut Court of Appeals case. And that particular respondent, unfortunately, and this is terrible, did not have counsel. He was mentally ill. He didn't raise any claims other than to say my Second Amendment rights are violated, and since he only raised the Second Amendment, he didn't raise any due process. The Connecticut Appellate Court said, well, we don't find this to be a Second Amendment violation, and I understand why. I understand why. I'm not sure I would make the case. The Indiana Appellate Court case involved a plaintiff who at least had counsel. Indiana precedent allows the prohibition of dangerous persons having firearms. That plaintiff did argue that it was the seizure of his firearms was a taking. That's a Fifth Amendment complaint. And he said he wanted compensation for that, and the court just said, they sort of blew it off and said, well, taking dangerous property doesn't require compensation. It's like a forfeiture law, but we all know that the United States Supreme Court struck a big blow to civil asset forfeiture a few days ago. Now, at the end, a real problem is with the safe and orderly relinquishment of the firearms. This is a practical problem. You know, basically, the respondent is supposed to immediately relinquish their firearms to law enforcement or an FFL, Federal Firearms Licensee. I don't think 1177 even allows turning them over to your brother-in-law. Has to be law enforcement or an FFL. And then it allows for When law enforcement does it, it allows for the invasion of your home to make sure they got them all, or to get them all on the front end. They don't even sort of have the order, and then if you don't turn some over and certify that you gave them up, then they go. The way this does, the way it's done in 1177 is, if law enforcement does the petition, they get a probable cause warrant and they get to invade your home. As I said earlier, it's an inflammatory situation, particularly when 30% of the orders, temporary orders, turn out to be incorrect. It is the ultimate surrender of one's personal rights at the expense of safety and security. As I've said earlier, and as most of you know, no-knock raids are disfavored in American law. But our House Bill 1177 has no protections against no-knock warrants. No-knock warrants require, in Colorado, the senator from Lafayette will know much better than I, they require a judicial warrant to do the no-knock at the request of the DA. There's no such requirement in the ERPO. It's silent about it. That will be litigated one day after, most likely after, an unfortunate and tragic event. Now, this idea that 364 days is not permanent, I guess I wonder why 364 days, why not 365? There's probably case law and precedent somewhere that says a year is permanent. Or at least 364 allows for some argument that it's not permanent. But the fact of the matter is that the burden of proof shifts. And if I'm going to get my firearms back, I have to prove that I'm not a risk. I have to prove a negative. Members, thank you for your attention the past several minutes, because this discussion summarizes our entire day and what is wrong with this bill. And if you say, well, Bob, why did you take all that time? It was all said all day long. I want there to be a place and a time as I look to the back of the chamber that the people of Colorado knew that this body had the opportunity to hear and to consider the reasons why House Bill 1177, while well-intended, is not good public policy. And so I ask for a no vote on House Bill 1177. Thank you.
Colleagues, dinner is here. There is food on the side of the chamber. Further discussion? Senator Marble. There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L088?
Amendment L088, House Bill 1177 by Senator Marble, amending English Bill, page 15, line 21, strike 12, and substitute 12A, page 16, after line 2, insert 12B if the court denies
Marble.
this.
Thank you, Mr. Chair. I move L088. And this is a very short amendment, but a very important amendment. Basically, protecting those who are falsely accused. It states that if the court denies the issuance of an extreme risk protection order, but ordered a temporary extreme risk protection order, the court shall destroy all records related to the petition for the temporary extreme risk protection order and the petition for the extreme risk protection order, and remove all associated records from online sources. I believe that this is a very important addition to the bill because these people, these accused, have become the victims. We're all about protecting the victims here in the legislature, and there's no better way or example to show that when somebody has been falsely accused and perhaps denied gun rights, when this order has been issued and the no-knock raid comes to the family's home, it's not just that family there who is affected in such a way that it's just about the guns, because it's not. What happens when the family dog comes out to protect the family who adopted it, who raised it, and that dog doing what it's supposed to do, protect the family, is shot? It happens a lot. Those children become victims. The whole family can never be restored because their lifelong protector and pet has been destroyed when something was issued that never should have been. To give these people in these families as much protection as we can, those records should be destroyed, because any time a court action is taken and there is lots of information regarding civil actions, when we have made victims out of innocent people, they should never have to worry or look at those records again or have to deal with them in such a way that it would bring back, once again, horrific memories of being a target. So I am going to ask for an aye vote on L088, that we protect those victims who have been made of this bill, who have been accused but found innocent, and never have them deal with this again.
Further discussion on the amendment. Senator Court.
Thank you, Mr. Chair. This is already covered. I urge a no vote.
Senator Fields. Okay. The question before us is the adoption of Amendment L088. All those, a division has been requested.
more time for dinner? There will be more time for dinner.
The question before us is the adoption of Amendment L088. All those in favor, please stand and remain standing until the count is taken. You may be seated. All those opposed to the amendment, please stand and remain standing until the count is taken. The chair is not in doubt. The amendment is lost. To the bill. Senator Fields.
Thank you, Mr. Chair. Members, I'm here to try to shift the narrative and focus on the facts. We've been talking a lot about procedures, and we know that we live in a state that is governed by law. It's governed by procedures. But what is lacking from the conversation is a conversation about people. People who are dealing with behavioral health issues, family members, and law enforcement. Let's change the narrative and not talk about some of the things that we have been talking about. I did take some notes. We were talking about banning the box. This bill has nothing to do with banning the box. We should be talking about people who have been harmed by gun violence. We even had a conversation talking about students that have been expelled by schools or suspension rates and what the process is like. But we haven't been talking about people who have been harmed by gun violence. In fact, we haven't even talked about the people who have lost their lives due to gun violence. But we've been talking about a lot of things, a lot of process. And the bill covers all of that. But the main focus of this bill is to empower family members and law enforcement. And we've gotten away and we've shifted away from that very important discussion. We need to be talking about the people. Sadly, in the state of Colorado, we have a crisis that are going on right now as it relates to suicide. The numbers are alarming when we look at the number of young people who are committing suicide. And many of them are using guns to commit suicide. And we're not talking about the children. We're not talking about the youth who have lost their lives due to gun violence. We're talking about a process that is already implemented in 13 other states, and it has not been challenged in reference to the constitutionality. Why aren't we talking about the victims who have been harmed by gun violence? I was just looking through my phone, and I was alarmed by a text that came across. One of the Parkland shooting survivors If you remember the Parkland shooting that took place, it was a student who was expelled, came back to school, and killed 17 of his schoolmates. And the Parkland students have been using their voices to get adults to do something about gun violence. And we're talking about ban the box and due process, and not talking about the harm and the devastation and the trauma that's caused by gun violence. Let's talk about the people. And we're focused on guns. Unfortunately, this survivor, her name was Cindy Aiello. At 19 years old, she survived the mass shooting at Parkland High, but her best friend didn't. She suffered with survivor's guilt. It's only been a year since the Parkland shooting. Her mother says that she was recently diagnosed with trauma related to mental illness because she survived and her best friend didn't. She's gone at 19 years old, and we're not addressing the epidemic as it relates to suicide. Can you imagine having to step over your schoolmate to trying to escape an active shooter in your school? Of course she's going to have some trauma associated with that. She's gone. Who knows how many other students from the Parkland shooting who are dealing with the post-traumatic stress after seeing the type of bloodshed and wanting adults to do something. This House Bill 1177 gives us some tools to help us do something. This young lady lost her life, and she did use a gun. We need to shift the conversation, because it's my understanding that young people in the state of Colorado, through the Healthy surveys that we do, are experiencing sadness more than 2 weeks out of a 30-day calendar. They're coming to school depressed. Our teachers see it. The resource officers see it. The neighbors see it. The family members see it. And sometimes people act out their behavioral issues in all kinds of ways. And sometimes you need people to intervene. And that's what House Bill 1177 will do. It will empower family members to get some help. And when law enforcement encounters people with behavioral health issues, it gives them the tools to save lives. This is not going to cause any harmful matters or issues for those who have guns. I would really encourage that you shift the narrative and let's focus on safety and those who are using guns as a way to maybe harm themselves or others. That's what the conversation should be about. And so I'm going to close with some statistics. Colorado is in a state of urgency as it relates to child and youth behavioral health. Overall, Colorado ranks 33rd as it relates to providing behavioral health services to kids and youth. 1 in 3 in Colorado is experiencing sadness. Suicide is the leading cause of death among youth between the ages of 10 and 24. And our behavioral health system is not keeping up and keeping pace. And this is just one small tool, one small strategy to help intervene when people are in crisis. This is not harmful. This is the right thing that Colorado should be doing, and I urge and I vote on 1177.
Further discussion? Senator Hill.
Thank you, Mr. Chair. Colleagues, we've had some discussion about what law enforcement thinks about this, and I know a few have weighed in, but I think this matters because one of the aspects we haven't talked about are those who actually use guns or are involved with guns for a living, and that's both our law enforcement and our military personnel. And I would like to talk about that some more, but I think it's important to put on the record what some of our very own sheriffs have actually said about this. Look, at the end of the day, they're going to be the ones responsible for enforcing this. In many cases, some of the previous speakers have highlighted how this bill potentially puts some of our law enforcement at risk, who now have to go out and serve these orders in cases where, whether it's in our rural areas or not, in cases where this is unwelcome. And whether it's unwelcome legitimately or not, it still is unwelcome. Montezuma County Sheriff has said, "This is directed at a piece of personal property and not a human life. There needs to be some intervention, but this is the wrong way." Garfield County Sheriff says, "Although I understand and support the intent of focusing on dangerous people with mental health issues and violent crime, this bill is not the answer and I oppose it." Weld County Sheriff says, "I can't enforce a law I believe goes against our state constitution and our federal constitution." Delta County Sheriff says, "I believe this bill is overreaching without any checks and balances that would keep it from being abused by both citizens and potentially law enforcement." El Paso County Sheriff said, "I'm challenging the law based on the Constitution of the United States." Fremont County Sheriff says, "I cannot support this bill as it is currently written." As it currently is written. Larimer County Sheriff says, "I oppose the bill and I call on the legislature to go back to the drawing board and improve the involuntary commitment laws and fund the mental health services necessary to protect our community." Mesa County Sheriff says, "This bill does not make law enforcement professionals or our Colorado citizens safer, and I will continue to work to find an alternate solution to assist those in crisis without targeting firearms." Sedgwick County Sheriff says, "I feel instead of violating someone's due process, we should be working on the underlying problem, which is the mental health aspect." Colleagues, I bring this up because one of the significant areas we haven't talked about at all today is how this will impact our military. It is no surprise to us. In fact, most people in the room, not that most people are in the room, but of the people in the room, most people know the stat of 21 or 22 veterans committing suicide a day. Almost everyone has mentioned that statistic at one point or another. This is a significant challenge that we face, and yet it's also faced by a group of people that interact with firearms on a daily basis, sometimes are required to use firearms as part of their job. And one of the challenges, I think the real limitations, one of the risks I think this bill poses is to create a necessary tension between those in our military seeking to get help, those of our veterans seeking to get help, and their identity and sometimes their work involved with firearms. And right now, the way this bill is written is, if they come forward to talk to a friend about their challenges, and that friend reports them, and they know that friend reports them, maybe just trying to get them help, there is a chance that an extreme risk protection order is put out on one of our veterans. And the way the bill is written, if you look at page 6, line 27, so this is how the pleading should be filed. It has the following statement: to the subject of this temporary extreme risk protection order, this order is valid until the date and time noted above. You may not have in your custody or control a firearm, or purchase, possess, receive, or attempt to purchase or receive a firearm while this order is in effect. You must immediately surrender to the insert name of law enforcement agency in the jurisdiction where the respondent resides all firearms in your custody, control, or possession, and any concealed carry permit issued to you. A hearing will be held on the date and at the time noted above to determine if an extreme risk protection order should be issued. Failure to appear at that hearing may result in a court entering an order against you that is valid for 364 days. An attorney will be appointed to represent you. So it doesn't have to do just with ownership. It has to do with any kind of possession or custody or control of a firearm. And so here's what we're looking at. For our infantry officers, for our veterans in Colorado Springs, associated with Fort Carson, maybe some up here at Buckley, but I know it's a big issue at Fort Carson. Anyone in this situation is now banned. They are going to be banned by court order from any further interaction with their unit, any further interaction with their platoon, their brigade, their BCT, any opportunity for them to control or to possess a firearm, whether it's on the range at Fort Carson, whether it's on a temporary deployment, whether it's on a training exercise at Fort Bragg, whether it's at Benning in Georgia, they are going to be violating this just in the line of work. And we know for folks, especially for our veterans, when they have these issues, one of the most damaging things you could possibly do to them is take them out of the camaraderie, the support structure, the identity of the uniform, and their task within that uniform as part of a team. In fact, that's often one of the greatest causes for the mental challenges that many of our veterans face when they come back. They are used to the crucible of combat. They are used to the camaraderie of their colleagues, and you come back and normal life just can't compare. And this is not new to our generation. It's not new to our age. It's happened for all of recorded history. In fact, there's some very moving stories about that in World War I think it's worth sharing. And in many cases, we see that the connection and the community that the veterans came back to from World War I that was so much stronger than we have today is perhaps one of the reasons why PTSD wasn't such a significant issue at the end of World War I. However, we are setting up a system, we are creating an environment whereby many of our veterans, knowing this is in place in Colorado, I fear will be tempted to further repress those, to not say something to a friend, or a colleague to not bring it up for fear that the price of them doing so, the price of them going to get help, will be to lose the very identity and the very connection and the very camaraderie that they have. And even if they were to try to maintain that place, that connection within their unit, they can't train with them anymore. They can't shoot with them anymore. Now every time they show up, every single person will know, oh, hey, Owen is on this list. He can't handle a firearm anymore. He's not allowed to be around it. And even further stigmatizing that person, pushing them farther out of the camaraderie and the connection and that which may be the only thing helping them keep it together. We are creating an environment where our veterans who are struggling are no longer able to train and be and serve with their team if they come forward and address some of their challenges and say and do exactly what all the literature out there says they should do, to come out and be proactive about it, to talk to somebody about it, to bring it up, and to look for that kind of help. The second they start looking for that kind of help is the second they are at risk of being petitioned into an extreme risk protection order where they have to come and now prove in court with clear and convincing evidence that they don't deserve it. After having been stigmatized, after having been outed to the rest of their group, after having been pushed out of potential training, after having the embarrassment of their life tools, their life or death tools that they use on a daily basis, being taken from them. And that is why, Mr. Chair, I will offer Amendment 87.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L087?
Amendment L087, House Bill 1177 by Senator Hill, Min, Grosville Bill, page 6, line 27, strike firearm and substitute firearm except for firearm necessary to conduct any military employment-related duties, page 15, line 1, strike firearm and substitute firearm except for firearm necessary to conduct any military employment-related duties.
Senator Hill.
Thank you, Mr. Chair. I move Amendment 87. And to the amendment, Mr. Chair, Amendment 87 recognizes on page 6 that, all right, we will deal with this on the firearm side. However, if this is part of your line of duty, if this is part of your work in conducting military and employment-related duties, that identity, the connection, the camaraderie, this does not apply. If you're concerned for their health, you're not going to kick them out of their unit. If you're concerned for their safety, you're not going to take away their source of connection and camaraderie. Colleagues, I ask for your support on Amendment 87.
Further discussion on Amendment 87. Senator Pedersen.
Thank you, Mr. Chair. And this is not a friendly amendment. Our people who are in the military are going to be held to the same standard, that if they are at risk to themselves or others, that they should not have access to weapons. This is not something any of us should want for anybody, even if you're in the military. And so I ask for your no vote.
Senator Lundeen. Senator Foote.
Thank you, Mr. Chair. And one thing that I would add is, again, we've been talking about throughout the day and on various amendments that that much of this bill is informed by our current systems that we have in Colorado. It certainly doesn't mirror those exactly, but it's informed by those. And one of the systems that we have in Colorado now allows for a temporary protection order that's filed in a civil sense. If, say, in a domestic violence context, the victim of domestic violence comes in and says that they want a temporary protection order, the court would then grant it. It could later become a permanent protection order. But as part of those protection orders is a prohibition to possess firearms. And so even in the civil context now, in the civil protection order context now, it applies to everybody. There's no similar exception to members of the military or members of law enforcement that use their weapons or possess weapons on a daily basis as part of their job. There's no exception in Colorado law for that, for protection orders, and there shouldn't be an exception in this case either. So I would also ask for a no vote.
Senator Lundeen.
Thank you very much, Mr. Chair. So I have not had the honor or the distinction of having served in the military. So I can't speak to this from a personal perspective, but I can speak to it on behalf of other members of my family who have served, for friends who have served. I can speak to it with a kind of a somewhat removed but connected at the same time sensitivity to what this particular set of difficult circumstances might do, and quite frankly, the additional compounding negative effects that could happen out of this that, quite frankly, are potentially completely unnecessary. And it's so much of what this bill is about is that potential. When we bring a piece of legislation, we always envision we're going to solve a specific problem, and we're going to do it by the force of law. And the reality is, sometimes you can solve that specific problem by the force of law. But the reality is, there are probably 359 other degrees of a compass of individuals that are not that specific case you're trying to solve. They're near it, and some are oblique to it, and some are the exact opposite. It's all those other people that we need to consider when we're writing laws, because it is, in fact, the people that we're working for. But we're not just working for the specific instance that is the perfect fit for exactly what that law was supposed to do. It's all the other people that we wander into their lives, and we intrude on their life and their behaviors and their hopes and their dreams and what they're doing in a way that's either inappropriate or sometimes completely offensive. And that's what this amendment speaks to. A circumstance where individuals are essentially being asked, after having given of themselves, being gone from their families, being deployed frequently to hostile conditions in a foreign land. They come home and we say, we want to take from you, under circumstances that may be correct, or quite frankly, my concern is more often than not, incorrect. We want to take from you, under those incorrect circumstances, something that is as close to you, as dear to you, as important to you, as I don't know how to describe it. It's as if we're saying we want to take your right hand, or if you happen to be left-handed, your left hand. We're going to take from you something that is that near, dear, and intrinsic, that's the word I was looking for, to who you are. This amendment says, not so fast, bucko. There are circumstances where it's completely inappropriate to do that, especially given the challenging, lack of diligence process that the bill already frames up. So, it's not the exact perfect circumstance that the bill seeks to address. It's all the other conditions. And quite frankly, that is our responsibility. We cannot forget all those other people and the ways that we will intrude into their lives inappropriately. And that's what this amendment seeks to do on behalf of those who've put their lives on the line for our safety, for our rights, for our future. And so I urge you to seriously consider, please seriously consider Amendment L087.
Further discussion on the amendment. Senator Heisey.
Thank you, Mr. Chair. Like my neighboring senator, and we share a boundary in El Paso County, I too have not had the honor of serving. And while I really respect and appreciate my veteran friends and those that are serving actively in the military now, I've never donned the uniform. However, there was a time that I was spending enough time at Fort Carson that they started kind of joshing me a bit about measuring me for a uniform because I was out there so much. I rise in support of L087. The military is a unique body unto itself, and In previous sessions, this body has recognized that. They have approved veterans courts. They have proven to be very, very successful. If there are issues that rise to the level of law enforcement getting involved, the veterans are directed to a veterans court. They have a mentor that is assigned to them, a veteran, who they speak the same language. They can talk about the same things. They know what they've been through, both in deployment and here at home. They understand each other, and they can talk to each other in a way that I could never have that bond with a military member when they want to talk about what they've been through, what they've seen. I also know that the military, Fort Carson in particular, because that's the one I'm most familiar with, the military has pre-deployment counseling. They have post-deployment counseling for when the service member comes back and they reunite with their family and the dynamics change in the family. And if an incident comes up or someone is concerned but it hasn't risen to the level of law enforcement yet, they have internal ways to work with these people. If they need to be removed from their home, they are removed from their home. They spend the night in a separate location. They're able to see their family, but they spend the night in a separate location, and they're counseled, and both parties go through counseling. The military occupation is one that is just so different from anything else that we have in our society, that unless you've been there, unless you've been part of it, unless you've witnessed it, you really don't understand just exactly how it works. And I believe this amendment is an amendment that we should all support, and we should not take away the right of someone who's had a stressful deployment, had a little tough time adjusting when they get back home. This is what they signed up for. It's an all-volunteer service. These are people that want to dedicate their lives to our freedom and keeping us with the way of life that we have currently. And we don't want to take that away from them. And we don't want to take that away from America. So I would urge you all to support Amendment L087.
Further discussion on the amendment. Senator Rankin.
Thank you, Mr. Chair. Well, I was a soldier, and I did live with a culture of guns, and my fellow soldiers think about guns differently than someone who might live in an urban environment and never had guns. I also grew up with guns, and I represent people who live in a culture where guns are a normal part of everyday life. Believe me, if the civil authorities interfere with what the military authorities are very good at, which is taking care of their families and their soldiers, if that interference happens and one of our soldiers is, has this stigma of not being able to deal with firearms or guns, it will ruin their career. And these are wonderful people who devote their career for low pay, dangerous jobs. I mean, this amendment will protect those people who we depend on, those soldiers. And believe me, the guys I served with would be very traumatized if they got caught up in this system. So I urge your support for this amendment.
Any further discussion? Senator Hill.
Thank you, Mr. Chair. Colleagues, just to explain a little bit more about the military culture and the difference and the challenges between bringing civilian authorities into something that the military actually already has means for addressing. If the concern is that, well, they're just like anybody else, if they're a danger to themselves or others, then this should apply. Well, guess what? There's actually processes for that within the military. This would be additional and on top of it. But if your concern is that they're a danger to themselves, let's be honest, every single military member is a danger to themselves. Jumping out of a perfectly good airplane is a danger to yourself. Showing up at a forward operating base in Afghanistan is a danger to yourself. Driving a convoy through many parts of the world is a danger to yourself. Disarming explosives is a danger to yourself. Flying airplanes way too fast is a danger to yourself. Routinely handling explosives is a danger to yourself. You get the point. Every single one of our military members signs up and is committed every single day to doing things that are dangerous. But now when you say that the consequences of those actions and the sacrifice, and I define sacrifice as my mother gave to me years ago, and I love this. I love this idea. Sacrifice is giving up something you love for something you love even more. They sacrifice, they give up that safety, they accept that danger to themselves for something they love even more. And usually, believe it or not, that something you love even more, yeah, there's the esoteric ideal of freedom and opportunity in defending your country, which is absolutely important. But part of what ensures that, part of the structure and the environment that keeps that mindset going, the mindset that looks to something that is ethereal, is camaraderie. This is why you train together. It's why we spend so much money to make sure that we don't leave a single bit of human remains on any battlefield ever. And to this day, we are still repatriating human remains from parts of the world from 20, 30, 40, 50, 60, and 70 years ago. Why? Because there's this essence of camaraderie. The essence of camaraderie is what perpetuates the marching at the tomb of the unknown soldier. The camaraderie that says, come rain, come sun, come sweltering heat, come snow, come ice, damn it all, we will be here in camaraderie and solidarity with our brothers and now indeed our sisters in arms. That's the camaraderie that keeps people going. And what we are risking by not accepting this amendment, what we are saying is that forget all that. Forget the safety that provides. What's more important to us is that civilians somehow can come in and solve your problem, that you are a danger to yourself. This to people who have already proven that they are willing to risk a lot. This to people who have already shown their commitment to a greater ideal. Now we're saying, no, forget all that. You are going to be at risk if you come forward and seek for help within the context of the military, within the context of dealing with the challenges of the multiple deployments and the ops tempo and the difficult things we've seen, and dare I say even more deeply, the reality that war brings that necessarily makes us confront the potential evil inside of each and every one of us. We are saying we can take all that away from you without due process, just because someone else says, I'm concerned about them, maybe in good intention, maybe saying, hey, we've got to get some help for this person. But rather than using the military means of doing that and the strong structure of camaraderie, we're saying, no, we 35 senators in here, we know better than all that. We know better what that process should look like. Therefore, we are going to step in and make sure there's no exception for you. Therefore, we're going to step in and say, we're going to treat you like anybody else. And yet, on any other day that we're up here, the exact same senators will be down here extolling again and again and again how they're not like everybody else, how they've taken a level of service and sacrifice and risk that puts them above. Colleagues, I can't believe, I know there are different aspects on due process and all this stuff that we've debated here today, but I can't believe that we would say to our military members, it's better for you to deal with our notion on how we view that you should go through this process, rather than respecting the camaraderie and the culture in which you live and the military process for that. I cannot fathom that those of us in here, a small fraction of whom are veterans, would be willing to say we know more than the military system for how to deal with the challenges our veterans face. Again, I ask for your support on Amendment 87.
Senator Marble.
Thank you so much, Mr. Chair. I echo the sentiments of my colleagues before me and come here to support L087. A little bit of insight into exactly the way some military view their rifles. There is something called a rifle creed. Every Marine knows it. I'm going to read it to you, and it'll give you a little bit of understanding of why this amendment is so very important. This is my rifle. There are many like it, but this one is mine. My rifle is my best friend. It is my life. I must master it as I master my life. My rifle without me is useless. Without my rifle, I am useless. I must fire my rifle true. I must shoot straighter than my enemy who is trying to kill me. I must shoot him before he shoots me. I will. My rifle and myself know that what counts in this war is not the rounds we fire, the noise of our bursts, nor the smoke we make. We know that is the hits that count. We will hit. My rifle is human, even as I, because it is my life. Thus I will learn it as a brother. I will learn its weaknesses, its strengths, its parts, its accessories, its sights, and its barrel. I will ever guard it against the ravages of weather and damages, as I will ever guard my legs, my arms, my eyes, and my heart against damage. I will keep my rifle clean and ready. We will become part of each other. We will, before God. I swear this creed. My rifle and myself are the defenders of this country. We are the masters of our enemy. We are the saviors of my life. So be it until victory is America's, and there is no enemy but peace.
Further discussion on the amendment. Seeing none, the question before us is the adoption of Amendment L087. All those in favor? A division has been requested. The question before us is the adoption of Amendment L087. All those in favor, please stand and remain standing until the count is taken. You may be seated. All those opposed, please stand and remain standing. The chair is not in doubt. Amendment L087 fails. Further discussion on House Bill 1177. Senator Lundin.
Thank you very much, Mr. Chair. Many of us had an opportunity to hear a very similar bill last session. It did not proceed into the law books. It, in many ways, was drafted, I think, more friendly to some of the concerns that we've spent so much time talking about today. That is, last year's bill was more friendly. One of the unfortunate things in last year's bill was it called out, with regard to the list of individuals who may start this cascading series of events that either appropriately intervenes in somebody's life or impinges upon the freedom and property of somebody who truly should not be caught in the challenge that this legislation brings. It included among the people who could start that cascading series of events someone in a dating relationship, I think was the phrase. And of course that made almost everyone uncomfortable. They realized that that was probably not appropriate, that in fact somebody could, for any number of reasons, hostility, revenge, whatever, try to get back at somebody whom they'd fallen out of relationship with and use this or that bill, that law, as a tool, as a weapon of emotional damage. And so in this draft, the words dating relationship do not appear. But I would commend you or direct you to page 4, line 3 of the re-engrossed bill, and you'll see that a person in any other relationship described in section 18.6, 800.3, section 2, with the respondent. Well, we do that frequently as we write the laws. We don't write the words that say what we mean. We point at another place in the law and say, that's what we mean, go look there. And so this other person, any other relationship that fits in that category, we have to go into the Red Books to find exactly who we're talking about. And here's how it's defined. An intimate relationship means a relationship between spouses. No one's going to argue that that is a permanent and intimate relationship. Former spouses, less permanent, but still significant. Past or present unmarried couples, becoming even more potentially transitory. Persons who are both the parents of the same child, so something in common, but we don't know exactly how transient or not that particular relationship might have been. And then it goes on to say, regardless of whether the persons have been married or have lived together at any time. So it ends up defining, if you unpack it the way I'm interpreting it, a dating relationship. So we are right back where we were with that very challenging language in last year's bill that was stricken from last year's bill in the drafting of this year's bill, but unfortunately put right back in by reference. I think that that is completely misguided. We've got all of these challenges around the due process or the lack of process that's built into the bill, and at the very beginning of that cascading series of unfortunate events, potentially, it's a spurned lover who's dropping the dime, who's saying, you know what? I've had enough of that person, and I've got a way to get back at them. I call this to your attention simply to say, I don't think that's really where we want to be. Now, I have another concern I would like to share with you, and that has to do with what exactly happens to any firearms that are confiscated, are taken, there is a pathway to giving some people greater comfort as to the custodial relationship, the care for those firearms after they've been confiscated. And it is characterized in this amendment that is now at the desk.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L075?
Amendment L075, House Bill 1177 by Senator Tatum, re-engrossed bill, page 20, strike lines 20 through 26, and substitute.
Chair Lundin.
Thank you, Mr. Chair. So this amendment says, in addition to the pathway.
Chair Lundin, please move the amendment.
I'm sorry. Thank you very much, Mr. Chair. The hour is late. My mind is weak, but my voice is strong. Fair enough. Mr. Chair, I move L075, and I will tell you about it if appropriate.
To the amendment.
Thank you, Mr. Chair. So, in addition to other custodial places that the firearms may be taken, this amendment would allow for the transferring of the firearms to a third party who does not live with the respondent, that's the person in question that we're concerned about, after confirming through a criminal history records check that the third party is currently eligible to own or possess a firearm under the federal and state law. The purpose of this is to provide some degree of comfort that the firearms aren't going to go someplace where they're going to get marked or recorded or dealt with in some way that would be inappropriate or certainly discomforting to the individual. So I urge your support of this, again, as a teeny effort to make a challenging piece of legislation a little bit better.
Senator Court.
Mr. Chair.
Thank you, Mr. Chair. This is unnecessary. I urge a no vote.
Is there further discussion? Seeing none, the question before us is the adoption of Amendment L075. All those in favor say aye. A division has been requested. The question before us is the adoption of Amendment L075. All those in favor, please stand and remain standing until the count is taken. You may be seated. All those opposed to the amendment, please stand. The chair is not in doubt. The amendment is lost. The question before us is the adoption of House Bill 1177. Senator Woodward.
Thank you, Mr. Chair. One of the questions that's been raised recently is, are we focusing on the people? So I wanted to make sure that we bring this back to the question about how this will affect the people. We heard a lot of statistics about people in mass shootings who were affected nationwide to frequently and oftentimes to the detriment of our society as we see deaths. However, it's too bad that these red flag laws don't actually make any difference. The two most recent high-profile shootings are probably the Aurora, Illinois, and the Thousand Oaks, California shootings. Guess what both of those states have in common? Red flag laws. Guess what those red flag laws did to stop those mass shootings? Nothing. Colorado already allows loved ones to petition the court to commit someone to a psychiatric facility with a 72-hour hold if they represent harm to themselves or others. If these red flags were so pronounced, why did the families in those instances not already take advantage of those laws that are on the books? In the same way here in Colorado, if we believe that there is an issue, that someone has a mental health issue, we can bring them into a mental health hold.
Not that it matters, because like so many other times when red flag laws are pointed to as solutions, we can see that such solutions already exist and they aren't used. The Parkland killer was not arrested and charged with domestic violence prior to his killing, a charge that would have barred him from buying a handgun in the first place. The Aurora shooter was a convicted felon and should not have had a gun at all. Time and again, we see laws on the books fail, not because they're weak, but because they're not used. So all of a sudden, we lawmakers think we have to pass another law as a knee-jerk reaction when we already have laws on the books that can do much of the same thing that we're talking about, and in fact, take care of the person and not just confiscate a piece of metal. I looked back to see how these red flag laws were implemented. I looked first to the state of Maryland, which just last October put its own red flag law into action, and within 1 month, they had executed 114 petitions to take people's handguns. So 100 ERPOs within the very first month, and already by the end of that first month, they approached a man who had not committed a crime, who had no reason to be believed was an issue. When the police approached him, he did not know what was happening. He got irritated at the police, and that escalated and resulted in his death. Those are the kinds of escalations that we'll have if we allow this to proceed. While we've been in debate here today, I received an email from my local sheriff, and he asked me to let you know what he and the Board of Commissioners up in Larimer County had to say about this issue. Dear legislators, we would like to express our serious concern with House Bill 1177, the red flag gun bill now being considered in the legislature. This bill proposes a process to seize firearms in certain situations in which a person is deemed to be a danger to themselves or society. Anytime we are contemplating government seizure of persons or property, it is inherent that we assure Fourth Amendment rights guaranteeing the reasonableness of the seizure and 14th Amendment rights guaranteeing due process are honored. House Bill 1177 proposes implementing new civil processes for the government to seize private property, and there are good reasons to question the constitutionality of these procedures. As drafted, this bill may escalate rather than de-escalate volatile situations. We do not support a law that increases the risk of police agencies getting into shootouts with citizens who have not committed a crime. This bill makes that a very likely possibility. Further, it includes some very questionable as well as some clearly unconstitutional aspects. For instance, it creates search warrants that order police officers to forcibly enter premises and seize a citizen's property with no evidence of a crime. Over the last several decades, we have come to recognize that we need to be more, not less, judicious how we use force in encounters with those suffering mental health issues. This bill represents a 180-degree reversal of those actions which are showing favorable outcomes. Additionally, the bill requires police to seize firearms that may be mutually owned by family members, depriving them of their right to their property. This current bill also puts the burden on citizens to later prove they are fit to have their firearms returned. This burden belongs to the state, not to the citizen. A better approach would be to improve the involuntary commitment laws and fund mental health services necessary to protect our community. Larimer County and the state are increasing funding rights now to get at that need. We remain concerned with current state laws and procedures about involuntary mental health holds. While peace officers have the authority to place involuntary holds on those who they believe are an imminent threat to themselves or others, all too often we find them released from the hospital within hours with no treatment. Even that system is broken. So this is where we need to concentrate our efforts to improve public safety. As a board of county commissioners, we feel compelled to share our concerns with you as this proposed procedure directly impacts the operations of local governments, since these orders would not be carried out by state troopers or CBI agents, but by local sheriffs and police.
Is there further discussion? Colleagues, if you wish to speak on the bill, please be ready and in the well. Sarah Lundeen.
Apologize for my delay. So, I conclude, as we began, in agreement that a safer society is something we all want. The challenge with this particular conversation and this particular legislation is we start there and then we pivot immediately to an abdication of our freedoms, to an abandonment of our personal liberties, to a forfeiture of our private property without appropriate due process. And we do it all in the hope of a safer society. But here's a question, and this is the sort of question we need to think about. Any deliberative body should think about this. What are the freedoms and liberties and constitutional protections that protect everyone that we are willing to give up in order to hone in on a single, narrow, individual situation? That is dangerous, my friends, that we give up universal rights and freedoms and processes that are the hallmarks of this incredible country. The country where they said, let's do an experiment. For the first time ever, let's make the people sovereign and the king, the government, the servant of the people. You lose that sovereignty. You lose that authority where the people, in fact, are above and the government serves them, when you walk away from your freedoms and your liberties and your constitutional protections. This is a very philosophical argument I'm making, but it's an important argument, I would say, that we must protect due process, we must protect our rights if, in fact, we truly want to be safe. Sadly, this bill, in my opinion, is a misguided, ends justify the means, headlong rush. Now, we have had some very uncomfortable slowing in the last few days of the headlong rush that we seem to have had in this building running into this week. As we leave this week, it seems as though we've slowed to a slightly more deliberative path and process and tempo. As uncomfortable as that is, as much as I'd rather be home right now, I think it's important that we take the time to think through, work through, and talk through these really important issues. To the bill itself, I really have heartburn, and it's not from the wonderful empanada I just had. I have heartburn over the fact that this bill, essentially, when you look at it broadly, says you're guilty until proven innocent or proven sane. And you got to climb a wall of more challenging evidentiary standards as you work to fight back to your innocence or the definition of your sanity. I also have concerns, as you heard, about the array of individuals, some of whom may have been fairly casual in an individual's life, who can raise concerns, who can, as they say colloquially, drop the dime, possibly as a tool of revenge or vindictiveness. That is not a good place to start. And then the challenges get worse as the process of people, individuals that we're fighting on behalf of, we're trying to understand, their rights may be trampled upon. Here's another piece that I had not thought of, and I'm grateful for the debate today and grateful for the insights of my colleague from El Paso County. I think that this bill as drafted has the potential to create a significant expansion in the power of law enforcement. Well, I'm a law enforcement kind of guy, and generally I'm very, very comfortable with a strong and stable law enforcement. However, when we move forward into a philosophical idea of preventive punishment, I start to think of that movie that was popular a while back, the Minority Report's the name of the movie. Who's the actor? Tom Cruise. How dare I forget Tom Cruise's name? It was a dystopian future. That means it's a bad time that's somewhere ahead of us. But this bill, I will tell you, is the edge of that dystopian future. In that movie, billboards looked into people's eyes and understood who they were and what they were thinking, and took judgments and stepped into their lives, intervened, and prevented them from executing crimes. Does that not sound like this bill? In fact, it does. But quite frankly, that is not my primary objection to this bill. My primary objection to this bill is it does not address the root issue that we all know underlies the problem. And that is the challenge and the problem of mental health. So not only are we writing bad policy, we're leaving people out there who still need our help. And all we're doing is intervening and confiscating a narrow subset of the property they have with which they may be able to do harm to themselves or harm to others. Yet we leave behind other elements of their private property with which they can do equal or greater harm. What is the sense in that? So that is my concluding thought on this bill. Shame on us for starting out saying we're going to help somebody who is having a mental break, who is having a crisis in their mental health, and then we pivot to confiscating property instead of getting them the support that they need. I oppose this bill strenuously.
Colleagues, I'm going to remind you that according to Mason's Manual of Legislative Procedure, a member who resorts to persistent irrelevance or to persistent repetition after the attention of the House has been called to the matter may be directed to discontinue speaking by the presiding officer. If you bring up Minority Report or Tom Cruise again, I'm going to shut you down. Senator Woodward. Senator Lundin.
I promise I will not say the names that you said I cannot say, Mr. Chair.
Senator Woodward.
Thank you, Mr. Chair. When I read a letter a few minutes ago from the Larimer County Board of Commissioners, I forgot perhaps the most important thing, and that is it has the unanimous support of our Sheriff, Justin Smith, and our 3 county commissioners, Tom Donnelly, former Senator Steve Johnson, and former Senator John Kafalis. So I think bipartisan support at the county level, I think the wisdom that our 2 former senators have in retiring from this House, when they get back closer to the people, I think that they understand that what's important is people, not these policy and ideological efforts.
Senator Gardner.
Thank you, Mr. Chair. So we're in the evening stretch. It's kind of like the back stretch of the quarter mile that I used to actually run when I was younger and slimmer. Members, bills like House Bill 1177 inevitably, I think, have technical corrections that have not a great deal to do with the merits of the bill itself. And one of those is, excuse me, one of those revolves around the question of who actually serves process when process is served here. The bill refers to law enforcement agencies and law enforcement officers. The city of Colorado Springs came to me and said they were concerned that the implication of the bill was that police departments were to get into the business of serving process, and as the former sheriff of Weld County will tell you, that is a sheriff department duty. And office, that's right. I stand corrected from the back of the room. I keep saying a sheriff's department. It's an office. It's a high office. To correct this technical error, and members, I do not think it changes the bill substantively at all. There has been some discussion about whether or not it is necessary, but it is necessary enough that my major city, surely the equal of Aurora, is concerned and has asked for this amendment, which is...
There is an amendment on the desk. Mr. Carpenter, please read Amendment L084.
Amendment L084.
Senator Gardner.
Thank you, Mr. Chair. So I move L084, and as I say, this, as you'll see, it strikes law enforcement officer or agency and substitute sheriff or deputy sheriff for service of process. I won't belabor this. It just, in Colorado, the sheriff's office or one of its deputies does service of process. We don't have service of process done by the city. I asked for an aye vote on Amendment L084.
Senator Court.
Thank you. Unnecessary. I urge a no vote.
Further discussion? Seeing none, the question before us is the adoption of Amendment L084. All those in favor say aye. Opposed, no? Amendment L084 is lost. The question before the body is Mr. Minority Leader.
Thank you, Mr. Chairman. House Bill 1177 is one of the bills that I've noticed that advocates against constituents outside the Capitol have frequently asked, how can this pass? How can such an unconstitutional thing be in our legislature? How can it advance? I recall in 2013 there were a lot of questions similar to that. While I am not an attorney, I would leave it to my colleague from El Paso County to correct me or expand on this if he cares to. But a bill is not a law. We debate bills here, and if the required number of votes are achieved, 18 or more in this chamber, and 33 or more in the chamber opposite, then a bill moves down to the first floor to the governor of Colorado, and if he decides not to veto that bill, then it becomes law within 10 days during the session or 30 days after the session, with or without his signature. At that time, as we saw in 2013, the bill becomes law. And when we have a law, then there is another condition set that does not yet exist, and that is standing. People are asking, how can they take action to stop the legislative body from passing this bill that they see as unconstitutional? And the answer is, a bill isn't a law. And without a law, there can't be standing. As we saw in 2013, I would imagine that some people who have such motivations might challenge this law should this bill become law. Earlier today, I talked about the different constitutional amendments that I see, the Bill of Rights that I see that run in conflict in addition to the Supremacy Clause of the U.S. Constitution, and the requirement that all of our laws here in this state must comply with that U.S. Constitution. So I wanted to explain for those watching online or Comcast 165, listening from afar, If you have that question, if you're wondering how the legislature could consider a bill that you might consider unconstitutional, it is that this legislative branch does have the authority to do such things. And then if we pass a bill into law that is challenged in court and found to be unconstitutional, then the judicial branch would theoretically strike down that law. There are many of us here in this chamber and across the way in the lower chamber who agree with those concerns. But there is not a challenge that we can offer here other than debating and offering that perspective to our colleagues and calling attention to our concerns about the constitutionality of this bill. We have done that. I ask you, colleagues, please consider this carefully. The 4th, 5th, 6th, and 14th amendments, not to mention the 2nd, which is rather obvious, and Article 2 of the Colorado Constitution as well. This is a troubling bill. We should not pass it. We should expect challenge in court that it goes too far. I am grateful to the good senator from Sterling for attempting earlier today, many hours ago, to change this from taking property away from people who are not charged even with a crime to turning that into taking a person into custody rather than his or her property, and to get them help if they so need it. I ask for a no vote on House Bill 1177.
Senator Gardner.
Thank you, Mr. Chair. I move the committee rise and report.
We'll be in a senatorial 5. For the body is to rise and report. All those in favor say aye. Opposed, no. Motion fails. Further discussion on House Bill 1177. Senator Hill.
Thank you, Mr. Chair. I ask for the bill to be read at length.
Mr. Carpenter, please read House Bill 1177.
House Bill 1177 by Representatives Sullivan and Garnett and Senators Court and Pedersen, concerning creation of an extreme risk protection order and in connection therewith making an appropriation. Being enacted by the General Assembly in the State of Colorado, Section 1 in Colorado Revised Statutes, add Article 14.5 to Title 13 as follows. Article 14.5, Extreme Risk Protection Orders 13, 14.5 101, short title. The short title is Article 14.5. is the Deputy Zachariah Parrish III Violence Prevention Act 14.5102 definitions as used in this Article 14.5. Unless the context otherwise clearly requires. 1. Extremist protection order means either a temporary order or a continuing order granted pursuant to this Article 14.5. 2. Family or household member means with respect to a respondent, any A. person related by blood, marriage, or adoption to the respondent. B. person who has a child in common with the respondent regardless of whether such person has been married to the respondent or has lived together with the respondent at any time. C. person who regularly resides or regularly resided with the respondent within the last 6 months. D. domestic partner of the respondent. E. person who has a biological or legal parent-child relationship with the respondent, including step-parents and step-children and grandparents and grandchildren. F. person who is acting or has acted as the respondent's legal guardian. And G. a person in any other relationship described in Section 18.6.800.32 with the respondent. 3. Firearm has the same meaning as in Section 18.19013H4. Petitioner means the person who petitions for an extremist protection order pursuant to this Article 14.55. Respondent means the person who is identified as the respondent in a petition filed pursuant to this Article 14.513, 14.5103. Temporary extremist protection orders. 1. A family or household member of the respondent or a law enforcement officer or agency may request a temporary extremist protection order without notice to the respondent by including in the petition for an extremist protection order an affidavit signed under oath and penalty of perjury supporting the issuance of a temporary extremist protection order. It sets forth the facts tending to establish the grounds of the petition or the reason for believing they exist, and if the petitioner is a family or household member, attesting that the petitioner is a family or household member, the petition shall comply with the requirements of Section 1314.51043. If the petitioner is a law enforcement officer or law enforcement agency, the law enforcement officer or law enforcement agency shall concurrently file a sworn affidavit for a search warrant pursuant to Section 16.3301.5 to search for any firearms in possession or control of the respondent at a location or locations to be named in the warrant. If a petition pursuant to Section 2765.106 is also filed against the respondent, a court of competent jurisdiction can hear that petition at the same time as the hearing for a temporary extremist protection order or the hearing for a continuing extremist protection order. 2. In considering whether to issue a temporary extremist protection order pursuant to this section, the court shall consider all relevant evidence, including the evidence described in Section 1314.51053. If a court finds by preponderance of the evidence that based on the evidence presented pursuant to Section 1314.51053, the respondent poses a significant risk of causing personal injury to self or others in the near future by having in his or her custody or control a firearm or by purchasing, possessing, or receiving a firearm, the court shall issue a temporary extremist protection order. For the court shall hold a temporary extremist protection order hearing in person or by telephone on the day the petition is filed or on the court day immediately following the day the petition is filed. The court may schedule a hearing by telephone pursuant to local court rule to reasonably accommodate a disability or in exceptional circumstances to protect the petitioner from potential harm. The court shall require assurances of the petitioner's identity before conducting a telephonic hearing. The hearing by telephone must be recorded and provided to the respondent prior to the issue of an extremist protection order. 5A, in accordance with Section 1314.51051, the court shall schedule a hearing within 14 days after the issuance of a temporary extremist protection order to determine if a 364-day extremist protection order should be issued pursuant to this Article 14.5. Notice of that hearing date must be included with the temporary extremist protection order that is served on the respondent. The court shall provide notice of the hearing date to the petitioner. B, any temporary extremist protection order issued expires on the date and time of the hearing on the extremist protection order petition or the withdrawal of the petition. 6, temporary extremist protection order must include a statement of the grounds asserted for the order. B, the date and time the order was issued. C, the date and time the order expires. D, the address of the court in which any responsive pleading should be filed. E, the date and time of the scheduled hearing. F, the requirements for surrender of firearms pursuant to Section 1314.5108. And G, the following statement to the subject of this temporary extremist protection order. This order is valid until the date and time noted above. You may not have in your custody or control a firearm or purchase, possess, receive or attempt to purchase or receive a firearm. While this order is in effect, you must immediately surrender to the insert name of law enforcement agency in the jurisdiction where the respondent resides all firearms in your custody, control, or possession, and any concealed carry permit issued to you. A hearing will be held on the date and at the time noted above to determine if an extremist protection order should be issued. Failure to appear at that hearing may result in the court entering an order against you that is valid for 364 days. An attorney will be appointed to represent you, or you may seek advice of your own attorney at your own expense as to any matter connected with this order. 7, a law enforcement officer shall serve a temporary extremist protection order concurrently with the notice of hearing petition in the same manner as provided for in Section 1314.5105 for service of the notice of the hearing where the respondent resides. 8A, if the court issues a temporary extremist protection order, the court shall state the particular reasons for the court's issuance. B, if the court declines to issue a temporary extremist protection order, the court shall state the particular reasons for the court's denial. 1314.5104 petition for extremist protection order. 1A, Petition for extreme risk protection order may be filed by a family or household member of the respondent or a law enforcement officer or agency. The petition is filed by a law enforcement officer or agency. The officer or agency shall be represented in any judicial proceedings by a county or city attorney. Upon request that the petition is filed by a family or household member, the petitioner, to the best of his or her ability, shall notify the law enforcement agency in the jurisdiction where the respondent resides of the petition and the hearing date with enough advance notice to allow for participation or attendance. Upon the filing of a petition, the court shall appoint an attorney to represent the respondent, and the court shall include the appointment of the notice of the hearing provided to the respondent pursuant to section 1314.51051A. The respondent may replace the attorney with an attorney of the respondent's own selection at any time at the respondent's own expense. Attorney fees for the attorney appointed for the respondent shall be paid by the court. To a petition for an extreme risk protection order must be filed in the county where the respondent resides. 3, a petition must A, allege that the respondent poses a significant risk of causing personal injury to self or others by having in his or her custody or control a firearm, or by purchasing, possessing, or receiving a firearm. It must be accompanied by an affidavit signed under oath and penalty of perjury stating the specific statements, actions, or facts that give rise to a reasonable fear of future dangerous acts by the respondent. B, identify the number, types, and locations of any firearms the petitioner believes to be in the respondent's current ownership, possession, custody, or control. C, identify whether the respondent is required to possess, carry, or use firearms as a condition of the respondent's current employment. D, identify whether there is a known existing domestic abuse protection order or emergency protection order governing the petitioner or respondent. E, identify whether there is a pending lawsuit, complaint, petition, or other action between the parties to the petition. And F, if the petitioner is not a law enforcement agency, identify whether the petitioner informed a local law enforcement agency regarding the respondent, for the court shall verify the terms of any existing order identified pursuant to subsection 3D of this section governing the parties. The court may not delay granting relief because of the existence of a pending action between the parties. A petition for an extreme risk protection order may be granted whether or not there is a pending action between the parties. 5, if the petition states the disclosure of the petitioner's address would risk harm to the petitioner or any member of the petitioner's family or household, the petitioner may be omitted from all documents filed with the court. If the petitioner has not disclosed an address pursuant to this section, the petitioner must designate an alternative address at which the respondent may serve notice of any motions. If the petitioner is a law enforcement officer or agency, the address of record must be that of law enforcement agency. 6, a court or public agency shall not charge a fee for filing or service of process to petitioner seeking relief pursuant to this article. 14.5, a petitioner or respondent must be provided the necessary number of certified copies, forms, and instructional brochures, fees free of charge. 7, a person is not required to post a bond to obtain relief in any proceeding pursuant to this section. 8, the district and county courts of the state of Colorado have jurisdiction over proceedings pursuant to this article. 14.5, 1314.5105, hearings on petition grounds for order issuance. 1A, upon filing of the petition, the court shall order a hearing to be held and provide a notice of the hearing to the respondent. The court must provide the notice of the hearing no later than 1 court day after the date of the extreme risk protection order petition. The court may schedule a hearing by telephone pursuant to the local court rule to reasonably accommodate disability or in exceptional circumstances to protect petitioner from potential harm. The court shall require assurances of the petitioner's identity before conducting a telephonic hearing. B, before the next court day, the court clerk shall forward a copy of the notice of the hearing petition to the law enforcement agency in the jurisdiction where the respondent resides for service upon the respondent. See, a copy of the notice of the hearing petition must be served upon the respondent in accordance with the rules for service of process as provided in Rule 4 of the Colorado Rules of Civil Procedure, or Rule 304 of the Colorado Rules of County Court Civil Procedure. Service issued pursuant to this section takes precedence over the service of other documents unless the other documents are of a similar emergency nature. D, the court may, as provided in section 1314.5103, issue a temporary extreme risk protection order pending the hearing ordered pursuant to subsection 1A of this section. The temporary extreme risk protection order must be served concurrently with the notice of hearing and petition. 2, upon hearing the matter, if the court finds by clear and convincing evidence based on the evidence presented pursuant to subsection 3 of this section that the respondent poses a significant risk of causing personal injury to self or others by having his or her custody or control a firearm, by purchasing, possessing, or receiving a firearm, the court shall issue an extreme risk protection order for a period of 364 days. 3, in determining whether grounds for an extreme risk protection order exists, the court may consider any relevant corroborated evidence, including but not limited to any of the following. A recent act or credible threat of violence by the respondent against self or others, whether or not such violence or credible threat of violence involves a firearm. B, a pattern of acts or credible threats of violence by the respondent within the past year, including but not limited to acts or credible threats of violence by the respondent against self or others. C, a violation by the respondent of a civil protection order issued pursuant to Article 14 of this Title 13D, a previous or existing extreme risk protection order issued against the respondent, a violation of previous or existing extreme risk protection order. E, a conviction of the respondent for a crime that included an underlying factual basis of domestic violence as defined in Section 18.6, 800.31. F, the respondent's ownership, access to, or intent to possess firearms. G, or credible threat of the unlawful or reckless use of a firearm by the respondent. H, the history of use, attempted use, or threatened use of unlawful physical force by the respondent against another person, or the respondent's history of stalking another person as described in Section 18.3602I. Any prior arrest of the respondent for a crime listed in Section 24.4.13021 or Section 18.9202. J, evidence of the abuse of controlled substances or alcohol by the respondent. K, whether the respondent is required to possess, carry, or use firearms, condition of respondent's current employment, and L, evidence of recent acquisition of a firearm or ammunition by the respondent. For the court may A, examine under oath the petitioner, the respondent, and any witnesses they may produce, or in lieu of examination, consider sworn affidavits of the petitioner, the respondent, and any witnesses they may produce, and B, request that the Colorado Bureau of Investigation conduct a criminal history record check related to the respondent and provide the results to the court under seal 5. The court shall allow petitioner or respondent to be present, evidence, and cross-examine witnesses, and be represented by an attorney at the hearing. 6, in a hearing pursuant to this Article 14.5, the rules of evidence apply to the same extent as in civil protection order proceeding. Pursuant to Article 14 of this Title 13.7, during the hearing, the court shall consider any available mental health evaluation or chemical dependency evaluation provided to the court. 8A, before issuing extreme risk protection order, the court shall consider whether the respondent meets the standard for a court-ordered evaluation for persons with mental health disorders pursuant to Section 2765-106. If the court determines that the respondent meets this standard, then, in addition to issuing extreme risk protection order, the court shall order mental health treatment evaluation authorized pursuant to Section 2765-106.6. Before issuing extreme risk protection order, the court shall consider whether the respondent meets the standard of emergency commitment pursuant to Section 2781-111 or 2782-107. If the court determines that the respondent meets the standard, then in addition to issuing an extreme risk protection order, the court shall order emergency commitment pursuant to Section 2781-111 or 2782-107. 9. An extreme risk protection order must include A statement of the grounds supporting the issuance of the order, B, the date and time the order was issued, C, the date and time the order expires, D, the address of the court in which any responsive pleading should be filed, E, the requirements for relinquishment of a firearm and concealed carry permit pursuant to Section 1314.5108, and F, the following statement to the subject of the extreme risk protection order. This order will last until the date and time noted above. If you have not done so already, you must immediately surrender any firearms in your custody, control, possession, and any concealed carry permit issued to you. You may not have in your custody or control firearm or purchase, possess, receive, or attempt to purchase or receive a firearm while this order is in effect. You have the right to request one hearing to terminate this order during the period that this order is in effect, starting from the date of this order and continuing through any renewals. You may seek the advice of an attorney as to any matter connected with this order. 10, when the court issues an extreme risk protection order, the court shall inform the respondent that he or she is entitled to request termination of the order in the manner prescribed by Section 1314.5107. The court shall provide the respondent with a form to request a termination hearing. 11A, if the court issues an extreme risk protection order, the court shall state the particular reasons for the court's issuance. B, if the court denies the issuance of extreme risk protection order, the court shall state the particular reasons for the court's denial. 12, if the court denies the issuance of extreme risk protection order, but ordered a temporary extreme risk protection order and law enforcement agency took custody of the respondent's concealed carry permit, or the respondent surrendered his or his concealed carry permit as a result of the temporary extreme risk protection order, the sheriff who issued the concealed carry permit shall reissue the concealed carry permit to the respondent within 3 days at no charge to the respondent. 13, if the court issues extreme risk protection order and the petitioner is a law enforcement officer or agency, the petitioner shall make a good faith effort to provide notice of the order to a family or household member of the respondent and to any known third party who may be a direct risk of violence. And this must include referrals to appropriate resources, including domestic violence, behavioral health, and counseling resources. 1314.5106, service of protection orders. 1, extreme risk protection order issued pursuant to Section 1314.5105 must be served personally upon the respondent, except as otherwise provided in this Article 14.5 to the law enforcement agency in this jurisdiction where the respondent resides shall serve the respondent personally. 3, the court clerk shall forward a copy of the extreme risk protection order issued pursuant to this Article 14.5 on or before the next court date of the law enforcement agency specified in the order for service. Service of an order issued pursuant to this Article 14.5 takes precedence over the service of other documents unless the other documents are of a similar emergency nature. 4th, law enforcement agency cannot complete service upon the respondent within 5 days. The law enforcement agency shall notify petitioner. The petitioner shall then provide any additional information regarding the respondent's whereabouts to the law enforcement agency to the effective service. The law enforcement agency may request additional time to allow for the proper and safe planning execution of the court order. 5, an extreme risk protection order entered by the court states that the respondent appeared in person before the court. The necessity for further service is waived and proof of service that the order is not necessary. 6, returns of service pursuant to this Article 14.5 must be made in accordance with the applicable court rules. 7, if the respondent is a veteran, there are any criminal charges against the respondent that result from the service or enforcement of the extreme risk protection order, the judge shall refer the case to the Veterans Court if the jurisdiction has a Veterans Court and the charges are Veterans Court eligible. 1314.5107, termination or renewal of protection orders. 1, termination. A, the respondent may submit one written request for a hearing to terminate an extreme risk protection order issued pursuant to this Article 14.5 for the period that the order is in effect. Upon receipt of this request for a hearing to terminate an extreme risk protection order, the court shall set a date for a hearing. Notice of the request and date of hearing must be served on the petitioner in accordance with the Colorado Rules of Civil Procedure, Colorado Rules of County Court Civil Procedure. The court shall set the hearing 14 days after the filing of the request for a hearing to terminate an extreme risk protection order. The court shall terminate the extreme risk protection order if the respondent established by clear and convincing evidence that he or she no longer poses a significant risk of causing personal injury to self or others by having his or her custody or control a firearm, or by purchasing, possessing, or receiving a firearm. The court may consider any relevant evidence, including evidence of the considerations listed in section 1314.51053B. The court may continue the hearing if the court determines that it cannot enter a termination order at the hearing, but determines that there is a strong possibility the court could enter a termination order at a future date before the expiration of the extreme risk protection order. If the court continues the hearing, the court shall set the date for the next hearing prior to the date for the expiration of the extreme risk protection order to renewal. A, the court shall notify the petitioner of the pending expiration of an extreme risk protection order 63 calendar days before the date that the order expires. B, a petitioner, family, or household member of a respondent or law enforcement officer or agency may by motion request a renewal of an extreme risk protection order at any time within 63 calendar days before the expiration of the order. C, upon receipt of the motion to renew, the court shall order that a hearing be held not later than 14 days after the filing of the motion to renew. The court may schedule a hearing by telephone in the manner prescribed by section 1314.51051A. The respondent must be personally served in the same manner prescribed by section 1314.51051B and 1C. D, in determining whether to renew an extreme risk protection order issued pursuant to this section, the court shall consider all relevant evidence and follow the same procedures provided in section 1314.51005E. If the court finds by clear and convincing evidence that, based on the evidence presented pursuant to section 1314.51053, the respondent continues to pose a significant risk of causing personal injury to self or others by having in his or her custody or control a firearm, or by purchasing, possessing, or receiving a firearm, the court shall renew the order for a period of time the court deems appropriate, not to exceed 1 year. In the order, the court shall set a return date to review the order no later than 35 days prior to the expiration of the order. However, if after notice the motion for renewal is uncontested and the petitioner seeks no modification of the order may be renewed on the basis of the petitioner's motion or affidavit signed under oath and penalty of perjury, stating that there has been no material change in relevant circumstances since the entry of the order, and stating the reason for the requested renewal. 3, if an extreme risk protection order is terminated or not renewed for any reason, the law enforcement agency storing the respondent's firearm shall provide notice to the respondent regarding the process for the return of the firearms. 1314.5108, surrender of a firearm. 1A, upon issuance of an extreme risk protection order pursuant to this Article 14.5, including a temporary extreme risk protection order, the court shall order the respondent to surrender all firearms by 1, selling or transferring possession of the firearm to a federally licensed firearms dealer prescribed in 18 U.S.C. Section 923 is amended, except that this provision must not be interpreted to require any federally licensed firearms dealer to purchase or accept possessions of any firearm. 2, arranging for the storage of the firearm by a law enforcement agency. The law enforcement agency shall preserve the firearm in a substantially similar condition that the firearm was in when it was surrendered. If the respondent does not choose the option in subsection 1A1 of this section, a local law enforcement agency shall store the firearm. Or 3, only for either an antique firearm as defined in 18 U.S.C. Section 921A16 as amended, or curio or relic as defined in 27 CFR 478.11 as amended, transferring possession of the antique firearm or curio or relic to a relative who does not live with the respondent after confirming through a criminal history record check the relative is currently eligible to own or possess a firearm under federal and state law. B, the court shall order the respondent to surrender any concealed carry permit to the law enforcement officer serving the extreme risk protection order. 2A, the law enforcement agency serving any extreme risk protection order pursuant to this Article 14.5, including a temporary extreme risk protection order in which the petitioner was not a law enforcement agency or officer, shall request that the respondent immediately surrender all firearms in his or her custody, control, or possession, and any concealed carry permit issued to the respondent, and conduct any search permitted by law for such firearms or permit after the law enforcement agency or officer has custody of the firearms. The respondent may inform the law enforcement officer of his or her preference for sale, transfer, or storage of the firearms as specified in subsection 1 of this section. If the respondent elects to sell or transfer the firearms to a federally licensed firearm dealer described in 18 U.S.C. Section 923 as amended, the law enforcement officer or agency shall maintain custody of the firearms until they are sold or transferred pursuant to subsection 1A1 of this section. The law enforcement officer shall take possession of all firearms and any such permit belonging to the respondent that are surrendered in plain sight or discovered pursuant to a lawful search. Alternatively, if a personal service by the law enforcement agency is not possible or not required because the respondent was present at the extreme risk protection order hearing, the respondent shall surrender the firearms and any concealed carry permit within 24 hours after being served with the order by alternate service or within 24 hours after the hearing at which the respondent was present. B, if the petitioner for an extreme risk protection order is a law enforcement agency or officer, the law enforcement officer serving the extreme risk protection order shall take custody of the respondent's firearms pursuant to the search warrant for firearms possessed by a respondent in extreme risk protection order as described in section 16.3.301.5. If a warrant was obtained after the law enforcement agency or officer has custody of the firearms, the respondent may inform the law enforcement officer of his or her preference for sale, transfer, or storage of the firearms as specified in Section 1314-105.52C. The law enforcement officer shall request that the respondent immediately surrender any concealed carry permit issued to the respondent and conduct any search permitted by law for the permit. 3. At the time of surrender or taking custody pursuant to Section 16.3301.5, a law enforcement officer taking possession of a firearm or a concealed carry permit shall issue a receipt identifying all firearms and any permit that have been surrendered or taken custody of and provide a copy of the receipt to the respondent within 72 hours after service of the order. The officer serving the order shall file the original receipt with the court and shall ensure that his or her law enforcement agency retains a copy of the receipt, or if the officer did not take custody of any firearms, shall file a statement to that effect with the court. 4. Upon the sworn statement or testimony of the petitioner or of any law enforcement officer alleging that there is probable cause to believe the respondent has failed to comply with the surrender of firearms or a concealed carry permit as required by an order issued pursuant to this Article 14.5, the court shall determine whether probable cause exists to believe that the respondent has failed to surrender all firearms or a concealed carry permit in his or her custody, control, or possession. If a probable cause exists, the court shall issue a search warrant that states with particularity the places to be searched and the items to be taken into custody. 5. If a person other than the respondent claims title to any firearm surrendered or taken custody of pursuant to Section 16.3301.5 pursuant to this section, and he or she is determined by the law enforcement agency to be the lawful owner of the firearm shall be returned to him or her. If A, the firearm is removed from the respondent's custody, control, or possession, and the lawful owner agrees to store the firearm so that the respondent does not have access to or control of the firearm, and B, the firearm is not otherwise unlawfully possessed by the lawful owner. 6A, within 48 hours after the issuance of an extreme risk protection order, respondent subject to the order may either 1, file with the court that issued the order 1 or more proofs of relinquishment or removal showing that all firearms previously in the respondent's custody, control, or possession, and any concealed carry permit issued to the respondent were relinquished to or removed by a law enforcement agency, and attest to the court that the respondent does not currently have any firearms in the respondent's custody, control, or possession, and does not currently have a concealed carry permit, or to attest to the court that A, at the time the order was issued, the respondent did not have any firearms in the respondent's custody, control, or possession, and did not have a concealed carry permit, and B, the respondent does not currently have any firearms in the respondent's custody, control, or possession, and does not currently have a concealed carry permit. B, if 2 full court days have elapsed since the issuance of an extreme risk protection order, the respondent has made neither the filing and attestation pursuant to subsection 6A1 of this section, nor the attestations pursuant to subsection 6A2 of this section. The clerk of the court for the court that issued the order shall inform the local law enforcement agency in the county in which the court is located that the respondent has not filed the filing and attestation pursuant to subsection 6A1 of this section, or the attestation pursuant to subsection 6A2 of this section. C, a local law enforcement agency that receives a notification pursuant to subsection 6B of this section shall make a good faith effort to determine whether there is evidence that the respondent has failed to relinquish any firearms in the respondent's custody, control, possession, or concealed carry permit issued to the respondent. 7. The Peace Officers Standards and Training Board shall develop model policies and procedures by December 1st, 2019 regarding the acceptance, storage, and return of firearms required to be surrendered pursuant to this Article 14.5 or taken custody pursuant to Section 16.3301.5, and shall provide those model policies and procedures to all law enforcement agencies. Each law enforcement agency shall adopt the model policies and procedures or adopt their own policies and procedures by January 1st, 2020. 13.14.5.109 firearms return disposal. 1. If an extreme risk protection order or temporary extreme risk protection order is terminated or expires without renewal, law enforcement agency holding any firearm that has been surrendered pursuant to Section 13.14.5.108 or taken custody of pursuant to Section 16.3301.5 or a federally licensed firearms dealer described in 18 U.S.C. Section 923 is amended with custody of a firearm or relative with custody of an antique firearm or curio or relic pursuant to Section 13.14.5.108.1A3 must return the firearm requested by a respondent within 3 days only after confirming through a criminal history record check performed pursuant to Section 2433.5424 that the respondent is currently eligible to own or possess a firearm under federal and state law, and after confirming with the court that the extreme risk protection order has terminated or has expired without renewal. 2. Any firearm surrendered by a respondent pursuant to Section 13.14.5.108 or taken custody or pursuant to Section 16.3301.5 that remains unclaimed by the lawful owner for at least 1 year from the date the temporary extreme risk protection order or extreme risk protection order expired, whichever is later, shall be disposed of in accordance with the law enforcement agency's policies and procedures for the disposal of firearms in police custody. 13.14.5.110 reporting of extreme risk protection orders. 1. The court clerk shall enter any extreme risk protection order or temporary extreme risk protection order issued pursuant to this Article 14.5 into a statewide judicial information system on the same day the order is issued. 2. The court clerk shall forward a copy of an extreme risk protection order or a temporary extreme risk protection order pursuant to this Article 14.5 the same day the order is issued to the Colorado Bureau of Investigation and the law enforcement agency specified in the order. Upon receipt of the copy of the order, the Colorado Bureau of Investigation shall enter the order into the National Instant Criminal Background Check System, any other federal or state computer-based system used by law enforcement agencies or others to identify prohibited purchases of firearms, and any computer-based criminal intelligence information system available in this state used by law enforcement agencies. The order must remain in each system for the period stated in the order, and the law enforcement agencies shall only expunge orders from the systems that have expired or terminated, and shall promptly remove the expired or terminated orders. Entry into the computer-based criminal intelligence information system is noticed to all law enforcement agencies of the existence of the order. The order is fully enforceable in any county in the state. 3, the issuing court shall, within 3 court days after issuance of extreme risk protection order or temporary extreme risk protection order, forward all identifying information the court has regarding the respondent, along with the date the order is issued, to the county sheriff in the jurisdiction where the respondent resides. Upon receipt of the information, the county sheriff shall determine if the respondent has a concealed carry permit. If the respondent does have a concealed carry permit, the issuing county sheriff shall immediately revoke the permit. The respondent may apply for a concealed carry permit after the temporary extreme risk protection order and extreme risk protection order, if ordered, are no longer in effect. 4, if an extreme risk protection order is terminated before its expiration date, the court clerk shall forward on the same day as the termination order a copy of the termination order to the Colorado Bureau of Investigation and the appropriate law enforcement agency specified in the termination order. Upon receipt of the order, the Colorado Bureau of Investigation and law enforcement agency shall promptly remove the order from any computer-based system in which it was entered pursuant to subsection 2 of this section 5 upon the expiration of a temporary extreme risk protection order. Extreme risk protection order, the Colorado Bureau of Investigation and law enforcement agency specified the order shall promptly remove the order from any computer-based system in which it was entered pursuant to subsection 2 of this section 6. Any extreme risk protection order does not constitute a finding that a respondent is a prohibited person pursuant to 18 U.S.C. section 922, 1314.5, 111 penalties. Any person who has in his or her custody or control a firearm or possesses or receives a firearm with knowledge that he or she is prohibited from doing so by an extreme risk protection order or a temporary extreme risk protection order issued pursuant to this article 14.5 is guilty of class 2 misdemeanor. 1314.5, 112, other authority retained. This article 14.5 does not affect the ability of a law enforcement officer to remove a firearm or concealed carry permit from a person or conduct a search and seizure for any firearm pursuant to other lawful authority. 1314.5, 113, liability 1, except as provided in section 1314.5, 111. This article 14.5 does not impose criminal or civil liability on any person or entity for acts or omissions made in good faith related to obtaining extreme risk protection order or temporary extreme risk protection order, including but not limited to reporting, declining to report, investigating, declining to investigate, filing, or declining to file a petition pursuant to this article 14.5 to a person who files a malicious or false petition for temporary extreme risk protection order. An extreme risk protection order may be subject to criminal prosecution for those acts. 3, in addition to any other remedies, a respondent who has a malicious or false petition for temporary extreme risk protection order filed against him or her as a private cause of action against petitioner in the action, the plaintiff is entitled to actual damages, attorney's fees, and costs. 1314.5, 114, instructional informational material definition 1A. The state court administrator shall develop standard petitions and extreme risk protection order forms and temporary extreme risk protection order forms in more than one language consistent with state judicial department practices. The standard petition and order forms must be used after January 1st, 2020 for all petitions filed and orders issued pursuant to this article 14.5. The state court administrator may consult with interested parties in developing petitions, and forms and materials must be available online consistent with state judicial department practices. B, the extreme risk protection order must include in a conspicuous location notice of criminal penalties resulting from violation of the order in the following statement. You have the sole responsibility to avoid or refrain from violating this extreme risk protection order's provisions. Only the court can change the order, and only upon written motion. 2, a court clerk for each judicial district shall create a community resource list of crisis intervention, mental health, substance abuse, interpreter, counseling, and other relevant resources serving the county in which the court is located. The court shall make the community resource list available as part of or in addition to the informational brochures described in subsection 1 of this section. 3, the state court administrator shall distribute a master copy of the standard petition extreme risk protection order forms to all court clerks in all district and county courts. 4, courts shall accept petitions pursuant to sections 1314.5, 103 and 1314.5, 104 beginning on January 1st, 2020. Section 2 in Colorado Revised Statutes 13.3, 101 add 10 as follows. 13.3, 101 state court administrator 10. The state court administrator or his or her designee shall present at the judicial department's hearing pursuant to section 27203 statistics related to extreme risk protection orders in article 14.5 of this title 13. The statistics must include the number of petitions filed for temporary extreme risk protection orders, the number of petitions filed for extreme risk protection orders, the number of temporary extreme risk protection orders issued and denied, the number of extreme risk protection orders issued and denied, the number of temporary extreme risk protection orders terminated, the number of extreme risk protection orders terminated, and the number of extreme risk protection orders renewed. The state court administrator or his or her designee shall also report state court data related to all persons who are subject to any temporary emergency risk protection order, and who within 30 days after the issuance or execution of the protection order are charged with a criminal offense. The report must include the nature of the criminal offense, including but not limited to any offense for violation of the emergency risk protection order and the disposition or status of that criminal offense. Section 3 in Colorado Revised Statutes adds 163301.5 as follows. 163301.5 search warrant for firearms possessed by a respondent in an extreme risk protection order. 1. Any court may issue a search warrant to search for and take custody of any firearm in the possession of a named respondent in an extreme risk protection order or temporary extreme risk protection order filed pursuant to Article 14.5 of Title 13 if the application for the warrant complies with all required provisions of Section 163303 and also provides facts sufficient to establish by probable cause A, that the named person is a named respondent in an extreme risk protection order or temporary extreme risk protection order filed pursuant to Article 14.5 of Title 13, and B, that the named person is in possession of one or more firearms, and C, the location of such firearms, and D, any other information relied upon by the applicant, why the applicant considers such information credible and reliable to the return or disposal of any firearm taken custody pursuant to this section shall be accomplished pursuant to Section 1314.51 and 9, Section 4 in Colorado Revised Statutes 1812-203, amend 1G2 and 1G3 and add 1G4 as follows. 1812-203 criteria for obtaining a permit. 1. Beginning May 17, 2003, except as others provided in this section, the sheriff shall issue a permit to carry a concealed handgun to an applicant who G is not subject to. 2. A permanent protection order issued pursuant to Article 14 of Title 13, strike CRS or unstrike. 3. A temporary protection order issued pursuant to Article 14 of Title 13, strike CRS, unstrike, that is, in effect at the time the application is submitted. Or 4. A temporary extreme risk protection order issued pursuant to Section 1314.5103 on extreme risk protection order issued pursuant to Section 1314.5105 Section 5, appropriation for the 2019-20 state fiscal year. $119,390 appropriated to the Judicial Department. The appropriation is from the general fund. To implement this act, the department may use this appropriation for court costs, jury costs, and court-appointed counsel. Section 6, Safety Clause. The General Assembly hereby finds, determines, and declares that this act is necessary for the immediate preservation of the public peace, health, and safety.
Motion is the passage of the bill. All those in favor say aye. Aye. Opposed, no. Bill passes. Mr. Carpenter, please read the title to Senate Bill 5.
Senate Bill 5 by Senators Rodriguez and Janal and Representative Hawkins Lewis concerning wholesale importation of prescription pharmaceutical products from Canada for resale to Colorado residents.
Senator Janal.
Thank you, Mr. Chair. I move Senate Bill 19-005 and the Health and Human Services Report and the Appropriations Committee report.
To the Health and Human Services Committee report, Senator Janal.
Thank you, Mr. Chair. The Health and Human Services Committee report amended the bill to include Senate Bill 5 to be administered by the Department of Healthcare Policy and Financing. It also defined what a health care provider is. It reset several dates on implementation of the program and several technical amendments. I ask for an aye vote.
Is there further discussion on the Health and Human Services Committee report? Seeing none, the question before us is the passage of the report. All those in favor say aye. Opposed, no. The report is adopted. To the Appropriations Committee report, Senator Janal.
Thank you, Mr. Chair. I move the Appropriations report. The Appropriations Committee just appropriated dollars to the Department of Healthcare Policy and Financing for 2019-2020. I ask for a yes vote.
Is there further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the report. All those in favor say aye. Opposed, no. The report is adopted. To the bill, Senator Janal.
Thank you, Mr. Chair. Today we have a chance to help patients as well as consumers, no matter what side of the aisle that they're on. Drugs are cheaper in Canada because Canada imposes restrictions on how much pharmaceutical companies are allowed to charge for medicines. The U.S. does not do that. This bill is an innovative way for states to take control of reducing skyrocketing prescription prices, which the pharma lobby has blocked. Purchasing drugs at lower prices threatens that market here in the United States. Senate Bill 5 tasks the Healthcare Policy and Financing to design a state importation program. HCPF will hire and train staff to license and monitor 1, importers to the U.S., 2, exporters in Canada, and 3, any third-party contractors in the supply chain. Also, they have to comply with federal track and trade laws. determine administrative costs and importation, and by January 1st of 2020, HICPUF will release a draft program and submit this to the General Assembly in a final report on 4/15/2020. And on 5/1/2020, HICPUF director submits the request to the Federal Health and Human Services Secretary to review and approve. The approval is what we would wait on, and HICPUF will put those plans into motion when we get the approval from the federal government. And I ask for an aye vote.
Is there further discussion on Senate Bill 5? Senator Marble.
Oh, hi guys. I didn't know you were here.
Thank you so much, Mr. Chair. I'm not so sure that I support this bill, although I do support lower costs of prescription drugs throughout the United States. It's well known that a lot of the drugs that come into the United States from other areas are untested, and some of those that are untested and have been around our nation for quite a number of years, they actually aren't what we think they are. And this is also happening in Canada. The Federal Food and Drug Administration has repeatedly said that it cannot guarantee the safety of prescription drugs imported from Canada. 80% of all prescription drugs sold in Canada are from foreign sources. So if we start in the United States limiting the import of drugs, are they just going to reroute and come through Canada? I think so. We have a problem. High costs and drugs coming into the country that are not tested. And then when they are, it is found that even in some of the things that came through for children, they didn't contain anything. It was like giving them a syringe full of nothing. We need tighter controls and testing on drugs that come in our country, or limit the drugs to just what is made within the United States, because we are having a lot of problems. And letting these drugs reroute through Canada isn't going to help us. We need to get strict controls, and we need to test these drugs that are coming in from Canada and in the United States from places like China. It's amazing what we have let happen, and we need to stop it, and this bill isn't going to help that. So I really have high reservations regarding the safety of this bill, and I am a strong no.
Senator Tate, there is an amendment on the desk. Mr. Carpenter, will you please read Amendment L017?
Amendment L017, Senate Bill 5 by Senator Thompson.
Senator Tate.
Thank you, Mr. Chair, and members, I apologize for having an amendment here in the late hour. And if y'all could indulge me, I think it's a pretty important amendment, and I'm introducing.
Senator Tate, please
move amendment L017.
Thank you. To the amendment.
And with one of my colleague from Parker not here, who would be the one to probably best articulate the need for the amendment, it is an amendment that is a quality assurance amendment, and I'm just going to I know it's annoying, but I'm just going to read some notes I have about why the amendment is necessary and prudent. As currently written, the bill requires HICPUF to develop a program to import prescription pharmaceutical products from one or more licensed Canadian suppliers. And it also to ensure drug safety for Colorado consumers. Those are good things. While sponsors and proponents have testified that drugs are imported through the program would be safe because they would be those regulated by Canada's gold standard regulatory system, the bill itself does not require that drugs be manufactured for Canadian citizens. The bill simply states that the drugs must be purchased from a licensed Canadian supplier. Given the bill's requirement that the state ensure drug safety for Colorado consumers, this amendment would simply make certain what proponents have already stated, that any drug we get through an importation program would be as safe as those dispensed to a Canadian patient. Furthermore, the amendment would require that the Canadian supplier with whom the state contracts to assume liability if any drugs they export to Colorado are found to be transshipped through Canada instead of those meant for Canadian supply. Under Canadian law, transshipped goods or goods manufactured from export from Canada are not subject to Canada's drug regulations. As such, it cannot be assumed that drugs exported from Canada are the same drugs Canadians have access to at Canadian pharmacies. Rather, drugs procured through importation from Canada may be transshipped through Canada from anywhere else on Earth, or otherwise not be intended for use in Canada. Significantly, Canada has no track and trace system, making it very difficult for an individual or company to verify the legitimacy of any particular drug product or remove suspect products along the supply chain. A product imported from Canada may look identical to a drug intended for sale to Canadian consumers, but may in fact be a counterfeit drug. Without this amendment, Senate Bill 5 would incentivize those involved in illegal activity to profit through transshipment. That's a pretty significant concern of mine. A report by a former FBI director found that drug importation would increase financial incentives for individuals and criminal organizations to transship products through Canada that are likely to be counterfeit, diverted, adulterated, substandard, or other non-FDA approved products. As written, Senate Bill 5 provides no means for the FDA or other U.S. or state regulatory or law enforcement body to determine whether the drugs have been transshipped. The proposed amendment would add an extra layer of verification from a contracted Canadian supplier that the drugs exported to Colorado are safe and not transshipped from countries with unknown standards in the regulatory system. Canadian law seeks to protect Canadian citizens and patients. As such, medicines that are merely transshipped through Canada or manufactured in Canada for export outside of Canada need not meet Canada's food and drug safety laws and regulations. Given the bill's requirement that the state ensure drug safety for Colorado consumers, the proposed amendment simply requires that we be sure that the drugs being exported by a licensed Canadian supplier to Colorado are those regulated by Health Canada and therefore originally intended for use by Canadian citizens. Apologize for going through that in late hour, members, and again, my colleague would mainly be the one who'd mainly be speaking on this issue, but hopefully with that information you can see there's a fairly legitimate quality and safety concern with regard to transshipped products. And members, I just strongly urge a consideration on this amendment and happy to hear maybe why what I don't know. Thank you, members.
Further discussion on the amendment? Senator Lundin.
Thank you very much, Mr. Chair. So, TANSTAFL, there ain't no such thing as a free lunch. It's an economic principle. You get what you pay for is another way of saying it. There's an enormous potential for pharmaceutical dumping that could be coming into our country through a process of this nature. Quite frankly, to the bill itself, to the extent the Canadian government wants to subsidize my safe pharmaceuticals, I guess I'm fine with that concept. However, I don't know that pharmaceuticals are safe, and that's what this amendment's about. It's about making sure that these are fit for human consumption, so to speak. It's about identifying that these are serious drugs, identified in serious processes for the people of Canada, and I guess if it's good enough for my Canadian daughter-in-law, it might be good enough for me. But I don't know that without this amendment. I urge your support of L017.
Senator Rodriguez.
Thank you, Mr. Chair. A little bit of misconception of this bill. The whole purpose of this bill and the reason or this amendment, sorry about that. The whole purpose of this amendment and the bill we have, and the reason that it's from Canada is they have the most similar regulation and safety guidelines. A little bit of facts that we have is, which I don't have, about 20% of the drugs we make in the United States are shipped to Canada. I don't understand why those drugs are any better. I'm curious as to why the pharmaceutical industry doesn't think their drugs up there are any better than the drugs we get here. The whole purpose of this bill is to do a study and to make sure that we control the safety and testing of these drugs before they come in. People are already buying these drugs and have access to unsafe drugs, and this is what we're trying to control. I urge a no vote on this amendment.
Mr. Minority Leader.
Thank you, Mr. Chair. I would ask the sponsors to please reconsider that position, a no vote on the amendment. I think this could very easily be considered a friendly amendment, and it distinguishes between drugs that come through Canada versus drugs that are actually manufactured in Canada or according to Canadian standards. I admit that our colleague from Parker, my friend from Douglas County, knows more about this than do I. But we do have a problem with things manufactured in Asian countries or maybe in South America, and particularly with fentanyl, drugs, pharmaceuticals that are laced with things that are not supposed to be in those drugs. And if we distinguish between pharmaceuticals that are manufactured in Canada, or at least according to Canadian standards, if there's some validation from the country of Canada that the drug has been manufactured properly, then I think we get to the purpose of this bill. Without this amendment, we leave the door open for counterfeit pharmaceuticals that don't come from Canada. They come through Canada, but they don't come from Canada. They don't come from the standards adopted by Canada. There was one thing that I learned when I was vice chair and then chair of the Senate Business Committee in studying a different industry here in Colorado that involves the manufacture of food products for the first time by any government, and that's the marijuana industry. I learned about process validation. And when a company manufactures a large quantity of pills, for instance, you might think of something like Tylenol. They do not test every single pill. They don't test every single bottle of pills. And they may not test even every single batch of pills that come off their assembly line, but they test the process by which those pills are manufactured. And as long as the process tests within limits, there's assurance that all of the pills that come through that process fit the prescribed guidelines, the tolerances. They're not all exactly the same, but they're within the limits, the acceptable limits. This is very much the kind of discussion that would come into play with L017. Canada, I am confident, has those kinds of manufacturing requirements, and if the prescription drugs are manufactured under those requirements, I think we can take some certainty in this bill in that if people here in Colorado, our constituents, receive those pharmaceuticals, that they will be relatively safe. That the prescription, what is supposed to happen with that prescription, is what happens. If we don't have this amendment and close this loophole, our constituents could be receiving pharmaceuticals that look the way they're supposed to. They may appear, the quantity, the size, the color, everything looks just like the legitimate pharmaceutical. But it turns out it's counterfeit. It comes from some country that is not manufacturing according to standards in Canada. And that is why this amendment is so important. And I would just ask the sponsors, please give thoughtful consideration. This is not a poison pill, no pun intended, to get cut directly to it. We don't want that. And this would provide safety and certainty for the people of Colorado and for those of us in the legislature applauding lower prices for pharmaceuticals for people in Colorado. I understand that motivation, but let's make sure the people of Colorado are protected. Ask for an aye vote on L017.
If it were a poison pill, it might be cheaper if you got it from Canada. Further discussion? Senator Woodward.
Thank you, Mr. Chair. When I started looking over this bill the very first time, and then specifically when I got to this amendment, my question is not certainly to the intent of the bill sponsors. I think that anything that we can do and try that can bring down the cost of medical care is worth analyzing and researching. This particular amendment, I think, is important because this is the only piece that makes sure that we're getting what we pay for. Now, at first I thought, well, maybe the concern is that there's a risk that we're going to get generic drugs from Canada. The senator from Douglas County mentioned that there's a risk that we get tainted drugs, perhaps drugs tainted, made in Asia or South America or Central America, that could ultimately cause harm. I think just as great of risk is the chance that we get counterfeit drugs that are completely ineffective. They're sugar pills. So when you're trying to take care of grandma's chemotherapy or important insulin for your kids, you presume that when you buy those drugs here in the U.S. that they're effective and they're going to work as prescribed. This amendment, I think, ensures that what will happen to our kids and our parents and ourselves when we start getting drugs is if we do eventually get them from Canada, we want to make sure that they are 100% as safe as those that we get here in the U.S. I think that we need to stand behind this amendment L017, and I stand in support of this amendment.
Senator Janal.
Thank you, Mr. Chair. And I think I need to clarify some things that, people seem to be stuck on in regards to the drugs that are coming through, being tainted, being sugar pills, being poison pills, whatever. This already happens. You can get mail order prescriptions from Canada. May not be from Canada, may be from another country. So this is not a personal, unregulated importation program where individuals are, using these websites or mail order online pharmacies. This is a program where the state takes on a responsibility to act as a wholesale importer, to act like the FDA. But the state of Colorado does that. I want to clarify a couple of other things. The regulatory compliance is solely Colorado's responsibility. The Canadian regulatory requirements for marketing of prescription drugs is very similar to that of U.S. FDA requirements. In fact, I was just looking up package inserts last night, because I like to look up package inserts for different drugs. And I happened to look up Apixaban, and it's made by Pfizer. And what popped up when I Googled it was package insert for Canada or package insert for the United States. And guess what? Pfizer sells to Canada. The same drug that's made right here, they sell to Canada. And what we're doing is buying it back from them for 2/3 less that cost. There are more than 30 Canadian manufacturers that are FDA registered to produce drugs for the United States marketplace. The FDA has had this cooperative agreement with Canada since 1973. And the program will show a significant cost savings to the consumers, as I just said, about 2/3 less than what we're paying here in the United States. That is significant. I looked up the word significant last night, too, because this was something that was brought up in committee. Significant, defined in percentage, was anything less than 50% or greater than 30%, somewhere in that range. That's a significant price change. So Colorado is not going to deal with all of the drugs. First of all, I want to make it clear that we're going to select a limited number of high-cost drugs to be imported. For example, the state of Vermont right now has passed this law, and there are 16 drugs, which are some of the most expensive drugs that they are buying from Canada. They are not generics, and I will also tell you that this bill, you don't have to worry about narcotics, because we're not doing fentanyl, we're not doing any of those, any opioids, anything that's a narcotic. No biologics are in this bill, and no parenteral meds. And if any of you know what parenteral meds are, they're the ones that you inject sub-Q or IM. These are medications that people use for chronic diseases and brand names that we can get at 1/3 of the cost by importing them from Canada. So the amendment that's been brought forth is not a friendly amendment, because actually we do have the same standards, just the same as the FDA. The Canadians have similar standard than the FDA. And all of this is under HCPUF's direction. And the biggest thing is, you're looking at a date for the letter of intent, and we may get approval before, we may get approval after. So, this date depends upon the approval by the Secretary of Health and Human Services at the federal level. Sorry. Ask for no vote.
Senator Bridges.
Thank you, Mr. Chair. I rise in opposition to this amendment as it is written, but I think there are some very important things in here that, as HCPUF puts this program together, I hope they will consider. And I would like to, enter into the record that it is my assumption they will do this as they go through, that the drugs that we will be importing are safe. I think especially the piece in here that nothing that Canadians wouldn't consume themselves, that wouldn't fit consumption by Canadians, should be allowed into the U.S. just because they happen to have passed through the Canadian market. I would also say that as far as the liability goes, I think that the supplier should assume the liability for any damages if they give us drugs that are terrible. I think that liability should rest with the people who gave us the terrible drugs. Again, I think there are some details in this amendment that I think cause some real problems for the bill, so I'm a no on the amendment, and I ask for a no vote. But I think the ideas in here, some of the ideas in here are very solid, and I support those and would support those in rulemaking at HCPUF. Thank you.
Senator Cook.
Thank you, Mr. Chair. I rise in support of the amendment. I don't think I can do a much better job than the good senator from Centennial or the good senator from Berthoud on describing the problem. But this is a matter of public safety, and it's a matter of consumer protection. This is about pass-through. We all know about pass-through money and other pass-through items. So we get pass-through from the feds. We don't really know what's in it. We just know it's coming from the feds, and we pass through it. This is the same thing. It's pass-through from these drugs could be made in some Indonesian country, some other foreign country, shipped to Canada, and then passed through down to the United States. So this is a consumer protection problem. And I want to just quote a little fact here. The World Health Organization estimates 10% of medicines worldwide and up to 50% of the drugs consumed in developing nations are counterfeit. Why do we want to lower ourselves to a third world nation, to a developing nation? This is about the protection of our citizens here in Colorado. And then also, to date, not a single secretary of the U.S. Health Department of Health and Human Services has been able to clarify that importation will both, one, pose no additional risk to public health and safety, and two, generate cost savings that are passed on to American consumers. This does not offer any cost savings, and it does not even help the health and safety of our citizens. So I would ask for a yes vote on the amendment.
Is there further discussion on the amendment? Senator Rodriguez.
Thank you, Mr. Chair. So the biggest safety concerns I have for the safety of all Coloradans who cannot afford to buy the medicines that control or cure their diseases, this is a very real safety concern on which we should all be focused, not the farmer hyperbolic worry about some program we are not even considering. And the pharmaceuticals would try to have you worry that the Colorado state government and the U.S. government together would have insufficient interest and insufficient ability to design or approve a safe program. It's just silly. Our state government and federal government will keep safety top of mind. If our folks and the federal folks do not think it can be safe, importation would not happen. It's that simple. I urge a no vote.
Any further discussion on the amendment? Senator Marble.
Thank you, Mr. Chair. I rise in support of the amendment. I think it's very prudent and very much in line with what we need. Colleagues, we've got a problem in the United States, and shipping in drugs from Canada is not going to help. They have the same problems we do. We need to sit back. We need to take a look at what we're bringing in. We need to take a look at the information that we have at our fingertips right now about what we have been doing to our children and to the people here in the United States with drugs coming in that we think are fine, but they're not. Just because now we get them from Canada, all of a sudden we think that fixes it just because they're cheaper and more affordable? No, they're the same thing. And HCPF, did you see their audit? I think take a look at that and then say, is this something you want to hand over to them? I think they need to have a lot of revamping within their structure, and hopefully the new director will do just that.
Any further discussion on the amendment? Senator Tate.
Thank you, Mr. Chair, and thank you, members, for indulging this discussion. I just think the plain language of the amendment speaks for itself. Each prescription pharmaceutical product that the supplier exports to the program for dispensation to Colorado residents is manufactured for consumption by Canadian residents and not diverted or otherwise sourced from any other market. Thank you, members, for having this discussion on this bill at the late hour.
Seeing no further discussion on the Senator Todd.
Thank you, Mr. Chair. And this has been a really good discussion, and a couple of things that I want to say in terms of when we start looking at drugs coming from another company or from another country, making sure that the safety, making sure that all of the precautions are taken care of. And I think that the parts of where the bill is now obviously will continue moving into the House and continue being addressed with some of those things, but the parts of the amendment that I'm very much in agreement with, and parts of it that I have concerns about, and out of respect of the sponsors, I can't support the amendment, but I do support the fact that making sure that safety is never compromised and making sure that as drugs are coming into the United States, I think we all know people who are currently getting pharmaceuticals from Canada. We know people that are taking those drugs and saving a boatload of money. And so as a result of that, what we want to do is just make sure that safety is at the top of the list, and I do believe that the bill sponsors are prioritizing that. My hope is that as the bill continues to move forward, if there is any question, as it is scrutinized and as it is worked with HCPF, that it is continued to be addressed and continued to be reinforced on safety and protection. So again, I urge an aye vote on Senate Bill 5 and not on this amendment.
Any further discussion on the amendment? Seeing none, the question before us is the passage of Amendment L017. All those in favor say aye. Aye. Opposed, no? No. Amendment L017 is lost. To the bill. Senator Janal.
Thank you, Mr. Chair. So Senate Bill 5 tasks HICPUF to devise a system of state regulations. None of us want to see any harm come to anyone. So it must design a state importation program where they have to hire and train staff to license and to monitor importers in the United States and exporters in Canada and third-party contractors in the supply chain. This state of Colorado will have to physically inspect the Canadian companies in order to get export licenses. And importers will also have to be inspected. And in order to make sure that the drugs are safe, we will test drug batches, as is done now for some of the other imports that we get from Canada. But also, databases have to be managed. So we're inspecting Canadian companies in order to get export licenses. We're inspecting importers who would also have to be licensed. And we have to keep track of the drug batches as a track and trace. So there's a lot of things involved and a lot of things to work out in regards to this bill before it goes to the Federal Secretary of Health and Human Services, and that's what this bill is tasking HICPUF and probably other departments that HICPUF will look to do these duties. So I ask for an aye vote.
Senator Rodriguez.
Thank you, Mr. Chair. I just want to clarify what this bill does not do. This does not create a national importation program. It is not importing drugs other than those regulated or licensed for sale in Canada. And it would not implement a program without the approval of the Federal Health and Human Services. Look, we all know that this bill isn't going to be the answer to all that ails us for drugs. This is only looking at some of the high costs and passing savings on. This needs to happen at a federal level. I am not a federal legislator, but we can control what happens here, and we need the federal government to do it. Many other states are looking at this. Republican red states, blue states, Florida is looking at the same legislation. They have the support of the Trump administration. If this gets passed, we're hoping to jump on that wagon. And I think we owe it to Coloradans to show that we're trying to fight to get them savings. So I urge an aye vote and call the question.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L018?
Amendment L018, Senate Bill 5 by Senator Janal.
Senator Janal?
Thank you, Mr. Chair. I move L018.
To the amendment, Senator Janal.
Thank you, Mr. Chair. What this does is it takes the definition for drugs, pharmaceutical products, and when it's defined in the statutes, it's not only for human consumption, but for veterinary consumption. And what this does is it just truncates it so that these are only drugs that are used for human consumption, and I ask for an aye vote.
Senator Tate.
Thank you, Mr. Chair, and question for the bill sponsor. As co-chair of the Claw Caucus, my bunnies first, Mr. Carrot and Mona, would like better pharmaceuticals, as well as my dog Toby. I'm very disappointed. Thank you, members.
Further discussion on Amendment L018. Seeing none, the question before us is the passage of Amendment L018. All those in favor say aye. Opposed, no? No. Amendment L018 is adopted. Is there further discussion on the bill? Senator Hill.
Thank you, Mr. Chair. I ask for Senate Bill 5 to be read at length.
Mr. Carpenter, please read Senate Bill 5.
Senate Bill 5 by Senators Rodriguez and Janal and Representative Hackers Lewis concerning wholesale importation of prescription pharmaceutical products from Canada for resale to Colorado residents. Being enacted by the General Assembly of the State of Colorado, Section 1, Legislative Declaration 1, the General Assembly hereby finds and declares that a United States consumer pays some of the highest prescription drug prices in the world, And it is estimated the United States consumers pay twice as much as the amount of Canadian consumers pay for patent and prescription drugs and 20% more for generic drugs. B, federal law, as codified in 21 U.S.C. Section 384, authorizes the Secretary of the United States Department of Health and Human Services to allow wholesale importation of prescription drugs from Canada if such importation is shown to be both safe and less costly for United States consumers. C, although importing prescription drugs would be less costly, there may be risk posed to consumer health and safety if the source, quality, and purity of the prescription drugs sold by online pharmacies cannot be verified. D, Canada has a rigorous regulatory system to license prescription drugs equivalent to the licensing system in the United States. E, in the United States Title II of the Federal Drug Quality and Security Act, publication L 11354, referred to as the Drug Supply Chain Security Act, has significantly improved drugs security and safety through a system of pharmaceutical product track and trace procedures, and the FA wholesale drug importation program for the exclusive benefit of Colorado residents should be designed and implemented to provide Colorado consumers access to safe and less expensive prescription drugs. Section 2 in Colorado Revised Statutes add Part 2 to Article 2.5 of Title 25.5 as follows. Part 2, wholesale importation of prescription drugs. 25.5, 2.5201, short title. Short title is Part 2. This is the Colorado Wholesale Importation of Prescription Drugs Act's 25.5, 2.5202 definitions used in Part 2 unless the context otherwise requires. 1, actual acquisitions cost means the price paid for an imported prescription pharmaceutical product by a wholesaler under the importation program. 2, carrier has the same meaning as set forth in Section 1016-1028. 3, importation program means a program administered by the State Department in accordance with this Part 2. 4, secretary means the Secretary of the United States Department of Health and Human Services. 25.52.5203. Wholesale drug importation program, State Department to design program requirements. 1, on or before January 1st, 2020, the State Department, in consultation with relevant stakeholders and federal agencies, shall design an importation program to import prescription pharmaceutical products from one or more licensed Canadian suppliers solely for distribution to participating in-state pharmacies and other licensed providers for the exclusive purpose of dispensing prescription pharmaceutical products to Colorado residents with valid prescriptions. In designing the importation program, the State Department shall ensure that the importation program satisfies the requirements of 21 U.S.C. Section 384. The State Department shall include the design of the importation program information indicating how the importation program will A, ensure drug safety and cost savings for Colorado consumers, B, meet the requirements for wholesaler licenses in accordance with Part 3 of Article 42.5 of Title 12C, select qualified Canadian pharmaceutical suppliers that are licensed, regulated under Canadian national or provincial laws. D, sample imported prescription pharmaceutical products for purity, chemical composition, potency to the extent required by federal law. You determine which prescription pharmaceutical products will be imported and ensure that all imported products are significantly less costly to Colorado consumers than the equivalent United States licensed prescription pharmaceutical products. F, ensure that imported prescription pharmaceutical products are not distributed, dispensed, or sold outside of Colorado. G, ensure that participating pharmacies and other licensed providers charge individual consumers, carriers, and other payers no more than the limit established by the State Department for each imported prescription pharmaceutical product. H, ensure that each payment made by a carrier for reimbursement of the product component of any claim does not exceed the limit established by the State Department for the imported prescription pharmaceutical product for which the payment is made. I, ensure that carriers maintain up-to-date formularies and claims payment systems for their participating health plans consistent with the importation program. J, ensure that participating carriers base their health plan co-insurance and patient cost sharing on prices that are no higher than the limit established by the State Department for each imported prescription pharmaceutical product. K, ensure that participating carriers demonstrate to the State Department how savings on imported prescription pharmaceutical products are reflected in premiums for the carrier's health plans. L, set a maximum profit margin stated in terms of a percentage above the actual acquisition cost that wholesalers, distributors, and pharmacies participating in the importation program may earn. M, exclude generic products if the importation of the products would violate United States patent laws applicable to United States branded products and comply with the requirements of 21 U.S.C. Section 360 EEE to 360 EEE4 pertaining to the track and trace requirements as enacted in Title II of the Federal Drug Quality and Security Act, publications of 11354. O, determine a method for covering the administrative costs of the importation program, which method may include a fee imposed on each prescription pharmaceutical product sold through the program or any other appropriate method as determined by the State Department, but the State Department shall not require a fee in an amount that the State Department determines would significantly reduce consumer savings. And P, determine the most cost-effective providers to include in the importation program. 25.52.5204 draft report public hearings final report repeal. 1, on or before January 1st, 2020, the State Department shall A, prepare and publicly release draft report that fully describes the proposed importation program, and B, post the draft report on its website and submit the draft report to the Joint Budget Committee, the Health and Human Services Committee of the Senate, the Public Health Care and Human Services Committee of the House of Representatives, and the Health and Insurance Committee of the House of Representatives, or any successor committees to not less than 15 days nor more than 45 days after the date the State Department posts the report on the State Department's website. The State Department shall hold at least 2 public hearings to receive comments on the draft report. At least 1 hearing must be held in the Denver metropolitan area. At least 1 hearing must be held in western Colorado. 3, following the public hearings required by subsection 2 of this section, no later than April 15, 2020, the State Department shall prepare and publicly release a final report that fully describes the importation program. The State Department shall post the final reports on its website and submit the final report to the Joint Budget Committee, the Health and Human Services Committee of the Senate, the Public Health Care and Human Services Committee of the House of Representatives, and the Health and Insurance Committee of the House of Representatives, or any successor committees for the section, is repealed effective May 1st, 2020, 25.5, 2.5205. Request for Secretary's approval, effective approval notice to reviser of statutes. 1, on or before May 1st, 2020, the Executive Director shall submit a formal request to the Secretary for review and approval of the importation program. The Executive Director shall provide information requested by the Secretary during the Secretary's review. The Executive Director may modify the importation program design as required by the Secretary so long as the modifications are consistent with this Part 2 to Sections 25.52.5206 to 25.52.5209. Take effect if the Secretary approves the importation program by determining that the importation program complies with 21 U.S.C. Section 384. The Executive Director shall notify the reviser of statutes in writing that the Secretary has approved the importation program by emailing the notice to reviserofstatutes.ga@state.co.us. Section 25.52.5206 to 25.52.5209 take effect on A, the date specified in the Executive Director's notice to the riser statutes that the Secretary has approved the importation program, or B, the date of said notice that the notice does not specify a different date. 25.52.5206 importation program authorized rules. 1, upon approval by the Secretary in accordance with Section 25.52.5205, the State Department shall administer an importation program. 2, the State Department shall approve a method of financing the administrative costs of the importation program, which method may include imposing a fee on each prescription pharmaceutical product sold through the importation program or any other appropriate method determined by the State Department to finance administrative costs. The State Department shall not require a fee in an amount that the State Department determines would significantly reduce consumer savings. 3, the Executive Director shall promulgate rules in accordance with Article 4, Title 24 as necessary for the administration of this Part 2. 25.52.5207 importation program implementation. 1, to implement the importation program, the State Department shall, A, based on the relevant criteria contained in the importation program design, develop and issue a request for proposals from 1 or more pharmaceutical wholesalers licensed by the State Board of Pharmacy in accordance with Part 3 of Article 42.5 of Title 12. The State Department shall select the licensed pharmaceutical wholesalers best suited to import prescription pharmaceutical products under the importation program. In addition to any other terms required by the State Department, a wholesaler shall agree to 1, develop a registration system to enroll distributors, pharmacies, and other licensed providers and carriers in the importation program. 2, establish an outreach and marketing plan to foster public awareness of the importation program. And 3, establish a telephone hotline and create an internet portal to address questions regarding the importation program and to assist pharmacies, other licensed providers, and carriers in registering for the importation program. B, require participating pharmacies or other licensed providers to contract directly with the pharmaceutical wholesalers selected by the State Department. C, require participating Canadian suppliers to contract directly with the pharmaceutical wholesalers selected by the State Department. And D, establish and make publicly available the initial list of imported prescription pharmaceutical products covered by the importation program and the actual acquisition cost for each listed prescription pharmaceutical product. At any time, the State Department may add to or remove from the importation program prescription pharmaceutical products. The State Department shall update the public list of included products at least quarterly. 25.52.5208. Report to the General Assembly. 1, notwithstanding Section 24.1, 136.11A1 on or before January 1st, 2022, and each January 1st thereafter, the Executive Director shall submit a report to the Joint Budget Committee, the Health and Human Services Committee of the Senate, the Public Health Care and Human Services Committee of the House of Representatives, and the Health and Insurance Committees of the House of Representatives, or any successor committees to the report described in subsection 1 of this section must include the following: A, the specific prescription pharmaceutical products imported through the importation program. B, the number of wholesalers, distributors, pharmacies, and other licensed providers and carriers that are participating in the importation program. C, the number of imported prescription pharmaceutical products dispensed and sold through the importation program. D, the estimated savings to consumers, carriers, and employers resulting from the importation program. E, the information collected pursuant to Section 25.52.5209, and F, any other information the State Department deems relevant. 25.52.5209, monitoring anti-competitive behavior. The State Department shall, in consultation with the Attorney General, define the potential for anti-competitive behavior in the pharmaceutical industry and other healthcare industries that are affected by the importation program. The State Department shall include information concerning potential anti-competitive behavior in the report required by Section 25.52.5208, Section 3 in Colorado Revised Statutes, Amendment 25.52.5 101 as follows. 25.52.5101 short title. The short title of this strike article shall be known and may be cited as unstrike. Part 1 is the Colorado Cares RX Act, Section 4 in Colorado Revised Statutes 25.52.5103, amend 3 as follows. 25.52.5103. Lower cost prescription drugs information research reporting. 3, the State Department shall report annually to the Public Health Care and Human Services.
Senator Hill.
Chair, I appreciate Mr. Carpenter being willing to read so much. I think I've got a full understanding of the bill at this point and ask that we end reading of the bill at length.
Thank you, Senator Hill. The question is the passage of Senate Bill 5. All those in favor say aye. Opposed, no. Senate Bill 5 is adopted. Mr. Carpenter, please read the title of House Bill 1135.
House Bill 1135 by Representative Gray and Senators Todd and Winder concerning a clarification that the income tax credit for retrofitting a residence to increase a resident's accessibility is available for changes made to a residence that benefit a qualified individual's dependent.
Senator Tate.
Thank you, Mr. Chair. I move House Bill 1135.
Is there further discussion? Seeing none, the question before us is the passage of House Bill 1135. All those in favor say aye. Opposed, no. House Bill 1135 is adopted. Mr. Carpenter, please read the title of House Bill 1170.
House Bill 1170 by Representatives Jackson and Weissman, Senators Williams and Bridges concerning increasing tenant protections relating to the residential warranty of habitability.
Senator Williams.
Thank you, Mr. Chair. I move House Bill 1170 and the Local Government Committee report.
To the Local Government Committee report. Senator Williams.
Thank you, Mr. Chair. Members, the Local Government Committee report, we read an amendment on the notification of electronic communications. They must use a email or phone number and electric portal to specified in the rental agreement. The tenant cannot deduct costs from payments inspected by periodically housing that meets federal requirements for low-income housing, and the written rental agreement must include a statement of the name and the address of the landlord and the landlord's agent if that agent changes. Ask you for an aye vote on the Local Government Committee report.
Is there further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye. Aye. Opposed, no. Committee report is adopted. To the bill. Senator Williams.
Thank you, Mr. Chair. Members, the warranty of habitability is a bill that will make sure that those who live in habitable conditions in rental units, we want to make sure that health, safety, and consumer concern is addressed with the housing market booming and considering the fact that every 4 renters in Colorado spends more than 50% of their income on housing. Want to make sure that they have a safe place to live and that if there are repairs that need to be done to ensure that the apartment and or resident is safe, that this will expand the current habitability statute. I would ask you for an aye vote.
There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L024?
Amendment L024 to House Bill 1170 by Senator Williams, amend re-engross bill page 5, strike lines 22 and 23, and substitute.
Senator Bridges.
Thank you, Mr. Chair. L024 is about the time frame for getting
Senator Bridges,
bids.
please move Amendment L024.
Thank you, Mr. Chair. I move L024.
To the amendment, Senator Bridges.
Thank you, Mr. Chair. The amendment changes the amount of time required to begin getting a bid to repair problems with the residents. It increases it from 2 days to 4 days.
Is there discussion on Amendment L024? Seeing none, the question before us is the adoption of Amendment L024. All those in favor say aye. Opposed, no. Amendment L024 is adopted. There is an amendment on the desk. Mr. Carpenter, please read Amendment L027.
Amendment L027, House Bill 11.
Senator Williams.
Thank you, Mr. Chair. I move L027.
To the amendment, Senator Williams.
Thank you, Mr. Chair. Members, L027 adds some language under which the circumstances that the landlord commits a breach of warranty when mold is associated with dampness, that has to mitigate within 24 hours, maintain the containment until the health risk is removed, and with a reasonable amount of time. I ask you for an aye vote on L027.
Is there further discussion on Amendment L027? Seeing none, the question before us is the passage of the amendment. All those in favor say aye.
Aye.
Opposed, no. Amendment L027 is adopted. There is an amendment on the desk. Mr. Carpenter, will you please read the title to Amendment Or will you please read Amendment L028?
Amendment L028, House Bill 1170 by Senator Williams.
Senator Bridges.
Thank you, Mr. Chair. I move L028.
To the amendment, Senator Bridges.
Thank you. This adds a definition for mold and adds an inconsistency that we had in the bill. We like to fix things.
Is there further discussion on Amendment L028? Seeing none, the question before us is the adoption of the amendment. All those in favor say aye.
Aye.
Opposed, no. The amendment is adopted. There is an amendment on the desk. Mr. Carpenter, will you please read Amendment L029?
Amendment L029, House Bill 1170 by
Senator Williams.
Thank you, Mr. Chair. I move L029.
To the amendment, Senator Williams.
Thank you, Mr. Chair. Members, this basically says that a tenant can provide the landlord with electronic notice as well as a written notice if domestic violence occurs. I ask you for an aye vote.
Is there further discussion on L029? Seeing none, the question before us is the passage of Amendment L029. All those in favor say aye. Opposed, no. Amendment L029 is adopted. To the bill, Senator Bridges.
Thank you, Mr. Chair. I just want to say there was great stakeholder work on this, and we appreciate the support. Ask for an aye vote.
Is there further discussion on House Bill 1170? Senator Tate.
Thank you, Mr. Chair. And I wonder if the good senator from Greenville Village who said there was great stakeholder work, does that mean like the apartment association and other stakeholders are in support of the bill? I just wasn't part of the discussion.
Senator Bridges.
Thank you, Mr. Chair. The Apartment Association is not in support of the bill. They do officially oppose the bill, but on a scale of like 1 to 10, they are certainly not a 10 on this. I think there are other bills that they oppose much more vehemently than this one.
Senator Tate.
So to use Princess Bride, they're just mostly opposed, not all opposed.
Is there further discussion on House Bill 1170? Seeing none, the question before us is the passage of House Bill 1170. All those in favor say aye. Opposed, no. House Bill 1170 is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
You've heard the motion. The motion is to rise and report. All those in favor say aye. Opposed, no. The committee will rise and report.
Senate will come back to order. Senator Moreno.
Thank you, Mr. President. Your committee has met and had a number of bills under consideration. Mr. Carpenter, will you please read the report?
Mr. President, your committee will place the reports out on consideration following tax bills being saved. There makes following recommendation on Senate Bill 5 as amended passed second read order grace place counter for the reading and final passage. House Bill 1177 as amended. House Bill 1135, House Bill 1170 as amended passed second read order revised place counter for the reading and final passage.
Senator Moreno.
Thank you, Mr. President. I move for the adoption of the report.
The motion is for the adoption of the committee of the whole report. There is an amendment at the desk. Will the clerk please read the amendment 001 to the committee of the whole report?
Committee of the whole amendment 001, House Bill 11.
Senator Sonnenberg.
Thank you, Mr. President. I move Committee of the Whole Amendment 1, the Sonnenberg Amendment. Members, I know it's been a while and it's a long day. I'll briefly remind you what this amendment was. This had to do with turning a gun confiscation bill into a mental health bill to deal with the issues with violence. Members, simply ask for your yes vote that this bill or this amendment did pass and that did fit under the title, and we turn this red flag bill into a bill to help people rather than take their guns. Ask for an aye vote.
Is there further discussion? Senator Court.
Thank you, Mr. President. The chair ruled that this did not fit under the title, so this is a done deal.
Senator Lundin.
Thank you, Mr. President. This amendment, which we talked about extensively, honors significantly the intention, the desire, the plan, the best hopes of the bill. It does it in a way that is elegant and at the same time challenging, obviously, for the bill sponsors. But it does it in a way that I think is so important, and that is it acknowledges this is all about someone who is in mental health crisis, somebody who's having a mental health break. And it does it by saying we're going to stay focused on that element. We're going to stay focused on providing the support to that individual, engaging with that individual, as opposed to turning and making it about confiscation of a subset of private property and leaving in place other private property that could be just as threatening, just as damaging. I urge your serious consideration and support of this amendment.
Is there further discussion on the committee of the whole amendment 001? Seeing none, the motion before the body is the adoption of the committee of the whole amendment 001. Are there any no votes? Senators Foote, Fields, Court, Williams, Winter, Fields, Gonzalez, Donovan, Lee, Moreno, Rodriguez, Danielson, Janal, Bridges, Story, the Majority Leader, Todd, Zenzinger, Patterson. Please add the President. With a vote of 16 ayes, 19 no votes, 0 absent, and 0 excused, Amendment 001 is lost. Mr. Carpenter, please read Amendment 002.
Committee of the Whole Amendment 002, House Bill 1177, Senator Tate moved to amend the report of the Committee of the Whole, show the following date for Amendment L0077 to House Bill 1177 did pass amendment State Veterans Military Affairs Committee report dated March 15, 2019, page 1, strike line 19.
Senator Tate.
Thank you, Mr. President. I move Amendment 2, the Tate Amendment to the COW.
To the amendment, Senator.
Thank you, Mr. President. Members, channel your thoughts back to hours ago this morning. This is related to something that was important to me. It was about the recourse for a respondent who suffered a false complaint, and specifically when that's malicious. The good senator from Lafayette did happen to mention some other avenues of recourse, but what's not currently provided, that this section of language of the bill that was in the bill when it came over from the House was related to civil remedies, damages, and legal fees. And I can say, as a country businessman, I don't like paying legal fees. They're always very expensive, and certainly as a personal, as a citizen, with regard to protecting my rights, I certainly wouldn't want to incur those costs suffering from a false petitioner's complaint. Anyways, thank you, members, for the consideration of the amendment, on this amendment that's important to me. Thank you.
The Senate will stand in a brief recess. Senate will come back to order. Mr. Majority Leader.
Thank you, Mr. President. I move a call of the Senate.
You have heard the motion. A call of the Senate has been called. Sergeants, will you please close the doors and retrieve the senators? Ms. Carpenter, please take the roll.
Senators.
Mr. Carpenter, stand by, please. The motion is that the call of the Senate, please proceed, and the Senate will have a call of the Senate. Ms. Carpenter, please do the roll call.
Senators Bridges, Cook, Quorum, Court, Crowder, Danielson, Donovan, Finberg, Fields, Foote, Gardner, Janal, Gonzalez, Hill, Heisey, Holbert, Lee, Lundeen, Marble, Moreno, Pedersen, Priola, Rankin, Rodriguez, Scott, Smallwood, Sonnenberg, Story, Tate, Todd, Williams, Winter, Woodward, Zenzinger. Mr. President.
Sergeants, please retrieve the senators who are absent